5, 4, 3. Good morning. Ladies and gentlemen, welcome to the Public Service Commission of South Carolina's hearing in Dominion Energy of South Carolina's rate case, application for adjustment of rates. It's docket number 2020-125E. Before we get started, we're going to do a quick roll call. Vice Chair Belzer, Commissioner Caston, and Chairman Williams are present in the hearing room. Commissioners Thomas, Irvin, Powers, and Williams are joining us virtually. Please pause with me for a moment of silence. Thank you. Before the applicant calls its next witness, do we have any preliminary matters to discuss? I think someone is trying to speak, but you're a little vague there on the microphone.
Yeah, it does help if I cut mute off, Mr. Chair. Thank you very much. Mitch Willoughby on behalf of Dominion Energy South Carolina, Mr. Chairman. I wanted to inform the chair and the parties that Mr. Long unfortunately had a family emergency last evening, and he will not be available to testify today due to that family emergency. But he was one of the individuals, Mr. Chairman, that the parties had agreed, I think all parties had agreed, that Mr. Long's testimony could be stipulated into the record. If that is, if I'm accurate, then we would at the appropriate time, we would stipulate Mr. Long's testimony into the record as if given orally from the stand, and we would submit a verification at a later time, at probably sometime next week before we'd be able to get that verification. So I needed to alert the chair of that issue, and I see Mr. Bateman is on the line with us, so I don't know that he will have any objection, but I'll let him speak for himself.
No, Mr. Willoughby, this is Andrew Bateman with ORS. No objection, and I certainly hope that whatever issue has arisen resolves itself well enough. Mr. Chairman, excuse me, I would ask whether the Commission has made a determination about the possibility of carrying the proceedings over into the weekend.
Tomorrow?
Yes, sir.
No, we're not going through tomorrow. Not this weekend.
Okay. Thank you, Mr. Chairman. ORS has no additional preliminary matters at this moment.
Mr. Chairman, this is Mitch Willoughby again. We do have some preliminary matters. We had proposed yesterday, in addition to the 3 witnesses, Mr. Long, and 2 of ORS's witnesses, of course, that probably won't get to next week, that we would stipulate their testimony into the record. I think as far as Mr. Long is concerned, Mr. Chairman, I believe the Commission was going to let the parties know whether or not they would permit the witness to not appear at all, which of course would mean that the Commission itself would not be able to ask questions of the witness. So I would make that request that the Commission let us know about Mr. Long at an appropriate time, if he could be totally excused, along with the 2 ORS witnesses when their turn comes up. I would also inform the chair that we had proposed to do the same for witnesses Elbert, which is a Dominion Energy South Carolina witness, and also for the other parties, witnesses Woolridge, Rothschild, and Zoo. And so I would ask if there is agreement on being able to stipulate the testimony of those 3 witnesses or those 4 witnesses into the record without having them appear to present their testimony.
All right, let's talk about Ms.
Certainly.
Elbert. Ms. Elbert, the parties, how do you feel about stipulating to Ms. Elbert's testimony?
Mr. Chairman, this is Andrew Bateman with ORS. I emailed Mr. Willoughby last night. I do not believe that ORS is in a position to agree to the stipulation of Ms. Elbert's testimony, and it also believes that that it would prefer that the testimonies of the cost of capital witnesses, that those witnesses be allowed to testify before this commission.
Okay, I'm just focused on Ms. Elbert at this moment.
Yes, sir.
Anyone else for Ms. Elbert?
Mr. Chairman, Roger Hall with the department. We do not have any planned questions for Ms. Elbert, so we would not object, depending on whether the commission would like to ask any questions for her.
Okay. Anyone else for Ms. Elbert? Okay, so Attorney Bateman, ORS objects to stipulating to Ms. Elbert's testimony?
Yes, Mr. Chairman. We have brief cross, but we do have cross planned for Ms. Elbert.
Okay. Everyone is in agreement with stipulating to Mr. Long's, Mr. Sandonato's, and Mr. Brazino's testimonies, right?
I believe so, Mr. Chairman.
Okay. So we'll stipulate to those and move forward with the rest of the witnesses as they are called.
Thank you, Mr. Chairman.
Mr. Chairman, one additional. I understand that there is a discussion occurring at this time about this is Sierra Club's witness, Stanton, and the company's witness, Neely, and that the Sierra Club is willing to stipulate the testimony of Mr. Neely into the record, as we've done now with Mr. Long and Sandonato and Brazino. So we would ask if the parties are willing to stipulate to Mr. Neely and of course then Sierra Club witness Stanton.
Let's take those matters up. Let's take those matters up after lunch.
Thank you.
Yeah, let's take those matters up after the lunch break. I'm ready to go ahead and get started.
Well, Mr. Chairman, I would say that Mr. Neely is one of our witnesses, and depending upon how quickly we move this morning, that issue may come up sooner than lunch. I'm not sure of that, but I just would bring that to the Commission's attention. And one final point I would make, Mr. Chairman, is with the witnesses of Woolridge, Rothschild, and Zoo, I would certainly trust that the parties are not looking to try to do friendly cross to elongate the hearing. We believe that would be redundant. We believe it would be unfair. We've proposed a way to streamline the process, to streamline this hearing as the chair has requested, and the witnesses are only permitted to summarize their testimony and respond to questions from the parties and from the commission, and if we're willing to, the company's willing to waive its cross-examination, then it would really only depend upon whether or not the commission itself wishes to ask questions of those particular witnesses. So I make that point. I don't know that the chair has to rule at this moment, but certainly we would ask that the chair make sure that the parties do not use the cross-examination of those witnesses as a means of further trying to put additional testimony in beyond the testimony that's already been developed and pre-filed with the witnesses, and we think it would be inappropriate to do so.
All right, please call your next witness.
Thank you, Mr. Chairman. Belton Ziegler, representing Dominion Energy, South Carolina. We would call to the stand Regina Elbert.
Hello, can you hear me?
Ms. Elbert, would you
Can you hear me?
Yes, ma'am. Can you hear us?
Yes.
Would you raise your right hand, please? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you so much.
Please state your name for the record,
Regina Elbert,
and by whom are you employed and in what capacity?
Dominion Energy Services, Inc., as the Vice President of Human Resources Business Services.
Have you prepared or caused to be prepared under your direction 27 pages of direct testimony that was pre-filed with the Commission in this proceeding?
Yes, I have.
Do you have any changes or additions to that testimony?
No, I don't.
If I were to ask you all the questions contained in the pre-filed testimony today, would your answers from the witness stand be the same?
Yes, they would.
Mr. Chairman, at this time I'd move the pre-filed direct testimony of Ms. Elbert be entered into the record of this proceeding as if given orally from the stand.
Yes, sir. The pre-filed direct testimony of Ms. Elbert will be entered into the record as if given orally from the stand, And Ms. Elbert? Ms. Elbert,
Yes.
could you do me a huge favor and either speak closer into your microphone on your computer or hold your phone to your mouth?
Okay, let me try to adjust the speakerphone here. Is this any better?
That's a little better.
I could pick up the receiver.
Perfect.
Okay.
All right. Ms. Elbert, you had one exhibit labeled RJE1 attached to your direct testimony. Is that correct?
Yes.
Do you have any changes to that exhibit?
No.
Mr. Chairman, I'd move into the record exhibit RJE1 attached to Ms. Elbert's pre-filed direct testimony at this time.
Could you identify that exhibit again, Attorney Ziegler?
It's labeled RJE-1, and it was attached to the direct pre-filed testimony of Ms. Elbert.
All right. Ms. Elbert's exhibit will be entered into the record as, will be marked and entered into the record as hearing exhibit 28. RJE1, I believe it is.
Thank you, Mr. Chairman. Ms. Elbert, have you prepared a summary of your direct testimony?
I'm sorry, Attorney Ziegler. I barely can hear you, which means we barely can hear you in the hearing room.
That's not good. Hold on a second. Apparently, let me see if I can. I will need to move my speakerphone closer. Apparently, it's gotten pushed away over the evening. Mr. Chairman, is this better?
It's a little bit better, but if you could just hold the handset, that would eliminate all problems.
We'll do it the old-fashioned way. How about this?
And just turn your volume up a little bit, and I think we'll be good to go.
Okay, my volume's on maximum. Is this good?
It almost sounds as if you're still on speakerphone.
Does not show that I am. I just turned on speaker. And this is handset.
Okay.
I noticed some crackling in the line. I don't know what the issue is.
Usually your voice comes through very strongly, but
Right.
it's faint today.
This is the same line that we've been using. Let me do this. They did plug a second phone in here. Let me unplug that. Well, I hate to start.
Let me make sure we don't have any issues on our end. I've been reassured we have no issues on our end.
Short of dialing back in, I'm not sure what I could do. I could hang up and redial in if that would be helpful.
I really don't want you to do that, but that's what they're advising me to tell you. Before you do that, Commissioner Caston, Vice Chair Belzer, are you struggling to hear? You make do?
Well, I hate to.
Okay. Well, we're just going to practice silence here and just really focus in on your voice so we can get through it.
I'm sorry. All right, well, the first break I will redial in, but we won't try that now. The good news is I don't have much more to say for a while. So, Ms. Elbert, have you prepared a summary of your direct testimony in these proceedings?
I don't know what happened, Mr. Attorney Ziegler, but you solved the problem.
Oh, my goodness. Well, I will keep handling the system just like this. Would you please present this summary to the Commission at this time?
Yes. Good morning, Chairman Williams and members of the Commission. As Vice President of Human Resources Business Services for Dominion Energy Services, Inc., I oversee human resources for the company. The company's ability to provide its electric customers with safe, reliable, and economical electric service is dependent on the company's ability to attract, hire, motivate, and retain employees who have the skills and commitment required to achieve those priorities. This requires a total compensation plan that is competitive when measured against market benchmarks. For that reason, the company evaluates compensation on a job-by-job basis against the market and internally across the company to ensure equity. Customers have a direct stake in the competitiveness of our compensation structure. When employees leave prematurely due to plans that are not competitive, the company incurs additional costs to recruit replacements. Additionally, customers lose the value of the utility's investment in recruiting, training, and developing the knowledge base of the employees who have left. If we cannot attract the sorts of skilled and committed workers we seek, our efficiency and customer service will suffer. Incentive plans and programs are an integral part of the company's total compensation package. In addition, our incentive programs give employees a direct stake in achieving the company's goals and are an especially effective way of motivating employees to recognize and embrace these goals. The financial components of these plans benefit customers by encouraging employees to work efficiently and to keep costs low. Prior to the merger with Dominion Energy, Inc., employees historically participated in one of 3 annual incentive plans. The 357 plan gave employees the opportunity to earn incentive pay equal to 3%, 5%, or 7% of their eligible earnings based on the tier they were assigned. It was generally available within the company. The top 15% of performers in the 357 plan could also earn an additional 3%, 4%, or 5% subject to management discretion. The short-term annual incentive plan, or STIP, was generally available for employees at the director level or above. Employees were given targeted awards based on factors such as base pay, their specific role, internal equity, and individual performance. The mid-tier plan was a variant of the STIP, available primarily to VC Summer Nuclear employees. The mid-tier plan had the same structure as the STIP, but was more widely available to employees in specific technical positions. Effective nuclear operations required the company to be able to attract and retain personnel in these technical positions. During the test period, we preserved the pre-merger target award percentages and applied them as they existed at the time of the merger to legacy employees. In addition, for 2019, we also preserved the ability of the top 15% of performers in the former 357 plan tiers to earn an additional 3%, 4%, or 5% based on their target tier. This kept with our merger commitments. However, we made other aspects of the annual incentive compensation comply with the structure of the Dominion Energy, Inc.'s company-wide annual incentive plan, including the funding provisions and goals. The annual incentive plan rewards employees for meeting specific goals related to safety, diversity and inclusion, environmental training and tracking, operations and stewardship, and business unit and consolidated financial objectives. Points are awarded based on completing or partially completing each goal. Non-financial goals predominate for DESC employees. The amount of potential payout under the annual incentive plan is set by management at the beginning of each year. The final payout is determined by an independent committee of Dominion Energy, Inc.'s board based on financial performance against pre-established goals and forecasts. In addition to the annual incentive plan, the company offers a long-term incentive plan. For eligible non-executives, Dominion Energy, Inc.'s 2019 long-term incentive program consisted of restricted stock grants, which were awarded in 2019 and will vest after 3 years. Incentive goals tied to financial performance are important because they communicate to all employees that they have a direct stake in achieving the company's goal of economical service to customers and preserving its access to capital markets on favorable terms. Financial goals are part of how we ensure that managing costs and financial expectations are part of the balance of priorities that incentives communicate. Ultimately, if Dominion Energy, Inc. and its business units are able to manage their businesses in a way that allows them to meet financial targets and expectations year by year, a culture of cost control will be created, and pressure to increase rates will be reduced. Dominion Energy, Inc.'s top priorities include attracting and retaining a diverse workforce and creating an inclusive culture where all employees can thrive. DESC now has 8 new employee resource groups to support its employees, including groups for Latinos, disabled employees, veterans, and others. Hiring procedures require diverse applicant pools and at least one diverse member on each interview panel. Additionally, as previously mentioned, the annual incentive program contains a company-wide diversity and inclusion training goal. This concludes the summary of my direct testimony.
Thank you, Ms. Elbert. Have you also prepared or caused to be prepared under your direction 11 pages of rebuttal testimony that was pre-filed with the Commission in this proceeding?
Yes.
Do you have any changes or additions to that rebuttal testimony?
No, I don't.
If I were to ask you all the questions contained in the pre-filed rebuttal testimony, would your answers today from the stand be the same?
Yes, they would.
Mr. Chairman, at this time I would move the pre-filed rebuttal testimony of Ms. Elbert to be entered into the record of this proceeding as if given orally from the stand.
The pre-filed rebuttal testimony of Ms. Elbert will be entered into the record as if given orally from the stand.
Ms. Elbert, have you prepared a summary of your rebuttal testimony?
Yes, I have.
Would you please provide that to the Commission and the parties present here today?
Yes. The primary purpose of my rebuttal testimony is to respond to allegations in the testimony of other parties challenging the value to customers of recognizing financial performance in the company's incentive and compensation programs. First, the consumer advocate's witness, Mr. Hempling, asserts that including financial goals in the annual incentive plan rewards actions that are adverse to customers. This is exactly backwards. Financial goals are set for the company at the beginning of each year through the budgeting process. When these goals are met, costs are controlled, and upward pressure on rates is reduced. This process results in a culture of economic efficiency, which directly benefits customers. The incentive plans align customers' and employees' interests. A cost-effective utility is able to meet budgets and reduce pressure on rates. The financial targets reflected in the annual incentive plan reflect the earnings that will be produced if the operating units of the company are able to live within its capital and O&M budgets. The company leadership sets those budgets each year to reflect the investment that is required for each of its operation units to achieve its customer service and utility operations goals in a financially responsible way. The financial goals associated with the annual incentive plan are neither arbitrary nor random. They reflect the budgetary goals that provide for stewardship or operational goals to be accomplished in a fiscally responsible manner. Similarly, tying certain aspects of executive compensation to stock price and market share ensures that these leaders are not complacent in the face of industry changes. The company's strategic direction in light of changing economic conditions is constantly being evaluated by the financial markets and reflected in stock prices. This is as objective an evaluation of leadership effectiveness as exists. In addition, incentive compensation is an ongoing, normal, and expected expense of utility operations that is reflected in test period expenses and is anticipated to be paid out in future years. Under cost of service regulation in South Carolina, rates are set to reflect normal and expected levels of expense measured through a historical test period. Incentive compensation clearly meets that test. Finally, proposals to remove 50% of the amounts related to base salary and benefits for the 4 highest compensated executives are not justified. These employees are an integral part of the leadership team who ensure that safe, reliable, and economical electric service is provided to customers across Dominion Energy Inc.'s businesses. There is no basis to exclude the valid labor costs associated with these employees from the revenue requirements of the utility. This concludes the summary of my rebuttal testimony.
Mr. Chairman, Ms. Elbert is available for cross-examination and questions by the commissioners.
Thank you, sir. AARP?
Good morning, Your Honor. The joys of being first in the alphabet. We have no questions of Ms. Albert. Thank you.
Thank you, sir. Walmart Incorporated.
Good morning. This is Stephanie Eaton for Walmart. We have no questions for Ms. Albert.
Let me ask this question. Do any interveners other than ORS have questions? All right, ORS, it looks like you are the only party with cross-examination. Please proceed.
Thank you, Mr. Chairman. Good morning, Ms. Elbert. My name is Alex Knowles. I'm an attorney with the South Carolina Office of Regulatory Staff. How are you doing today?
I'm well. Good morning.
Good morning. And can you hear me okay?
I can.
Okay. Ms. Elbert, you testify regarding the company's annual incentive program and its long-term incentive program. Is that correct?
Yes.
And you testify that these programs benefit customers. Do you agree that these programs benefit shareholders too?
Yes, I think that programs can benefit both customers and shareholders. And these are examples of programs that do that.
And for the annual program, a part of the company's annual incentive plan is tied to consolidated financial goals. Is that right?
That is right.
And consolidated financial goals in this context refers to an earnings per share goal for Dominion Energy stock. Is that correct?
It's operating earnings per share, but yes.
Okay. And operating earnings per share is basically a measure of company profitability on a per share basis. Is that roughly correct?
Yes.
And under Dominion Energy's annual incentive plan, there are various employee tiers, and at the top tier, there's the CEO, right?
That's right.
And 85% of short-term bonus pay for the CEO is tied to Dominion Energy meeting its consolidated financial goals. Is that correct?
Yes, and we're talking about the 2019 plan design that's in rates, right? Just
yes,
so
ma'am.
I'm clear what we're talking about.
Yep.
That's right.
And then, again, under the 2019 plan for the next most senior tier of Dominion leadership, the second most senior tier in the plan, 40% of their short-term bonus pay is tied to Dominion Energy meeting its consolidated financial goals. Is that right?
That's right.
I guess just for context, this second tier includes people like Mr. Blevins as the president of DESC and then executive officers of Dominion Energy itself, right?
It does include Mr. Blevins. I'm not sure what you mean exactly by executive officers. It includes executive vice presidents, and that's a specific title that we have at Dominion Energy, Inc. It's a small number of people. It's probably less than 10 people. I would have to go back and look at the org chart to count, but it's a small number.
Yeah, and thank you for clarifying. Ms. Elbert, the outcome of this rate case will affect short-term executive compensation, right?
I don't think I quite understand the question. It will affect.
I guess we had been talking about 2019. For this year, for 2021, the outcome of this rate case will have an effect on short-term executive compensation. Is that correct?
You mean an effect on how it is designed, or an effect on what exactly?
The actual amount that could be paid out.
I guess that's hard to say, but as we've discussed, there are financial goals in the plan, and so to the extent that the outcome of the rate case has the financial impact, as do many other things that would affect payouts under incentive compensation.
Okay, and it would be reasonable to expect the outcome of the rate case to have an effect on the relevant financial metrics?
Well, I don't want to speculate about how exactly that would happen, but it's one of many inputs into what the ultimate earnings per share are for Dominion Energy Inc.
Okay, so it is an input.
Yes,
sure.
Along with
not to
many
belabor it, but yes, ma'am. Thank you. And the same would go for the long-term executive compensation. That the outcome of this rate case would end up factoring into the metrics that are relevant for determining at-risk performance-based executive compensation.
That's right. And any factors that affect our business ultimately, have the potential to affect financial metrics as well as other things. So yeah.
And on the topic of the long-term incentive program, as it applies to executives, under the 2019 plan, the amount of that bonus payout is tied 50% to Dominion Energy's success in meeting certain financial metrics. Is that right?
I'm sorry, for which group of people did you reference?
For long-term executive performance-based compensation.
And the question is 50% tied to financial metrics?
Yes, ma'am.
I think you're talking about the performance grant that's given as part of the long-term incentive program. Is that what we're talking about?
Yes, ma'am.
Okay.
So.
Yes, those are financial metrics that are part of that grant. Yes.
Okay, and those metrics, I guess, for this program are different from the short-term program. They include absolute and relative total shareholder return on invested capital, and then the price-to-earnings ratio. Does that sound right?
That's right.
And in general, each of these metrics that we just referenced offer a different way to assess the company's profitability. Is that right?
I wouldn't say that they all assess profitability, but they're all financial metrics that assess the company's overall health.
Okay. Okay. Can I ask, does Ms. Elbert, tying executive compensation to profit incentivizes executives to increase revenues, right?
Increasing revenue is one way to increase profit. There are other ways as well. I think it actually would be poor corporate governance not to tie executive compensation to financial outcomes. I don't think that there are any. I can't think of any publicly traded companies that don't do that, whether they're in our industry or otherwise.
I understand your position. Thank you. With respect to Desk's revenues overwhelmingly come from its retail customers, right?
I will accept that. I'm not in the accounting or finance group, so I don't want to get into specifics, but I will absolutely accept what you said.
Ms. Elbert, do you think that it might be hard for some of Desk's customers, in particular those folks that have faced and continue to face unrelenting adversity, over the past year, to understand why they're paying for bonuses that are tied to how profitable Dominion Energy has been?
Yeah, I can absolutely understand why people that are struggling would potentially make that connection. I can understand why that connection would be made. I'll have to say that, from the employee's point of view, it's part of their compensation package. An incentive compensation is one aspect of their compensation, just like their health benefits or their retirement plan or their salary. And so from the employee's point of view, if you're taking out one leg of the compensation package, you'd have to make it up in some other way, like increasing base salary, for example. And then if you take out incentive compensation, you also lose the ability for the company to focus employees on the goals that are important to, serving customers and therefore having a healthy company. So I can understand why people would sort of have that reaction. But, from my perspective in HR, it's part of treating our employees fairly for the work that they're doing.
I understand your position. Yes, ma'am. Thank you. And Ms. Elbert, you understand that ORS allowed bonuses that are tied directly to individual employee performance to provide outstanding service to South Carolina customers, right?
Can you say that one more time?
Yes, ma'am. In this case, you understand that ORS has allowed bonuses that are tied directly to individual employee performance to provide outstanding service to South Carolina customers, right?
If you're talking about in the past, yes, I think that's right. We've been talking sort of about how financial goals fit into that, and this is my view that I'm expressing, of course, but it seems to me that the customers have an interest in our workforce knowing that you have to achieve all of your goals within a certain financial paradigm. And that's how we use that, is to help our employees balance all that they have to do to get to the right outcome in an efficient way. So to me, it's just part of the cost of providing our service.
Thank you very much for your time this morning, Ms. Elbert.
Thank you.
No more questions, Mr. Chairman.
Commissioner questions? Commissioner questions?
Chairman Williams.
Mr. Chairman.
Oh, go ahead.
Commissioner Powers?
Thank you, Mr. Chairman. Ms. Elbert, can you hear me okay?
I can hear you.
Okay. We've had many hours of public hearings, and we've heard from hundreds of ratepayers, and everyone that spoke to us was, in fact, a ratepayer with Dominion Energy. Did you listen to any of those hours of testimony?
I did.
Did you listen last night?
I heard much of last night, and I heard all of the hearings during the day from earlier in the week.
Okay. We've been told by several ratepayers that the president of Dominion Energy of South Carolina makes a salary of $14 million. Is that correct?
That the president of Dominion Energy South Carolina makes $14 million as a salary?
Yes.
Is that the question?
The head of Dominion?
I'm sorry, I didn't hear.
That is something that ratepayers have told us over and over and over, that there's salaries in the area of 14 to 16 million. Is that correct or incorrect?
No, I think that's incorrect. I think if we were talking about Mr. Blevins, that's not correct. Although I don't have his salary in front of me, I could tell you that's not it. I don't know if they're maybe looking at the proxy. Could I give you a range? Is that what, I don't have it off the top of my head, and I wouldn't want to speculate. Although I could provide it, and it may have already been provided in discovery, but we could certainly provide it.
Do you understand during a pandemic that this is a great concern, or certainly affects rate holders very strongly?
Absolutely.
Okay.
I do.
I mean, I'm a big New York Yankee fan, but I really didn't like it when they paid all this money to Alex Rodriguez when there was a lot of other talent available. And the compensation on top of that, when we talk about bonuses and stock options, regardless of his salaries, are the top 4 executives that ORS has expressed concern. What type of bonuses are we talking about?
The top 4 executives, I believe that they're talking about would not, for example, include Mr. Blevins. They're talking about folks at the Dominion Energy level for whom a portion of their pay is allocated to Dominion Energy South Carolina. Is that what we're speaking about?
Yes. Well, in your rebuttal testimony, you disagreed with ORS's removal of 50% of the 4 highest compensated executives. How were these compensation packages structured for these executives?
So it is as I described earlier, in that they have a base salary and they have an annual incentive target, just like all other employees. And then as executives, they have the long-term incentive program, which consists of a grant of restricted stock and then a grant of a performance grant that is based on the payment of which is based on certain metrics. The long-term incentive program is a very standard way to compensate executives of publicly traded companies, and it's a way to align their interest with the company's long-term interest, which in our case is customers ultimately their interest.
Can you give a percentage of their overall compensation that is tied to earnings, financial performance, or as a fiduciary duty to your shareholders as well as the ratepayers? What is that percentage?
I don't have that percentage for those 4 individuals in front of me.
Could you provide that?
I could look at that. Sorry, I'm just going to take a note here while we're talking.
Is there a percentage of overall compensation that's tied to Mr. Blevins' earnings?
So he has the same basic structure of a salary that is fixed, and then an annual incentive target, and then the long-term incentive program. He has the same structure.
Okay. And do you realize during a pandemic just how this is incomprehensible to the average ratepayer?
Yeah, I definitely heard the struggles expressed by the ratepayers that called in, and the great concern over any kind of increase. I did hear that.
And a delay in an increase, would that affect these executives to any great degree?
I don't know. I don't know what. I just personally do not know what the outcome would be of a delayed increase and how that might affect the payout options.
Okay. Thank you, ma'am. That's all I have.
Commissioner Caston.
Thank you. And good morning, Ms. Elbert.
Good morning.
Lines 18 through 20 of ORS Witness Cleckley, which I know there's been discussion about this, but it says Dominion's executive level positions have incentive goals heavily weighted towards financial performance goals in contrast to operating and stewardship goals. And I know there's been a lot of discussion on this, but do you agree with that statement?
Yes, the very top executives, their goals, I think we're talking specifically about the annual incentive plan, that their goals are weighted more towards the financial for the folks at the very top.
In contrast to operating and stewardship goals, was his testimony.
Yes. And I'm sorry, if you'll give me just 1 minute to get that in front of me.
Yes, ma'am.
I can look at what you're referencing. Thank you.
Page 8 of 15, lines 18 through 20.
Yes. Okay. I've got that now. Thank you.
You concur with that statement, or that written testimony?
I'm sorry, I'm having a hard time hearing. Was there another question that was asked?
No, ma'am, I'm saying, and you concur with that statement and his written testimony, Mr. Cleckley's testimony?
So it says Dominion's executive level positions have incentive goals heavily weighted toward financial performance goals in contrast to operating and stewardship goals.
Yes, ma'am.
When I look at that, I guess I would qualify it in the following sense that if we're looking at the 2019 plan, for example, the vice presidents and senior vice presidents who are executives, their goals are weighted 50-50 equally between financial and non-financial measures, and it's only the CEO and the executive vice presidents or business unit presidents that had ratios higher than 50-50. So again, it's that small group of, I would say, less than 10 people that that are more weighted towards financials than operating and stewardship. So just with that clarification.
Do you believe there's a dichotomy between customers' best interest and shareholders' best interest?
I think that there should be alignment between the two. Our shareholders tend to be folks that want to hold for the long term. We are a company that looks towards the long term, and ultimately, when our shareholders invest in the company, they are investing in our service territory. They're investing in South Carolina and the health of the area. So I think that it's sort of misleading to say that those two things are always going to be in conflict, because ultimately we both benefit from more of a symbiosis. It is a balance. Like, we want to offer great service to the customers at a reasonable rate, and that is what shareholders want us to do too. To knowing that we're regulated in order for us to maintain profitability over the long term.
So
they know that our earnings are not unlimited and uncapped.
So a rate increase, whatever that is equally beneficial to the customer as it is to the investor.
A rate increase.
I'm
sorry.
If there is a rate increase, and that equally benefits the customer equally in this same way as a shareholder.
I think again it is a symbiosis, and more is maybe the way to think about it. If we kept rates unreasonably low to the point where they don't cover the cost of business in the long term, that is not a good outcome for the customer or the shareholder. I think we need to keep rates in the right spot, which is part of the good work of this commission to do, and so that we are covering costs, earning a reasonable rate of return, which is what customers want and what shareholders want.
Agree. It's a challenge. It'd be a challenge for anyone, since it's against our fallen nature to think of others before ourselves. That's just hard to do. Right thing to do, but the hard thing to do. That's good enough. Thank you, ma'am. Thank you, Miss.
Thank you, Commissioner.
Albert, thank you.
Any more commissioner questions for this witness?
Chairman Williams.
Commissioner Williams, the floor is yours, ma'am.
Thank you. Nice to meet you, Ms. Albert. And in the midst of a lot of South Carolina teams, I'll say wahoo wah to you. So it's nice to make a connection with a Virginia grad.
Absolutely. Go Hoos.
Right. My question is more broad. Talk to me some about generally compensation for Dominion South Carolina customers employees as compared to others in the independently owned utility industry. I'm sure there are standards that you look at, and I'd like for you to talk some about how you all relate to your peers in terms of your compensation packages.
Sure. We are on a pay grade structure, and SCANA was also on a pay grade structure before the merger, although our structures were a little bit different, and we've just integrated those as of the first of this year, 2021. And the way that you get to these grades and you put the job in the appropriate grades is we look at survey data, anonymized survey data for comparable jobs. And we look at as many sources as we can get and try to compare the data that's in the survey to the description of the jobs that we have. We also do some internal comparison to say, well, how does this job over here compare to the value and the work and of this job over here? And then we come up with the right grade. And so we that is the process, I'll say, for trying to make sure that our pricing is sort of market-based and competitive and fair to employees.
And once you've done that, how do those numbers relate to when you look at it as a big broad picture, how do you relate to Duke or to other utility companies?
Well, we don't compare ourselves to specific companies, and what I mean by that is that the survey data is always anonymized, so that we can't just go up to Duke and say, what do you pay for these jobs, and then try to pay them more or less. But we try to target the median of the survey data, so that we feel that we're being fair and reasonable in that.
So what I hear you saying is you through this anonymized survey data, you try to get to the right number, but then once you've landed on your packages, you don't go out and compare once it's been created.
I think that's right. That's right.
Okay.
I think there are antitrust considerations there that would prevent us from, sort of colluding directly with the companies.
Okay. Thank you very much.
Thank you.
Commissioner Caston.
Ms. Albert, another question, if that's okay.
Yes.
I'm not sure how the...
Mr. Chairman and Commissioner Caston, I'm sorry to interrupt. We're just having a little bit of a difficult time hearing you, Commissioner Caston.
I'm sorry. Can you hear now?
Yes, sir, that's a little better. Thank you.
Before you continue, Commissioner Caston, I believe that was Attorney Knowles.
Yes, sir. Sorry, Mr. Chairman. I didn't identify myself. My apologies, Ms. Weeder, Madam Court Reporter. This is Attorney Knowles.
Thank you.
Can you hear me okay now?
I can hear you.
Okay, thank you.
Just a little bit.
Attorney Knowles, yes, sir.
Relative to like the compensation package incentives, how that's set up, who establishes that? Is that an internal thing? Is that done by a board of directors, or how is that done again?
Who establishes the incentive plan?
Yes, ma'am, for the executives that we've been discussing.
Yes, so the annual incentive plan and the long-term incentive plans, those are approved by the compensation committee of the board of directors of Dominion Energy, Inc.
Would it be possible and again, I'm not sure how it's done, but would it be possible to link goals or incentive, whatever, to efficiency incentives? Something that's tangible and measurable at the end of the day, end of the year, or whatever. That, for example, let's say by doing X, we reduced our cost by Y, and we saved Z. And through the course of time, operating more effectively and efficiently, the incentive would be to really reduce cost so that the need for rate increases is marginalized, minimized, or suspended for a while. I mean, do you agree that that could occur, that could be a good thing?
Yeah, I actually think that the plan is set up to encourage that very outcome.
Well, maybe, but how do you know if you're achieving it? Now, I know there were some percentages mentioned yesterday, day before, but again, and those are certainly tangible and measurable, but as far as the big picture, the overall, how did that affect our cost? How did that help me save money that I can pass on to our customers? And as I understood it, I really wasn't clear what metrics you used to determine how effective or efficient you are, and it seems that you don't know what your neighbors do, whether that's Duke or whatever, and I don't know if perhaps you do. But it's hard to measure what are you measuring and against what, if that makes sense.
Right. Well, if we're talking specifically about cost savings, there are various programs in the company to track efforts that generate cost savings through supply chain and through the finance groups. So that is something that's tracked, and that's something that's encouraged by the structure of the annual incentive plan, for example, is to be creative and innovative and thinking about new ways to do things, whether that's through technology or just reconfiguring an old process or maybe moving to a different supplier in order to save money. So there are various ways in which those initiatives are tracked, and employees are really encouraged to bring their ideas forward, since they're the ones that have the expertise to come up with those types of ideas.
Sounds good. But I was even thinking back to, excuse me, I think Tuesday, when we were looking at number of customers per employee, maybe number of customers or number of employees per mile of transmission line. And I don't know what that should be. I'm not trying to say I know what that should be. But is 200 or 214 customers per employee a best-in-class number? I don't know. But things like that could matter. So in the big picture, if we're going to be talking about compensation, tying this to that, and it's just hard. It is hard or difficult to. It's hard to measure what you don't know is important. And I'm not saying Dominion doesn't know what's important. You have to determine that. But you say that the incentive package is linked to efficiency and such as that. Perhaps it is. I just didn't understand it real well, but that doesn't mean it's not existing. Anyway, thank you very much. Thank you.
Thank you. Thank you, sir.
Any more commissioner questions? I got a question for Commissioner Powers. Commissioner Powers,
Yes, sir.
I could have misheard, but I think you asked about the salaries of some of the executives at the company. Did you want a late filed exhibit?
I did, and I thought she agreed to that.
Okay, we just need to reserve hearing exhibit number for it. Could you make the request again?
Certainly, the request was the four top executives as well as the president of Dominion Energy South Carolina, Mr. Rodney Blevins, the salaries and what percentages that is tied to that as far as any compensation tied to those earnings.
Okay. And we will reserve a late file exhibit and mark the exhibit as hearing exhibit 29.
Thank you, sir.
No problem. Ms. Elbert, do you mind if I ask you a couple of questions?
Surely. Thank you.
You talked about diversity at Dominion Energy South Carolina, right?
Right.
Okay. How do you measure diversity at Dominion Energy South Carolina?
So we track it in different ways. Of course, we have EEO reporting that we're required to do, and then internally we also look at it from a perspective of sort of diverse versus non-diverse folks. So we look at it actually just in a number of different ways.
Okay, let's start from the top. What's the first way you look at it?
One would be to look at, and I'm sorry I don't have the reports in front of me to give you specific data, but one example would be to say, and we usually look at it company-wide, although we also will break it down by business groups, to look at different levels of leadership and see, where we have diverse and non-diverse people. And so that way we're looking at the pipeline for leadership in the future to ensure that we continue to have a diverse pipeline to fill leadership roles. So that's one focus that we have. Another is just looking at the employee base as a whole, including all levels, and seeing what areas of diversity we have or don't have. So those are some examples of how we look at it.
Ms. Elbert, I'm not trying to give you a hard time at all, but I think some of my line of questioning and the answers I'm receiving, I think it speaks to some of the I don't know if it's frustration or maybe it could be frustration. Some of my colleagues may have with some of the company answers. Now, you brought up diversity in your either direct or rebuttal testimony summary. I think you talked about how it was important to the company. And now here I am asking you questions about how you measure diversity, how you define diversity, what does diversity look like within the company, and you're telling me that you don't have the numbers in front of you and you give me some pretty general answers. They sound good, but it's not telling me much information. Now, and I don't mean that to be disrespectful or harsh. I'm just having a little conversation with you.
I understand. I just I would have brought more detailed data if I had thought that that's what we were going to be discussing. And actually, the way that we are set up, diversity and inclusion falls under a different executive who I'm sure would be able to give you more rapid-fire answers to the detailed questions that you're asking. It doesn't fall under me, but I'm happy to follow up with whatever information would be helpful.
Right. But you did bring up diversity, though, right?
Yes, because it is a part of our annual incentive plan goal to have diversity, inclusion training every year. So I did bring it up.
So it's a part of your annual incentive goal to have diversity and inclusion training, but yet you can't give me specifics regarding how you measure diversity. And I haven't even got to the more granular questions that I have.
Well, I'm sorry if I wasn't specific enough in your in my answers. Please let me know how I can be more.
How many
specific.
African Americans do you have employed at Dominion Energy, South Carolina?
I don't know that off the top of my head, but it's something.
How many
I
women do you have
get.
employed at Dominion Energy, South Carolina?
I also don't have that figure off the top of my head.
How many veterans do you have employed at Dominion Energy, South Carolina?
It's the same answer, sir.
How many, what's the percentage of diversity for Dominion Energy, South Carolina's executive leadership team?
For Dominion Energy South Carolina's. So I'm trying to think who exactly that would encompass. It's a small group of folks that are executives at Dominion Energy South Carolina.
And if you don't know the answer, that's fine, but I'll tell you this, and this is really not I don't want you to feel like you're not doing a good job testifying. You are actually doing a good job testifying. I think your testimony is in line with some of the other testimony that we've heard regarding other topics. I'm just happening to ask you about diversity. But I will say this to you. Based on your testimony, if I wanted to have an understanding of how Dominion Energy measures diversity, the level of diversity at Dominion Energy South Carolina, I'm speaking for Dominion Energy South Carolina. So if I wanted to measure the diversity at Dominion Energy South Carolina, determine what, if any, advances Dominion Energy South Carolina has made in diversity, based on your testimony, I couldn't do that.
That's right. That was not the focus of my testimony.
But you said diversity and inclusion is a part of the annual incentive program, right?
That's right. There is a goal under that is related to diversity and inclusion.
And a part of that incentive program, you're asking for Dominion Energy South Carolina customers to pay for that, right?
Well, that is part of the program, but the goal is not around the specific statistics that we are discussing now. The goal is around training and leadership-led training specifically, and also supplier diversity. So I could talk about a couple of those things if you like, and provide any supplemental information that would be helpful.
Sure. Because the reason I'm asking you these questions, we had over 160 ratepayers call in, and some of them may be watching the live stream, and some of them may be okay with paying for incentives. But they may say, well, hey, what am I actually paying for? This witness is talking about diversity and inclusion, just one of many incentive programs I'm sure you have there, but we're talking about diversity now. So what exactly am I paying for? Why are you asking me, a ratepayer, to pay for this diversity and inclusion program, and what is the benefit to me? Could you explain that?
Right. So the diversity and inclusion aspect of the goal has two parts. If you are a leader, it has a supplier diversity component, and if you are a non-leader, it is a training component. So if you're a leader, you have to accomplish both the supplier diversity and the training part. If you're a non-leader, it's just the training part. The supplier diversity is a program that's set up through supply chain to track whether or not our suppliers are diverse, and basically they set a certain percentage of spend target for the year and say, did we meet that or did we not meet that? And it could also be measured in terms of a hard dollar amount. And so that is the nature of that goal. The training goal is for 95% of our employees to engage in a leader-led conversation about diversity, and the company provides materials to help leaders facilitate those conversations. What we've found over the years is that a leader-led conversation is best because it shows the company's commitment to diversity and inclusion and why it's important to the company. It seems to be very effective compared to sort of general training materials or bringing in an outside consultant. So that's why we had included that type of goal.
May I ask you, Ms. Elbert, may I interject? I don't want to be disrespectful.
Surely.
How many leader-led conversations on diversity were held at Dominion Energy, South Carolina during the test year?
I don't know exactly how many conversations were had, and I'm using the word conversation. It could be like a small group meeting, but it's enough that we did meet the 95% goal in 2019 for employees to be engaged in a conversation with their leader about the business case for diversity.
95% of what?
95% of all employees.
95% of all Dominion Energy South Carolina employees participated in a leader-led discussion regarding diversity?
Yes, sir.
So that could have been one discussion that 95% of the employees attended. Was it live streamed? Was it pre-recorded?
No, it was interactive. It was not live stream. It wasn't one discussion for everyone.
Do you see how I may have some difficulty really understanding or knowing exactly what's going on in the area of diversity? And I'm speaking about diversity, but I want to repeat, this is a repeating theme regarding company witnesses on a multitude of areas. We're just happening to be talking about diversity now. But do you see how, like, if you were me, would you be able to really have a firm understanding of what exactly occurs in the diversity and inclusion incentive program to determine whether or not it's valuable to ratepayers, where you could clearly articulate in an easy-to-understand manner, a transparent manner, where a ratepayer can understand why they're being asked to pay for a diversity incentive program?
I apologize. I'm doing my best to explain how the goal works and what the features of the goal are. The purpose of the goal is to create that culture of diversity and inclusion and that consistent messaging reinforcing how important it really is to the company. And we do think that is important, that people hear that and they hear that from their leaders on a consistent basis.
Oh, I think it's important too. Please don't mistake that. I think it's very important. I just don't know how many conversations or meetings or discussions were held. I hear the number 95%. It's not. It's hard for me to really know what that means. It's just a figure that's thrown out there. I can't really compare it to anything. I want to move on. You did go to law school, right?
Yes, sir.
Okay, so you're familiar with hypotheticals?
Yeah, yes, sir.
Absolutely. And you're a UVA grad, so you're smarter than I am. Right?
I don't know about that.
Yes, you are. I want to throw a hypothetical out to you. Let's say there was a group of utility executives that came and testified before a state's public service commission about the health and profitability of utility on a variety of different areas, and that they were included in an incentive program that rewarded them as long as the company was healthy and performing well. But later on, it came out that those executives were lying to the state commission, and it came out a long time later, but during the course of those lies, they benefited greatly because of the incentive program that they were a part of. They benefited from their lies. You could argue they were incentivized to lie. And ratepayers were paying those incentives. What would you think about that?
That sounds like something to be, this hypothetical sounds like something to be looked into.
I agree.
I certainly was not. I think we're sort of vaguely alluding to things that happened at SCANA prior to the.
I'm not alluding to anything. I'm just asking a hypothetical. How would you feel if you were a ratepayer? How would you feel about paying for incentives that were the result of lies?
That doesn't feel very good.
167 people told me that over the course of about 80 hours about how bad it felt. Let me tell you why I asked that hypothetical. Wouldn't shareholders be in a better position to pay incentives than ratepayers?
Well, I have to say that I feel that when we're talking about the type of incentives we're talking about, we're not talking about something wildly out of line with any company that would be doing business. They're very standard incentives. It is part of good governance, and it's a cost of doing business. And so, I don't think it's this either or choice that we have, that it either benefits shareholders or it benefits customers.
I don't disagree with you, but I'm asking a best practice, considering the risk associated with incentives and maybe executives could be incentivized to ensure a healthy company, and that may not necessarily benefit the ratepayer. Maybe it does, but maybe it doesn't. But it's risky. Why not have the shareholders bear the burden of those incentives, considering that those executive performance measures usually increase or hopefully increase stock price, which benefits shareholders?
I just think that goes back to this either-or concept that I don't think is really true. I think if it's a appropriately incurred cost of doing business, then the expectation would be that that's a fair cost for ratepayers to incur.
Right. I hear you. But just because that's the way it's always been done doesn't necessarily mean that's the way it should continue to happen. I know that's the norm, the industry standard, but who's to say the industry standard is the right standard?
Well, it's certainly not for me to ultimately decide. I can just give you my opinion, which is that I think it is a reasonable and fair cost, but that is just my opinion.
Okay. One last question for you, Ms. Elbert. As I look at the list of public witnesses that we've listened to over the course of this hearing, I just keep hearing their testimony in my head, and I just want you to explain to me, for those ratepayers that called in and they had all their different issues, how would you explain to them how charging them for employee incentives, directly benefits them?
So I understand that this is a hard concept for folks to grasp, especially when you are struggling, as I heard many of those folks who called in are certainly struggling. But the way that I would attempt to explain it is that for the employee who's working here, whether they are a lineman or the CEO, they're doing a job for a fair pay with a compensation structure, and incentives are part of that. So it is reasonable for them to expect that they're going to be paid reasonably and consistent with what the market would suggest for the work that they're doing. And we could take incentives away, but then we're going to have to increase something else for the pay to continue to be fair. So I do think that we still have this duty to provide fair compensation, and that incentives are simply a part of that. They're not something that's unearned and just falls from the sky. They're part of the fair pay for the work and the job that they're doing.
So the answer would be it's fair. That's why you should pay for it, Mr. and Mrs. Ratepayer. It's fair to the company's employees to pay them an incentive. So because it's fair, you should pay for it.
It's fair and reasonable. It is.
Thank you so much for your testimony.
Chair Williams.
Commissioner Caston.
Ms. Elbert, first of all, I want to say that Chairman Williams is an honest man, and if he says you're smarter than he is, you are. And I want to commend you, too, on your poise, your calmness. He is correct. You've done an incredible job.
Thank you.
As I was listening to Chairman Williams, and again, we're just creatures of our history, our past. I'm no different. But I go back to, again, I don't know a whole lot about a lot of things. But to a great degree, an experience that at least I had, I think I do understand, at least from the utility I worked at, our purpose. One thing we really understood, I personally preached, and the culture became that. I don't know if you've ever read The Purpose-Driven Life, but it's kind of like that, the first sentence on the first page. It's not about us. At the utility I worked at, we understood that. It wasn't about us. It wasn't about me. And that's a constant fight. It's a constant battle because I'm selfish. So is everybody that worked at my utility. I want it to be about me or us. But we understood that the utility did not exist for us. It existed for our customers, period. That's why it existed. So our goal, my goal, our goal as a company was to do everything we could to help them as much as we could. Now, you can't just give stuff away and lose money. I get that. I mean, if you can't perpetuate yourself, you're no good to anyone. But we made it our goal to treat internal and external customers just the way we want to be treated, and that involved our compensation, everything. Looking at technology, strategy, whatever we needed to do, comparing ourselves not with just our neighbors, but whoever we could find that were the best in class. It didn't matter. Being the best we could be. Our incentive was that. To be the best we could be, to save our customers as much as we could, to not go up on their rates any more than necessary, which, matter of fact, we didn't. We did not go up on them because we understood we existed for them, not us. And oftentimes, looking at other utilities, look, I get it, I understand it. I'd see the same thing, we need this because this, and if we don't do this, then, that hurts the customers too. I understand all that. I guess what I'm probably bloviating about is perhaps it's time for a paradigm shift. Why do we need to do things the way we've always done them if the way we've always done them maybe isn't the best way to do it? So I'm encouraging not only Dominion, but all utilities. Let's not be afraid to figure out a better way to do all this stuff. And again, I want to thank you. You have been delightful. You've been wonderful. Thank you so much.
Thank you, Commissioner Gaston.
Chairman Williams?
Commissioner Williams.
Thank you very much. Ms. Elbert, I have been spending some of my time, as my colleagues have been asking you questions, looking at your exhibit. And I want to check to see if I'm understanding this right. What you've presented to us are your goals. And I think a lot of what is that true?
In the exhibit that talks about the 2019 plan, it does contain some of the goals. Not all of the operating and stewardship goals are in that exhibit, but it does contain some of the company-wide goals.
And as a non-lawyer, I'm not sure about the value of a late filed exhibit, but I wonder, given the line of questioning, if it would be valuable for us to be able to see how you performed in that 2019 test year as related to the goals that are in your exhibit. Would that be possible?
Yes, it would.
Do you think it might be meaningful to us, given the questioning?
It's up to you, but I'd be happy to follow up with an exhibit that would explain what the performance was, if you find that valuable.
I would. Yes, I would. And I also wanted to kind of check to see, and my screen is frozen right now, but page 11 of your exhibit, does that summarize the overall plans that we've been talking about this morning?
Yes, page 11 says 2019 AIP goal plan points.
Good. Okay, I just wanted to clarify that for my own understanding. But Chairman Williams, I would like to request a late file exhibit that is built on their goals that shows how they were able to perform metric-wise in 2019 in the test year.
Absolutely, and so just to make sure we're requesting the right thing, or the request meets our expectation, Ms. Elbert, what would you plan on submitting in response to that request for a late filed exhibit regarding the goals?
So I would, looking at the company-wide goals that are on that presentation, it's safety, diversity and inclusion, and environmental, as well as the financial goals. I would just probably structure it as a chart that says here's what the goal was, and then here's what the performance was. So here's the percentage score. Did we make 100% of that goal, or maybe we only made 80% of that goal, etc.? Would that be helpful?
Commissioner Williams, does that meet your intent?
I think what would be more helpful is to understand what that 85% is comprised of, and to go back to Chairman Williams' discussion with you to understand how many leader-trained diversity conversations happened at. And I also want to parse down that this is related to DESK and not Dominion Energy. And I understand these are company-wide goals, but we would want to see them as they related to DESK. So to understand what numbers comprise the 85% completion. How did you determine that you were 85% successful? I think we need to get down to the specific components.
Sure. I will be as specific as I can be in developing that. I think, one question that comes up is how many trainings. I'll have to see if we have the data exactly that way. I believe it was an attestation that was required for employees that they attended the training, and perhaps a separate attestation for leaders that they conducted a training. So I'll have to look and see how that data is captured.
And just to broaden it, of course, part of this is supplier diversity spending, and I don't know that it'd be appropriate to see specific numbers. I know you need to share that in as appropriate a way as possible, but that would be another. I mean, there you have some real specific numbers, so I think you'll be able to do that more easily, fulfill the request more easily in that case.
Yes, I'm confident we could get those numbers.
Thank you, Chairman Williams, for the question.
Oh, no problem. We just want to make sure that everyone's on the same page. And I know that Ms. Elbert is more than capable, but Ms. Elbert, now, you know, from where I sit, the questions we're asking you may go outside of your realm of responsibility. So I know that Dominion Energy South Carolina wouldn't expect for you to do all this on your own.
I sure hope not. But I think we can gather the data, and as I said, we'll break it out to Dominion Energy South Carolina to the maximum ability that we can. If we run into roadblocks, we would specify the reason why.
Yes, ma'am. So when do you think you can get this information to us?
Would the end of next week be a reasonable time frame? 1 week?
Reasonable for me. Is it reasonable for you?
I think so. I am speaking on behalf of some other teams that I'd have to engage to get the data, but I do think that would be reasonable.
Okay, so that's January 15th.
Yes, sir.
All right, so we're going to reserve a late file exhibit. That would be hearing exhibit 30 for detailed report on Ms. Elbert's exhibit. Is that RJE1? RJE1, yeah, I think that's it. Okay. Any more questions for Ms. Elbert?
Mr. Chairman, one follow-up, please.
Yes, sir.
Ms. Elbert, of the company's 4 highest compensated executives, how many of those are African American or women?
I believe 2 are women, and none of those 4 are African American.
Thank you very much.
Thank you.
Redirect.
No redirect, Your Honor.
Ms. Elbert, thank you for your testimony. Thank you for providing all the information we asked. You may step down from the witness stand and be excused. We're going to take a 10-minute recess.
Thank you.
All right, ladies and gentlemen, we're back in the matter of docket number 202125E, Dominion Energy South Carolina's application for rate adjustments. We're going to take a brief roll call. We have Vice Chair Belzer, Commissioner Caston, and Chairman Williams present in the hearing room. We have Commissioners Irvin, Thomas, Powers, and Williams present with us virtually. Before the applicant calls its next witness, a few things I need to clarify. At the start of the hearing, I believe it was ORS counsel who requested the letters in objection to the rate increase be admitted into evidence as hearing exhibit 8. Is that correct?
Yes, Mr. Chairman. I believe you're referring to the protest letters on the Commission's docket management system. Is that correct?
Right, the protest letters, and I'm mistaken. It's hearing exhibit 7. So we're going to keep that exhibit open until the end of the hearing, so that we can take all of those letters into consideration.
Perfect. Thank you, Mr. Chairman.
Mr. Chairman, this is Chad Burgess on behalf of Dominion Energy, and I'd like to renew the objection that we put on the record with respect to those letters of protest coming into evidence. Like you indicated in the night hearings, those letters, they're not sworn testimony. No one has presented them under oath, and we don't think they're appropriate to include in the record of evidence. Thank you, Mr. Chairman.
Thank you for your objection, Attorney Burgess. We also need to enter into evidence hearing exhibit 14, hearing exhibit 29, and hearing exhibit 30. Those are late filed exhibits, and we're going to enter them into the record at this time. All right. And the applicant has the next witness listed as Mr. Zachary D. Long. We're going to go ahead and stipulate to his...
Yes, Mr. Chairman, this is Michael Anselmo on behalf of the company. You're correct. The parties have stipulated to the admissibility of Mr. Long's testimony. So at this time, I move that the pre-filed direct and rebuttal testimony of Mr. Long be entered into the record as if being given orally from the stand. His testimony includes no exhibits.
Thank you, sir. Mr. Long's pre-filed direct and rebuttal testimony will be entered into the record as if given orally from the stand. Applicant, please call your next witness.
Mr. Willoughby will be doing that, Mr. Chairman.
Thank you, sir. Mr. Willoughby, Attorney Willoughby, give me 1 second. Sorry. And when should the commission expect the verification from Mr. Long?
Michael, you're on mute.
Yes, Mr. Chairman, we will effort that as soon as possible. Due to the family emergency, I would anticipate that coming in early next week.
Yes, sir. Thank you very much. Attorney Willoughby?
Thank you.
Thank you, Mr. Chairman. Our next witness is Mr. John Spanos. I would ask Mr. Spanos to turn on his camera. Good morning, Mr. Spanos. I would ask that you go ahead and turn on your mic or your audio, and the court reporter will swear you in.
Just checking. Good morning. If everyone can hear me.
We can hear you. Can you hear us?
Yes, thank you.
Very good. If you could raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much.
Thank you.
Good morning again, Mr. Spanos. Would you please state your name for the record?
John J. Spanos.
And Mr. Spanos, by whom are you employed and in what capacity?
I am employed by Gannett Fleming Valuation and Rate Consultants, LLC, and I am the president.
Thank you, Mr. Spanos. In connection with this proceeding, did you cause to be prepared and pre-filed direct testimony consisting of 20 pages?
Yes, I did.
Changes to be made to those 20 pages of testimony?
No, I do not.
If I asked you the questions that appear in that testimony, would your answers from the stand today be the same?
Yes, they would.
Mr. Chairman, we would move the direct testimony of Mr. Spanos into the record as if given orally from the stand.
The direct testimony of Mr. Spanos will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Spanos, did you have attached to your direct testimony 2 exhibits?
Yes, I did.
Are there any corrections or changes to be made to the exhibits?
No, there is not.
And I would mention that the second exhibit is the depreciation study that is comprised of some 592 pages. Is that correct?
That is correct.
Mr. Chairman, we would move into the record as the next hearing exhibit the 2 exhibits attached to Mr. Spanos' direct testimony.
The 2 exhibits attached to Mr. Spanos' testimony will be marked and entered as a composite exhibit, and that will be hearing exhibit 31.
Thank you, Mr. Chairman. Mr. Spanos, have you prepared a summary of your direct testimony?
Yes, I have.
Please deliver that at this time.
Good morning, Chairman Williams and members of the Commission. The purpose of my direct testimony is to support and explain the depreciation study conducted for all DESC's electric and common plant assets. Depreciation refers to the loss in service value not restored by current maintenance incurred in connection with the consumption or retirement of utility plant in the course of service against which the company is not protected by insurance. The purpose of the depreciation study conducted for the company was to determine the annual depreciation accruals related to electric and common plant in service for rate-making purposes and the appropriate average service lives and net salvage percents for each plant account. To determine the recommended annual depreciation accrual rates, I first estimated the service life and net salvage percents of the company's plant using historic data from 1940 through 2018, as well as supplementary information relating to plant operations. I then applied the retirement rate method to each group of property and interpreted this information using the Iowa type survivor curve, which contained the range of survivor characteristics usually experienced by other utility companies. In accordance with authoritative text, the life estimation process should include conducting field visits, which I have done in this and prior depreciation studies for the company, and forming an understanding of company plans for asset classes, which I have obtained in more than 20 years of conducting depreciation studies for DESC. My judgment also is informed by the hundreds of other site visits I have conducted for other utilities across the United States and Canada. Also, site visits are important to analyze whether changes in life characteristics from current estimates has occurred. To estimate the lives of significant structures and production facilities, I use the lifespan technique, which describes the survivor characteristics of the facilities using interim survivor curves and estimated probable retirement dates. This provides a consistent method for estimating for the lives of the several years of installation for a particular facility. I also made a field review of DESC's property to observe representative portions of plant to become familiar with the company operations and obtain an understanding of the function of the plant. I have also conducted field reviews in prior studies for the company as far back as the 1990s. Using historic data and estimates from other electric companies, the study also determined the net salvage percents of the capital assets. This is the salvage value received for the asset upon retirement, less the cost to retire the asset. The net salvage related to an asset should be incorporated in the cost of service during the same period as the original cost, so that customers receiving service from the asset pay rates that include a portion of both elements of the asset's service value. Using this information, I then calculated the annual depreciation accrual rates for each group based on the straight line remaining life method. As part of the study, I have recommended that amortization accounting be continued for certain general and common plan accounts. Amortization accounting is used for accounts with a large number of units but small asset values. Using this method, all units are retired when the age of the vintage reaches the amortization period and there is no dispersion of retirement. Also, as part of the study, I evaluated the company's program to replace its existing electric meters with new advanced metering infrastructure, AMI, technology meters. This project is expected to be completed in the next few years. As part of this project, the company will establish an unrecovered plant regulatory asset for the remaining net book value of many of the retired meters to be amortized over the anticipated remaining life of the meters, which would be through 2028. However, certain meter assets will not be replaced based on the program and will be depreciated consistent with the appropriate survivor curve. Based on my depreciation study, in my opinion, the depreciation and amortization rates set forth in my Exhibit JJS-2 that is attached to my direct testimony appropriately reflect the rates at which the value of DESC's assets are being consumed over their useful life. I also believe that these rates are an appropriate basis for setting electric rates in this matter and for the company to use in booking depreciation and amortization expense going forward. This concludes a summary of my direct testimony.
Thank you very much, Mr. Spanos. Did you also prepare, Mr. Spanos, a rebuttal testimony?
Yes, I have.
And a rebuttal testimony consisted of 51 pages, correct?
That is correct.
Are there any corrections or changes to be made to the pre-filed rebuttal testimony?
No, there is not.
If I asked you the questions that appear in the pre-filed rebuttal testimony, would your answers from the stand today be the same?
Yes, they would.
Mr. Chairman, I would move into the record as if given orally from the stand the pre-filed rebuttal testimony of Mr. Spanos.
Pre-filed rebuttal testimony of Mr. Spanos will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Spanos, did you have 3 exhibits attached to your rebuttal testimony?
Yes, I did.
Are there any corrections or changes to be made to those exhibits?
No, there is not.
Mr. Chairman, I would move into the record as the next hearing exhibit the 3 exhibits attached to Mr. Spanos's pre-filed pre-filed rebuttal testimony.
The 3 exhibits attached to Mr. Spanos' pre-filed rebuttal testimony will be marked as a composite exhibit and entered into the record as hearing exhibit 32.
Thank you very much, Mr. Chairman. Mr. Spanos, have you prepared a summary of your rebuttal testimony?
Yes, I have.
And Mr. Chairman, I'm going to ask Mr. Spanos to deliver it at this time. And during his summary, at some point, Mr. Spanos is going to ask me to share an exhibit on the screen from his rebuttal testimony, and I will do so. Please deliver your summary at this time.
Okay. In my rebuttal testimony, I respond to certain matters raised in the testimony of Mr. David J. Garrett on behalf of the South Carolina Office of Regulatory Staff, ORS, regarding the most appropriate life characteristics of some transmission and distribution accounts and the most reasonable approach to net salvage for generation accounts. I also respond to depreciation issues raised by ORS witness Lane Collin and Sierra Club witness Elizabeth A. Stanton concerning excluded plant and service. Additionally, I discuss the amortization period for the Kennedy's Generation Station, which is addressed by Mark E. Garrett on behalf of the United States Department of Defense and all other federal executive agencies, DoD, FEA. ORS witness David Garrett proposes changes to the net salvage component for generation accounts and proposed different life characteristics for some transmission and distribution accounts that approximate over $20 million of reduced annual depreciation expense. Each of his recommendations is unreasonable and fails to follow all the methodologies of authoritative text for estimating life and net salvage parameters. Although Mr. Garrett attempts to establish a distinction between terminal and interim net salvage for generating facilities, his calculations are flawed and create a random and insufficient amount of terminal net salvage, which is not supportable. Additionally, Mr. Garrett does not follow common recovery patterns of the weighted net salvage component for generating facilities to the date of retirement. I discussed the key elements of Mr. David Garrett's terminal net salvage analysis that are incorrect and provide correct calculations that would be appropriate for the type of methodology he is recommending. As for Mr. David Garrett's recommended changes in life estimation, his survivor curves are not consistent with the matching principle, which emphasizes the need to match utilization of the assets to recovery of the assets. His process of only using mathematical fitting of curves clearly produces an unreasonable life characteristic and cycles of many asset classes. In my opinion, his lack of informed judgment and understanding of the full life cycle of each asset class to which he recommends a change has created survivor curves that are not consistent with the reliability of the assets or the need for the utility to provide quality service to its customers. A few examples of Mr. David Garrett not fully considering the overall life cycle of his estimate can be found in Account 355, Poles and Fixtures, and Account 373, Street Lighting and Signal Systems. Mr. Willoughby, if you could put up the first chart, that would be helpful, please. Thank you. The following is a chart taken from my rebuttal testimony, and this represents a survivor curve. So I think it's important for everyone to understand how this is utilized for matching.
Mr. Spanos?
Yes. Yes.
Please allow Mr. Willoughby to expand or blow up your chart so we can see it a little better.
Great.
Okay. Thank you, Mr. Chairman. I will do that now. How about that?
That's better. Thank you.
Is that good enough,
Okay.
Mr. Chairman?
Yes, sir.
That's perfect. Thank you, Mr.
Yep.
Willoughby. So the survivor curve chart is a reflection of the matching principle, and it relates to the utilization of the asset and the recovery of the asset. So you will see the squares, triangles, and circles, which represent the historical utilization of the assets. So the Y curve is a percent surviving, and the X-axis is the age in years. So you can see for this particular transmission poles and fixtures account, the assets start at 100% and move down on this chart to approximately 18% at age 65. And that is how the assets have been utilized to date. The smooth curves represent the estimation of historical and future life characteristics and the entire life cycle of transmission poles. So as you can see, the smooth curve, which is a 53S1, which is my recommendation, reflects the my not only reflection of the historical, but the expectation of the future, which will take these curves and the utilization and recovery of these curves out to about 100 years where they will stay reliable and provide quality service. The second curve that you see there is ORS's representation of a 5901.5 curve, which reflects a reasonable match through age 55, but does not consider the fact that the assets will be retired with more forces of retirement, and thus the expectation that these assets will live 150 years, and which means they will be recovered over 150 years, which is not reasonable. So I will continue from that point just so people can see the graph and they will be understanding some of my comments. For count 355, poles and fixtures, ORS witness David Garrett recommends a 59 L1.5 survivor curve, which estimates an average life of 59 years, but a maximum life of nearly 150 years. Therefore, Mr. Garrett has the unrealistic expectation that once transmission poles reach 60 years of age, there will be less forces of retirements on poles, and that DESC should be expected to leave poles in service and provide quality, reliable service until age 150. Mr. Willoughby, if you could put up the other chart, please. Thank you. Mr. David Garrett has a similar expectation for account 373 street lighting and signal systems. The following is again taken from my rebuttal testimony. So again, here you see the two charts, and the 39 S0.5 is DESC's estimate. It reflects the fact that this particular account on a go-forward basis will have changes to the asset mix as we move forward with LED fixtures, and so the history should reflect an overall life expectation of no more than 75 years in life. ORS has recommended, although a 42-year average, but again, the expectation that these assets will be recovered over 110 years and that the forces of retirement will slow after age 40. So, for account 373, Mr. David Garrett estimates an average life of 42 years and a maximum life of 105 years. Again, his estimate anticipates the force of retirement will be reduced as the assets in this account get beyond the average, and he does not consider the extensive program to replace all high-pressure sodium fixtures with LED lighting. Flaws of this type in Mr. Garrett's life estimation clearly result from the lack of informed judgment in his analysis. I also address ORS witness Lane Collins' recommendation to exclude certain transmission assets and his additional adjustments to depreciation expense based on Mr. David Garrett's calculations. In short, Mr. Collins does not conduct any independent depreciation analyses and does not review or evaluate the company's plans for life characteristics or net salvage parameters. The issue I address related to Sierra Club witness Stanton is in the connection with the company has inappropriately expended capital plant additions for the last few years with respect to coal facilities. Many plant additions are necessary to keep assets operating and generating electricity until the end of their useful life. Witness Stanton's proposal most likely would require the company to invest in new generation facilities that would cost much more than the investments to keep coal facilities operating. I also addressed DoD FEA witness Mark Garrett's recommendation of a 40-year amortization period for recovery of the Kennedy's remaining net plant. There simply is no basis for this long period of time as compared to the established remaining life of the plant when it was taken out of service. The Kennedy's plant, and a lifespan through 2025, which is how the full service value was calculated and recovery was established, Mr. Mark Garrett's proposal would result in intergenerational inequity by shifting the cost to customers who do not benefit from the Kennedy's plant. Thus, there is no reason to change that recovery period for Kennedy's. This concludes the summary of my rebuttal testimony.
Thank you very much, Mr. Spanos. Mr. Chairman, Mr. Spanos is available for questions from the parties and from the commission. And Mr. Chairman, I would, as Mr. Spanos begins his cross-examination, I would like to put my name in for the commission's award for the most tech-savvy lawyer from this group. So if you'll just include me on that thinking, Mr. Chairman, when you start thinking about that award, I would appreciate it. Mr. Spanos is available for cross.
Absolutely, Attorney Willoughby. The award ceremony will start on January 18th.
Thank you.
AARP. Walmart.
This is Stephanie Eaton for Walmart. We have no cross-examination.
Sierra Club.
Yes, thank you, Mr. Chairman. This is Dorothy Jaffe on behalf of the Sierra Club. I do have one or two questions.
Please proceed.
Thank you. Mr. Spanos, on page 48 of your rebuttal, lines 16 through 17, you state immediate shutdown of facilities in reference to the coal plants is not an option. Is that correct?
On page 48, lines 16, 17, I do have a sentence that starts in that fashion.
Okay. And isn't it in fact true that Dr. Stanton's conclusion and recommendation is that a retirement analysis on the coal plants needs to be conducted before additional investments are made, and that she at no time stated that immediate shutdown was required?
Based on my reading of her testimony, I did not see that she was requesting an immediate shutdown, but my point in reference to this testimony was the fact that assets, there is a probable retirement date established in the calculation, and the fact that there are assets that will be needed to be replaced and added up until that date of retirement. So that's the point of the discussion, that making an immediate shutdown is not possible, and you do need to continue to add capital investment in order to allow it to reach its probable retirement date.
Okay, thank you, Mr. Spanos. No further questions.
Thank you.
United States Department of Defense and all other federal executive agencies.
Thank you, Mr. Chairman. Emily Medlin, we have no questions.
Frank Knapp, Jr.
Thank you, Mr. Chairman. I have no questions.
South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Thank you, Mr. Chairman. Kate Mixon for Safe and CCL. We have no questions.
South Carolina Energy Users Committee.
Mr. Chairman, Scott Elliott. I have no questions. Thank you.
South Carolina Department of Consumer Affairs.
No questions. Thank you, Mr. Chairman.
Office of Regulatory Staff.
Thank you, Mr. Chairman. This is Andrew Bateman. No questions from ORS. Thank you.
All right, before we break for lunch, there was an offer to stipulate more testimony. Wanted to see whether or not the parties had come to an agreement or not.
Mr. Chairman, this is Andrew Bateman with ORS. I certainly do not want to speak for the Sierra Club witness. I believe we are all in agreement with witnesses Brazino and Sandonato.
Okay. Sierra Club?
Yes, Mr. Chairman. I've received confirmation from all parties except for AARP that there's no objection to the stipulation of Dominion's witness, Mr. Neely, and the Sierra Club's witness, Dr. Stanton.
Okay. Well, okay. All right. Well, let's break for lunch. We'll come back on the record at 1:25.
Thank you very much, Mr. Chairman.
Good afternoon, ladies and gentlemen. Thank you for joining us for the Public Service Commission of South Carolina's hearing in docket number 2020-125-E, Dominion Energy South Carolina's application for rate adjustment. We're back from our lunch recess, and we're going to continue with questions for Dr. Spanos. Before we get started, let's do a quick roll call for the commissioners. Vice Chair Belzer, Commissioner Caston, and Chairman Williams are present in the hearing room. Commissioners Irvin, Thomas, Powers, and Williams. That's my public address announcers. Echo. But Commissioners Irvin, Thomas, Powers, and Williams are joining us virtually. Do we need to take a pause to solve that echo, or can we move forward? Stand by. Everyone on the line. It's 1, 2. All right. We have the echo resolved thanks to our production team. ORS Counsel, are you complete with your cross-examination? Or finished?
Yes, Mr. Chairman.
All right. Commissioners, questions for the witness.
Mr. Chairman.
Vice Chair Belzer.
Good afternoon, Mr. Spanos. Thank you for your testimony today.
Good afternoon.
We still got an echo. Bear with us just a moment, Mr. Spanos.
Okay, thank you.
Does somebody have a mic that's not muted? Is that the problem? Area code 717. Our producers are going to mute you because evidently you have an open mic. Test. Sounds like we're good to go. Has that got that, Mr. Erskine?
Testing 1, 2. Okay.
Thank you for waiting on us, Mr. Spanos. Appreciate your patience. Mr. Spanos, in your critique of ORS witness Garrett's approach and his testimony on depreciation, you state that there is a subjective component to the process of determining appropriate depreciation lives. Can you expand on that for me a little bit? Okay, we can't hear you, Mr. Spanos.
Wait a minute. Okay, which one is he? This one's, okay, he's unmuted now?
I think you're unmuted now, Mr. Spanos.
He's got to turn his mic.
Mr. Spanos, do you have two mics that are open? That might be the feedback. Okay, we can't hear you. Still can't hear you. Can't hear you.
How about now?
Gotcha.
And has the interference gone away?
Yes, sir. It seems to have disappeared.
Okay, thank you, and I apologize if it was me. I didn't do anything different this time, but yeah, I think it's a great question. The subjectivity is a component in depreciation that is emphasized by the authoritative text of conducting depreciation studies. So it's part of what needs to be done, and things that relate to subjectivity would be taking field visits in order to see the assets and understand the assets, talking to company personnel to understand how those assets operate and how some of those assets will have life cycles going forward into the future. Doing the same thing for other utilities in the industry so that you're not being, as all authoritative texts say, you don't want to be dominated by just the mathematical statistics of the data. You need to take into consideration how future assets will be different or the same from the past. So what you need to do is take into consideration all of the extra knowledge that can be obtained in understanding the life characteristics and the life cycles of an asset. And such things, subjectivity that comes into play as part of informed judgment also include regulatory environments, the focus of technology and obsolescence into asset classes and how those may be different than in the past. So when you build all of that into your judgment in determining not only the statistical analysis, but all the important factors that would relate to the assets going forward, that's where subjectivity comes into play. And the one thing that's critical to understand is we know what's happened in the past, but we also have to consider, survivor curves and depreciation rates are for going forward into the future. And so if you just mimic the past without taking into consideration all of these factors, then you avoid subjectivity and properly analyzing the life characteristics and future cycles of those assets. So those are some of the key components that relate to why subjectivity is important and why authoritative texts in the field of life estimation emphasize using it as part of your appropriate characteristics. And you can only do that by looking at facilities, conducting full studies, understanding how these assets are going to be operated.
Thank you very much. I appreciate that. That's all I have, Mr. Chairman.
Commissioner questions for this witness?
Chairman Williams.
Commissioner Caston.
Good afternoon, Mr. Spanos.
Good afternoon.
I was trying to, I was looking at the curves, figure 2 and 3 again, just, trying to follow along with what you were saying earlier. And I think these are the curves that were developed by, well, I'm getting ready to make some group probably angry, either the Iowa Hawkeyes or the Iowa State Cyclones. Which university were these developed at?
They were from Iowa State.
Okay.
So the Cyclones, I guess that's where the area of depreciation was focused. And it was Robley Winfrey back in the 20s that kind of established this process and then developed further by Iowa State.
All righty, thank you. I was looking at figure 2 and, trying again to follow along with what you were saying. And I was looking at, I guess, the scattered points you have on, between year, whatever that is, maybe 50, 55 to 70, 75, up to between 40 and 15%. Where did those come from?
Well, first, just to make sure I'm on the same, I'm assuming you're working off of the charts that were part of my rebuttal summary this morning that Mr. Willoughby expertly put on the screen.
Yes, sir. Page 22 of 51 of your rebuttal. Well,
Okay,
that's
so
what
you're
I was
working
looking
off
at.
of the
That's
okay,
what I was
very
looking
good.
at.
Now no, that's fine. I just wanted to make sure we were talking about the same asset class, so that we have things all properly assessed. So on that particular page, if I'm looking correctly at page 22, we're dealing with the count 356, which is transmission overhead conductors and devices. And the representation of those assets, the triangles, are the actual historical transactional data of Dominion Energy South Carolina. So when a new asset comes into service, it comes in at age 0 because it's brand new, and each year that it stays in service, it moves down the x-axis. So when you add up all the assets that have come into play, you then will see that for transmission, overhead conductor, and devices, the triangles, which is historical data, goes down to about 0% surviving around age 90. If you're following along there. So if you look at the x-axis, you'll see that we get all the way to age 90, and you should see 0%, those triangles around 0% surviving. So that's telling me that
hold 1 second.
Yeah.
I'm looking for the triangle. I just don't see it on my chart at 90. The axis, 0 axis, and 90 on the x-axis and 0 on the y-axis.
That's correct. All those, if you're looking at my rebuttal testimony, excuse me, I'm on the, let me go, I think I was in the wrong section for you. Let me just correct that. I apologize.
I see the squares.
John, he had...
Yes, I'm there. I'm sorry. I was on the wrong page because you were reflecting the same chart, the polls account. So there are, and it's kind of hard to see in the testimony, but there are triangles, squares, and circles that represent historical data. And the historical data, which started back in 1931, represents all of the activity that has gone on for this particular account. And when we get to age 60, well, close to age 70, the triangles, circles, and squares are about 18% surviving. And that is the company's historical data. Now, we don't know, there are still some assets that are living at that point that have made it to age 70, and you can see that the 53S1 curve that I've selected is a very good representation of that entire curve, meaning the smooth curve kind of hits the points pretty closely.
All right,
which means I'm doing it. Go ahead.
Again, I want to make sure I understand. I see the legend. The squares are 1931 to 2018 experience and placements. But what I'm trying to understand in my mind, like the square and the circle, what data is that? Is that, I mean, 100 of these things, 1,000 of them, or everything from 1931 to 2018? I still don't understand what the data points are. I mean, what is this one, for example, at the 30% 60-year intersection, that circle? What is that represent?
Sure. Okay. First, I want to say that it represents all of the company data. So for this particular account, we deal with, I'm going to kind of reference a few pages. I don't think you'll need to go to there directly, but just to kind of reference a few pages within my report. At age 0, we represent $480 million worth of investment. So that means that since 1931 through 2018, the company has put in $480 million worth of plant. When we get down to age 60, where there is about 40% surviving, we are now considering assets of about $531,000, so a much smaller percentage of the total investment. But in this particular case, these assets reflect polls that it is considered to be reasonable for those polls to make it to age 60. But again, it's statistical data for the company, meaning an asset that was put in 1931, approximately $531,000 of those dollars have made it to age 60. Does that help?
I think so. Let me ask you this then. Whether it's a square or a circle or a triangle, in essence, what those are, it's the cumulative representation of the company's data for that particular period of units or whatever it is. And go ahead.
Sorry, I was going to say, yeah, that is correct. That the squares represent the entire history, which is 1931 to 2018. The triangles relate to transactions that have occurred from 1969 to 2018 related to assets that were put in service in 1931 to 2018. And then the circles represent the last 20 years worth of transactional data, 1999 to 2018, related to all assets that were in service from 1931 to 2018. And that's part of how you put together an analysis as to determining life cycles, is to do those combinations. And you can see for polls, it's been relatively consistent with the life characteristics because all of those bands are almost right on top of each other. And that's kind of the key thing, is that that's telling me statistical data should be a big driver here, and any additional information that I learned, informed judgment to support the transmission polls should be explained if there's a deviation. And given that this curve shows that at least through age 65 or 70, the history is pretty good in determining what should be done, and the projections going forward, there's nothing that tells me that there would be fewer retirements on these assets so that they would live for an additional 80 years beyond 70. It would only be that they would be expected to live another maybe 30 years at most.
Okay. Then these data points, this historical data that's plotted here, it's not necessarily the cumulative systems that just quit working. But the data, as far as the retirement of life, was still kind of developed subjectively based on opinion and experience, or when they failed.
No, the actual data is specific to Dominion Energy South Carolina assets. So if we are looking at the accumulation of data, we can see that, again, an asset that was put in 1931, if it's still in service today, then it would be representing one of the points down at the bottom at age 70. because, that's, or age, 77 would be the longest that we would have a point for. If there was an asset that is in 1950 and it's still in service, then that would represent the point at 68, and also anything older than that that's made it that far. So a life table represents exposures and the retirements as a percentage of those exposures. So it's hard to specifically identify a specific asset in each of these, but what it does represent is all of the assets for Dominion Energy South Carolina and how long they've stayed in service to date, regardless of their reason for retirement. It just takes into consideration factual data, and then the job of the depreciation analyst is to estimate whether that is reasonable going forward when you incorporate all the informed judgment of the assets. When you go look at the assets, you understand whether assets that were put in 1930, are they the same as assets put in 2018, or are they different? And if they are different, how will they stay in service differently? Do they have the same forces of retirement that would affect that curve? And what I'm showing here with my 53S1 type curve is I anticipate that the life characteristics for transmission poles should remain relatively stable from what we've seen in the past, and that the future of those assets should experience similar levels of retirement, so that we should see the curve going to around 0% surviving around age 100. And that's what that smooth curve says. So that gets translated into the recovery pattern of those assets being consistent with the utilization of those assets and its projection, and that's where we get our calculation and our rate. The other curve you see there is reflecting the fact that once an asset gets to 60, we're going to stop retiring them, and it's going to be able to last for 90 more years, regardless of wear and tear, technological obsolescence, upgrades of data. That's just not reasonable, and that's kind of the distinction of the two curves, which is why we show them on the chart.
Okay, so what you're saying is that the 59-L 1.5 curve was, I guess, mathematically done. In other words, projecting through the slope of the curve what rates would be, and the 53S1 that you prefer, these data points, if you, I guess, normalize it or try to best fit or whatever, comes closer to fitting the 53-S1 with the data points entered. Now, again, it's my understanding these data points are specific to DESC, and the life of these, or these experience placements or whatever, it's not when it just dies, quits working, but it is still this subjective thing that, hey, this is going to be the determined life on it based on the way we do our stuff. Is that true or false?
I think you hit pretty much all the key components. I just want to kind of clarify a couple things, if I could, from your statement to make sure it's clear. First, on the 59L1.5, the statistical math or mathematical comparison, the reason why that's utilized is because the analysis was stopped at age 54, and that's when it was then extrapolated, saying that from age 54 to age 150, that's the curve we use. So that's a slight distinction from what you were saying as far as the full curve. My analysis takes into consideration the full curve and then matches all those points down to age 65 and incorporates what I expect to happen going forward, which is the rest of the curve. So the 53S1 is not only a reflection of what statistically has happened, but it's also a reflection of what I anticipate happening with those assets based on all the extra subjective information that I've obtained from doing work for the company over the last 20 plus years and being involved in the industry. So that's kind of my extrapolation of information beyond the historical data just for DESC.
Thank you. A couple more things, and I'll quit. The AMI, I've heard that mentioned a few times, and I wasn't sure I totally understand it. The AMI system, the metering system they're putting in, is the life of that however they're doing it, is that through 2028? Is that 7 to 8 years? Is that what the ESC is using?
That's a good question, because the way this is set up is needs clarification. The assets that are being replaced with the new AMI were expected to go and were agreed upon to go stay in service through 2028. However, the replacement to install the new AMI assets will be done a few years earlier than that, which is probably 2025 or so. So what has been done in the calculation is that since we know those assets will have a different life cycle, we've determined the recovery, and this is through an agreement prior to the case, that the recovery of these older assets that are being replaced by AMI will happen through 2028, even though most of them will be out of service by 2025, because that was what was originally agreed upon as the program. And then the new AMI assets will have the 15-year life cycle, which is how we're making sure that those get recovered over their useful life.
That kind of answers that then. So the AMI system will have a life expectancy of 15 years.
An average life of 15 years, that's correct.
And I assume this system, rather than have batteries, is probably wired directly to the power source since they have a good power source. And the data information's transmitted directly to wherever, the office or whatever. So meter reading will pretty much be done at the office.
The concept is, yes, you can have communication back and forth so that the drive-by meter reading will not be, where you have to stop and do all this specifically. That will be gone, and you'll have a more remote reads of that information. There will be a battery as part of the component, but that's I don't think that's the focus of what your question was, but it's the fact that, yes, this information will go back to headquarters, and you'll get that recording of information in a much simpler fashion than what was done when the meter readers were going out and manually checking this information.
Actually, that battery question actually was kind of part of it, because I was familiar with system that we were working toward, radio read, drive-by read it, and then go into AMI. We would have to use batteries. The meters themselves, we had a life probably of about 20 years. But the transponder, the data sending, radio sending unit, the battery life at that time was about 10 years. So I didn't know if that was part of this or if it was direct power to it, or what the life of the battery was if it had a battery.
Well, you've kind of actually hit on some good points. I think, at least it sounds to me, I won't put words in your mouth, but it sounds to me that you were kind of explaining what's going on a little bit in the water and wastewater industry on how that's a slightly different perspective than what's in the electric industry. But in general, the concept you laid out is correct. And most of these smart meters will have a battery component that's intended to be one of the forces of retirement, not the only force of retirement, but the expectation is with the types of AMI components that are going in, that they'll have an average life of 15 years. And that is also part of what will happen with that component of the AMI itself. The meter and its component will have a life, as I've selected here, in the 22-year average. So you've kind of got a mix between the meter itself. In some cases, you can retrofit the module, the smart module or AMI module, onto those meters, and other times you have an installed asset that is just off of that 15-year life. And the battery life is one of the components for life expectancy.
Good enough. That answers the question on the 15 years, and our experience was the technology changes way before that anyway. But thank you very much.
Yeah, that's right. Thank you.
Commissioners. Redirect.
Good afternoon, Mr. Spanos. The example that Commissioner Caston was referring you to, I think that was on page 22 of 51 in your rebuttal testimony. Would you turn there, please?
Yes, I am there. Thank you.
So would it be correct that if you look, this exhibit reflects the entire life cycle for this particular asset class? Is that correct?
Yes. The legend, the squares, triangles, and circles represent the life cycle that we have experienced, or Dominion Energy South Carolina has experienced to date. So that goes from 0% surviving to approximately 18% surviving. So there is a portion of that life cycle that's not defined yet. And because they have just not gone to that entire point where all of the beginning assets have been retired. So you need to close the loop in the life cycle by determining or extrapolating what you anticipate to happen from age 70 to the end of life. And the smooth curve does that. It then extrapolates and includes the entire life cycle of transmission poles in this case. And that takes it out. If you use the 53S1 curve, it takes that entire life cycle out to 100. And that's the expectation, that transmission poles can last through 100 years, and by properly matching that recovery with utilization, that depreciation expense will be allocated over a 100-year period of time, with the average being 53. So that's what's being done with my curve. Obviously, as you can see from ORS, they have a different interpretation, and the life cycle that ORS has anticipated is once it gets to 60, we're going to slow down retirements, and whatever's remaining is going to last up to 90 more years. And that's the discrepancy that we have in this particular case, is that although the averages are not very different, the overall life cycle is very different, and then recovery of the assets would be not matching expected utilization, and that's why there's quite a difference. But the life cycle itself is that smooth curve until it gets all the way to age 0, or excuse me, %0 surviving.
For this particular account, did you find that 150-year estimate was unreasonable?
Yes, for two primary reasons. First, transmission poles and fixtures are major for getting electricity from generation to the distribution substations, and that's the only way you can get power to the customers, is to go through that process, and they have to be reliable and serve and have quality service because of that. So to anticipate that once these assets get to 60 years old, that they won't have any forces of retirement and can stay reliable and provide quality service to 150 years of age, to me is very risky, and I wouldn't want to, you know, if I was a customer, I wouldn't want to be relying on assets lasting that long to serve me, and that's why the 59 L1.5 type curve is not a reasonable interpretation of the life cycle of transmission poles when you take into consideration all of the forces of retirement, all of the reasons for replacement, and you know, haven't even talked about upgrades to voltage or types of assets that would affect those life cycles. So those are some of the key reasons why I don't view a 59 L1.5 to be reasonable when considering the utilization of these assets.
And I want to talk about this for just a second. On this particular chart, I think you mentioned to Commissioner Caston that Mr. Garrett had cut off his chart and his analysis. Do I recall correctly at age 54?
Yes. One of the things that Mr. David Garrett has expressed in his testimony and part of his practice is a primary, if not sole, issue for him is to do a statistical analysis and to utilize that mathematical calculation as his primary focus. And one of the things that he does in doing that is looks at a 1% threshold. Well, the exposures hit to 1% around age 54, so he's ignored the last 13 years worth of historical data and done his mathematical curve fitting, which is his primary and really, in my opinion, only way of looking at this analysis, and said, okay, if I only focus through age 54, then a 59 L1.5 type curve fits those first 54 points just nicely, but ignores everything else and doesn't include reasonable judgment as to what's going to happen in the future. And that's kind of a distinction that why authoritative texts say don't be ensnared by the mathematical calculations only, because this is what would happen if you do that and you analyze it without considering the type of asset and the life cycle of that asset.
So if we looked at Mr. Garrett's chart for this particular asset class, essentially the bottom half of the chart that you have displayed here on page 22 would not be included for the chart that he included in his testimony. Is that correct?
Yeah, the analysis in his testimony is cut off really at the whole second half, and that's the manner in which he presents it, and in this particular scenario takes away the importance of the entire life cycle and why a chart should reflect the entire life cycle, and his does not, and in turn takes away from how he is attempting to match asset utilization with asset recovery. And this is a key piece of the analysis that needs to be included because it misrepresents what's going to happen with these particular assets.
By cutting off his chart and analysis, or looking now at this page 22, for the bottom half, does he basically ignore factually substantial historical data that you collected from your work with DESC that you presented in your testimony?
Mr. Chairman, this is Alex Knowles with ORS. We're going to object. I think we've been pretty patient, and I think at this point Mr. Willoughby is starting to get far afield of the questions that were asked on by the commissioners, and we're starting to get just having Mr. Spano's comment on Mr. Garrett's testimony.
Mr. Chairman, may I respond?
Yes, sir.
These questions go directly to Mr. Caston's, Commissioner Caston's testimony. And Mr. Spanos commented on the differential between his analysis and Mr. Garrett's analysis. In fact, the chart here has both analysis there, ORS, which is referring to Mr. Garrett, and then Mr. Spanos. And the point is he's juxtaposed those two analyses, and he should be able to explain why Mr. Garrett's analysis is deficient, since it does not consider all of the data that has been collected that is data specific to DESC. And I only have 2 or 3 more questions on this point, and I'll be done, Mr. Chairman.
All right, please proceed. Objection overruled.
Thank you very much. Mr. Garrett, so would it be true that, Mr. Spanos, would it be true that Mr. Garrett then, in his analysis, where he cuts off his charts and his analysis, basically ignores a factually specific data to DESC that you included in your work?
For this particular account, yes, I feel as though the last 13 years of historical data for DESC was ignored in Mr. Garrett's analysis, and his extrapolation of the historical data aside from that is quite different than what is expected. And if you only do a mathematical calculation and don't focus on all of the appropriate points in doing that analysis, and don't have any informed judgment as to what's going on in the industry and expectations of the asset itself, particularly for this company, your extrapolations are flawed, and in this case, ignoring part of the data made it even more of an issue for me. So that's why I've disagreed with him, and why I thought it important to explain this particular account, because it was pretty straightforward as to the isolation of the data, ignoring the last 13 points, which is, if he's doing a statistical analysis, that should be a focus. And he took that out, and in turn did not properly analyze this particular account's life characteristics.
Would it be true that his analysis, if we look at all of the other accounts that you've reviewed in your rebuttal testimony, would it be true that his work has the same deficiency for the other accounts as well?
I think there are similar deficiencies in each case. I think, as I expressed for the street lighting account in my summary and was discussed at that point, that has components such as what's going to happen. So his thoughts are, he loses informed judgment based on what's going to happen with the company. And those are the things you learn from, one, conducting studies for the company for 20 plus years, but more importantly, by asking the specific questions and being able to extrapolate the data properly, and using all of the authoritative text reasoning to do so. So in this particular case for 355, excluding data was a problem. There's a few others that excluding data created issues, and then there was a few others it was not incorporating all of the information available to understand the proper life cycle of the account. So there's a few scenarios that come into play, and if you don't look at the right data and ask the right questions, it makes it hard to understand the life cycles of these asset classes.
Thank you very much, Mr. Spanos. Mr. Chairman, those are all my redirect questions, and I would ask that Mr. Spanos be excused.
Chairman Williams.
Commissioner Caston?
Before, I know you're ready to go, Mr. Spanos, but listening to the conversation, first of all, I know nothing about how these curves were developed by Iowa State and whomever before that. But I think I heard or understood, and I well could be wrong, that these curves were developed, I guess, through empirical data, history, whatever, and And are you telling me that on like 53-S1, they had some devices that lasted to 100 years, and 53-S1, they had some that lasted 140, and that's why the shape of the curve is that way? Or is it in the engineering world, we have curves all the time, pump curves and such as that. And on occasion, you get the slope of the curve from this empirical data, whatever you have, and it can literally go down to where it never touches the line. It goes off into infinity. So I know we have nothing that lasts to infinity except what God allows. Other than that, what are we... I'm kind of confused on the 100 and 140 year thing. Are you saying these curves were developed based on something, a data point that they put at 140 years or 100 years?
No. The key, first of all, there are no transmission poles and fixtures for Dominion Energy South Carolina that have reached 100 years yet. Okay, so I want to make sure that's clear. And that's why these squares, triangles, and circles don't go to 100 on the x-axis. So what that requires is that we need to determine what is the oldest that we would expect transmission poles to stay in service based so that when they get to a certain age, we matched the utilization of those assets to the recovery of those assets. And when you put the 53-S1 curve on there, I am suggesting that nothing on a transmission pole will last longer than 100 years, which is why that smooth curve goes to 100. You can see when it hits age 100, percent surviving is 0. Now, in the same fashion, the 59L1.5 type curve, again, we know that no poles have made it beyond 70 at this point. But this particular curve says that these assets will make it to 150 years before they're all gone. And I say 150, I know the far right edge is 140, but if you really look closely, it overlaps about 10 more years on the left corner. So that's why I say 150. So what that means is that the 59L1.5 curve is going to assume that transmission poles can stay in service as long as 150 years before no more of them will be able to be utilized in plant and service. And I'm saying that is not reasonable. I cannot see any scenario that Dominion Energy South Carolina or any other utility would be comfortable keeping a pole 150 years and still be reliable. And that's why I don't view this particular option that ORS has presented to be reasonable, because again, these curves mean you have to match recovery to utilization. So the smooth curve represents recovery, and that means utilization is that these assets that have only made it to 70 so far, and there is 18% left, that 18% is going to go for another 80 years. That doesn't make sense to me, and that's where I have a difference in what ORS has presented.
I understand exactly what you're saying as far as the data points, the closest matching the curve. I understand that. And again, I don't have a preference one curve over another. I was simply just thinking in terms of, in my experience, the different curves we've used, developed, that have been empirically set up. And the thing about the years, 140, 100, I struggle with that, but I do fully understand that basically you're just trying to get the best fit match for the particular curve. And I think that's what you're saying. So I understand that, but again, I think all these curves, me knowing nothing about them, were probably developed like many other curves. It's just best fit, and it's using data points, and you just project it on out. I'm not sure that it's probably realistic for anyone to think some unit's going to last X time. You're just trying to match a curve or come close to matching it, correct? Trying to get the best fit.
I mean, obviously, my judgment is to try to incorporate how these curves make sense. And depreciation expense is based on these curves. And if you stretch it out too far, that's unrealistic, your depreciation rate's going to be too low and you'll have stranded cost, and that doesn't make sense. So the shape of the curve and its life cycle is critical for determining a depreciation rate and, again, matching the recovery with the utilization of the asset. And I know I keep saying that concept, but that's really what I hope hits home, is that there's nothing that will tell us that transmission poles should stop being retired when they hit 60 and slowly get replaced up until age 150 and still be something a utility can rely on. And that's what I'm trying to say, is that's what ORS is saying to you, is these poles have an average life of 59, but when it gets to 60, we're going to slow them down and keep them in service for another 90 years possibly, and we need to view that as something Dominion Energy South Carolina can be comfortable with, and its customers. And that's what I'm trying to say, that's not reasonable with how you utilize these curves and depreciation expense and coming up with the appropriate recovery pattern. I don't want to get into a situation where these assets are being misrepresented going forward and the company doesn't have the opportunity to replace them when they're no longer reliable and offering quality service. And I think that's what we're trying to avoid here.
I understand. Thank you so much, Mr. Spanos.
Thank you.
Any other questions for this witness?
I have no additional questions, Mr. Chairman.
All right. This witness may step down from the witness stand and be excused.
Thank you. Appreciate your time.
Thank you, Mr. Spanos, and thank you, Mr. Chairman.
Please call your next witness.
Thank you very much, Mr. Chairman. We would next call to the witness stand Mr. Casey Kofer.
Hello, can you hear me?
Good afternoon, Mr. Kofer.
Good afternoon.
Welcome. Would you prepare for the court reporter to swear you in?
Yes, I will.
If you would raise your right hand, please. Hold on just a second. Okay. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much.
Mr. Kofer, please state your name for the record.
Keith C. Kofer, Jr.
And by whom are you employed and in what capacity?
I am employed by Dominion Energy Services, Inc., and I serve as the controller of Dominion Energy South Carolina, Inc.
In connection with this proceeding, Mr. Kofer, did you prepare and cause to be pre-filed the direct testimony consisting of 29 pages?
Yes, I did.
Are there any corrections or changes to be made to that pre-filed direct testimony?
Yes, sir, there are. I'll direct your attention.
Yep. Would you direct our attention to where?
Yes, sir. I'll direct your attention to page 26 of my direct testimony, on line 19, after the word inventory, insert the words "and preliminary survey and investigation cost." Then on line 21, change the word "this" to "the," strike the words "equipment and," then after the word "inventory," insert the words "and the preliminary survey and investigation account."
Are there any other corrections or changes?
No, sir, they're not.
And I would state, Mr. Chairman, for the court reporter, we will send to her a printed copy of the direct testimony showing the red line changes and then a clean copy as well. But with the changes that you've just given us, Mr. Kofer, if I asked you the questions that appear in the pre-filed testimony as corrected, would your answers today from the stand be the same?
Yes, sir, they would.
Mr. Chairman, I would move the pre-filed direct testimony of Mr. Kofer as just corrected into the record as if given orally from the stand.
The corrected version of Mr. Kofer's pre-filed direct testimony will be entered into the record as if given orally from the stand.
And attached to your pre-filed direct testimony, Mr. Kofer, I believe were 7 exhibits. Is that correct?
That is correct.
Are there any corrections or changes to be made to the exhibits?
No, there are not.
Mr. Chairman, we would move as the next hearing exhibit the 7 exhibits attached to Mr. Kofer's pre-filed direct testimony as corrected.
7 exhibits attached to Mr. Kofer's pre-filed corrected direct testimony will be marked and entered into the record as a composite exhibit as hearing exhibit 33.
Thank you, Mr. Chairman. Mr. Kofer, have you prepared a summary of your pre-filed direct testimony?
Yes, I have.
Please deliver that at this time. And Mr. Chairman, I'm going to try yet again to see if this technology, if I live up to my claim, and at some point in the summary, I'm going to show one of Mr. Kofer's exhibits. Again, Mr. Kofer.
Good afternoon, Chairman Williams and members of the Commission. In its application in this proceeding, which it supplemented at the request of the hearing officer, the company included several exhibits containing financial information related to its request for rate adjustments. In my pre-filed direct testimony, I sponsor and discuss those exhibits and provide other accounting and financial information in support of the application. I also provide testimony regarding the company's request to amortize the carrying value of Kennedy's Units 2 and 3 at the level of depreciation expense being recorded at the time those units were retired. The books and records of the company are maintained in accordance with accounting principles generally accepted in the United States and in accordance with the Uniform System of Accounts for Major Utilities as prescribed by the Federal Energy Regulatory Commission, or FERC. This Uniform System of Accounts has been adopted by the Commission and is followed by the major utilities subject to its jurisdiction. In order to ensure complete and accurate books and records, the company maintains and relies upon an extensive system of internal accounting controls, audits by both internal and external auditors, and financial oversight by the Board of Directors. In my pre-filed direct testimony, I sponsor 8 exhibits, KCC 1 to KCC 7, all of which are also exhibits to the application, plus KCC 2 supplemental, which was submitted at the request of the hearing officer. These exhibits, which are more fully described in my direct testimony, demonstrate the calculation of DESC's rate of return in the test year, as well as its calculated rate of return based on the proposed rate increase. KCC 2 supplemental provides information on a retail electric basis. I also sponsor an exhibit providing the Commission with calculations detailing DESC's proposed revenue requirement supporting the requested rates. Finally, I sponsor an exhibit identifying the company's requested pro forma and accounting adjustments, and I provide a discussion of many of those individual adjustments. As shown by these exhibits, the company earned a return on equity of 5.90% during the test period, which reflects deferred costs such as storm costs, cybersecurity costs, and other deferrals and adjustments that the company is seeking to recover in this application, as compared to the 7.51% return on equity reported in the company's most recent quarterly monitoring report, which does not include these deferrals and adjustments. Therefore, both the 5.90% and the 7.51% are accurate in their proper context and are both significantly below the 10.25% return on equity currently authorized by the Commission. I also explained in my direct testimony that the company completed its retirement of Kennedy Station with the removal from service of Units 2 and 3 at that site. In Order Number 2013-649, the Commission authorized the company to account for its investment in, as well as the cost incurred related to the retirement of, those units as an unrecovered plant regulatory asset, to be amortized at the level of depreciation expense, $12.3 million annually, being recorded before the retirement. The company requests that the Commission affirm the treatment implemented pursuant to Order Number 2013-649 and affirm the company's treatment of the unrecovered investment as part of its rate base and its continued amortization of that unrecovered investment at the same level of depreciation expense authorized in Order Number 2013-649. This concludes the summary of my direct testimony.
Thank you very much, Mr. Kofer. Did you also prepare in this case a rebuttal testimony consisting of 18 pages?
Yes, I did.
Are there any corrections or changes to be made to this rebuttal testimony?
No, there are not.
If I asked you the questions that appear in the rebuttal testimony, would your answers from the stand today be the same?
Yes, they would.
Mr. Chairman, I would move into the record, as if given orally from the stand, the pre-filed rebuttal testimony of Mr. Kofer.
The pre-filed rebuttal testimony of Mr. Kofer will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Kofer, did you also have one exhibit attached to your pre-filed rebuttal testimony?
Yes, I did.
Are there any corrections or changes to be made to it?
No, there are not.
Mr. Chairman, we would move into the record as the next hearing exhibit, the one exhibit attached to Mr. Kofer's pre-filed rebuttal testimony.
The exhibit attached to Mr. Kofer's pre-filed rebuttal testimony will be marked and entered into the record as hearing Exhibit 34.
Thank you, Mr. Chairman. Mr. Kofer, have you prepared a summary of your rebuttal testimony?
Yes, sir.
Please deliver that at this time.
In my rebuttal testimony, I respond to certain matters raised in the testimony of witnesses filed on behalf of the Office of Regulatory Staff, or ORS, and in the testimony of Mr. Mark E. Garrett, filed on behalf of the United States Department of Defense and all other federal executive agencies, the DoD FEA, related to certain accounting adjustments and other matters. ORS witness Bickley recommends that the storm damage rider regulatory liability account earn carrying costs while also including the balance in rate base. I explained that the company's proposal establishes a regulatory liability for amounts collected through the rider that have not been utilized to offset incremental storm restoration costs and establishes a regulatory asset for storm restoration costs incurred in excess of rider recoveries, with the regulatory liability or asset serving to decrease or increase rate base, respectively. I explained that allowing carrying costs on the regulatory liability while including it as part of rate base effectively credits customers twice for the cost of capital associated with the collections. I note that the company's position is that the regulatory liability and asset account should be included in rate base without additional carrying costs. However, if carrying costs will be added, the regulatory liability or asset balances should be excluded from rate base in order to avoid duplicating the credit to customers or recovery by the company. I further recommend that if the ORS carrying cost proposal is adopted, that the Commission clarify that the carrying costs would apply to both over-collected and under-collected balances and be recorded using the company's embedded cost of long-term debt rate. DoD FEA witness Garrett recommends that the recovery of the unrecovered plant balance related to the retirement of Kennedy's Units 2 and 3 be extended to 40 years. I explained that Mr. Garrett's proposal is significantly more expensive for customers. I'm sorry, I was getting feedback. Can I continue?
Please continue.
Okay. I explained that Mr. Garrett's proposal is significantly more expensive for customers because the slower amortization of the asset balance results in a return on a higher rate base over a longer period of time. DoD FEA witness Garrett also contends that the company's proposed major maintenance accrual adjustment should be reduced. Mr. Garrett agrees that the accrual should be increased over the test year amount and that it should include the additional maintenance costs attributable to the Columbia Energy Center. However, he recommends a reduction in the company's proposed increase, which does not consider almost $2 million in carrying costs and does not fully incorporate the projected major maintenance costs for the rest of the company's units subject to the accrual. If Mr. Garrett's proposal is adopted, and assuming that maintenance costs are in line with the company's projections, the company estimates that it will be undercollected by approximately $39 million at the end of the 8-year operating cycle ending December 31st, 2028. I further note that the company is seeking to renegotiate certain long-term maintenance contracts, which could result in a reduction of its maintenance costs, which, if realized, would be captured in the maintenance accrual regulatory asset or liability for the benefit of customers in the next accrual update. ORS and DoD FEA propose extending the amortization periods for certain regulatory assets beyond the periods proposed by the company. However, the amortization periods proposed by the company more closely align with the periods over which the regulatory assets were accumulated and therefore are more appropriate in the company's opinion. I further note that the company believes the amortization of certain items should be treated as operation and maintenance expense, rather than depreciation and amortization as proposed by ORS witness Brazino, although the company has no objection to excluding the amortizations from the calculation of working capital. ORS witness Brazino and Cullen recommend changes in the balances used to establish amortization amounts for the transmission cost deferral, the critical infrastructure protection cost deferral, and the VCS cybersecurity deferral to the account balance as of May 31st, 2020, excluding projections. The company used projections as of February 2021 to more accurately reflect the deferred balance to be recovered and therefore serve as the most accurate basis for determining the appropriate amortization amount. Moreover, these projections are limited to carrying costs and for the transmission cost deferral, depreciation, property taxes, and carrying costs, all of which can be reasonably estimated. If the Commission determines that the amortization amount should be based on the account balance as of May 31st, 2020, the company respectfully requests that the amortization amount remain in effect until the entire account balance is recovered. ORS witness Brazino recommended an adjustment to the company's proposed pro forma adjustment establishing a vegetation management accrual, which I addressed in rebuttal testimony. In his rebuttal testimony, Mr. Brazino states that ORS has accepted the company's proposed adjustment based on clarification provided in rebuttal testimony and further information provided by the company in response to an additional discovery request on this matter. Finally, I note that the absence of testimony rebutting a particular adjustment or proposal does not constitute the company's agreement with or acceptance of that adjustment or proposal. This concludes the summary of my rebuttal testimony.
Thank you, Mr. Kofer. Mr. Kofer, you're one of the lucky ones, and that you have some supplemental testimony. Is that correct?
That is correct.
And I believe your supplemental testimony consists of 2 pages. Is that correct?
That is correct.
Are there any corrections or changes to be made to the supplemental testimony?
No, they're not. I'm verifying the page count on the supplemental testimony. I believe the supplemental testimony was actually 3 pages.
You are absolutely correct. I misspoke, and I'm sorry for that. I've been corrected. They've been corrected here. Let me get my video back on. So there are 3 typewritten pages. Are there any corrections to those 3 typewritten pages of your supplemental testimony?
No, they're not.
If I asked you the questions that appear in that supplemental testimony, would your answers from the stand today be the same?
Yes, they would.
Mr. Chairman, we would move the introduction of Mr. Kofer's pre-filed supplemental testimony into the record as if given orally from the stand.
Mr. Kofer's pre-filed supplemental testimony will be entered into the record as if given orally from the stand.
Thank you very much, Mr. Chairman. And as I recall, Mr. Kofer, there are no exhibits attached to your supplemental testimony. Is that correct?
That is correct.
Do you have a brief summary of your supplemental testimony?
I do.
Please deliver that at this time.
Certainly. In my supplemental testimony, I acknowledge the company's agreement with certain pro forma adjustment updates reflected in ORS Witness Sullivan's Sir Rebuttal Exhibit DFS-9. In addition, I provide information regarding certain changes that became effective January 1st, 2021 as part of the integration into Dominion Energy. During the discovery process, the company responded to numerous requests for information from ORS and other intervening parties. The company provided full and transparent responses to those requests. As a result of developing and providing these discovery responses, the company identified updates or corrections to certain pro forma adjustments contained in its application. The details of these updates were provided to ORS. ORS Witness Sullivan reflected the updated retail electric operating experience for these adjustments in exhibit number DFS-9, which was submitted as part of his Sir Rebuttal testimony. The company has reviewed and agrees with the updates for these adjustments as reflected in exhibit number DFS-9. Further, I explained that services company activity transitioned to Dominion Energy Services on January 1st, 2021. As a result, employees who were employed by Dominion Energy Southeast Services became Dominion Energy Services employees on January 1st, 2021, and, with certain exceptions, Dominion Energy Services acquired the assets and liabilities of Dominion Energy Southeast Services. I also explained that beginning with 2021 business activity, the company has converted from its PeopleSoft Enterprise Software Suite to the SAP Enterprise Software Suite used by Dominion Energy, and that this conversion required the company to change its primary trial balance chart of accounts from the FERC-based accounts historically used by the company to the chart of accounts used by Dominion Energy. However, I explained that the FERC Uniform System of Accounts will still be used for regulatory reporting purposes. This concludes the summary of my supplemental testimony.
Thank you very much, Mr. Kofer. Mr. Chairman, Mr. Kofer is available for questions from the parties and from the Commission.
AARP.
Your Honor, AARP has no questions.
Walmart Incorporated.
Mr. Chairman, Walmart has no cross-examination for this witness.
Sierra Club.
Dorothy Jaffe for Sierra Club. We have no questions for this witness. Thank you.
United States Department of Defense, and all other federal executive agencies.
Good afternoon, Mr. Chairman. Emily Medlin for DoD FEA. We have no questions.
Frank Knapp, Jr.,
I have no questions, Mr. Chairman.
South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
I guess, Mr. Chairman, this is Kate Mixon. States and CCL have no questions.
South Carolina Energy Users Committee.
Yes, sir, Mr. Chairman. I have a few questions. Thank you.
Please proceed, sir. Attorney Elliott.
Yes, sir. I will not get the Mitch Willoughby Technology Award this year. I'm trying to get my photo up. Thank you. Is it Mr. Cofer? I'm terrible with names. Pronounce your last name, please. I do not mean to mispronounce it.
No, you have it correct, Mr. Elliott. It's Mr. Cofer, and I do appreciate it. It's commonly mispronounced as Cofer. It's the misspelling with the two F's, I guess. You have it right.
Well, I apologize in advance. There's no telling what I'll call you throughout this. What I hope is a relatively short conversation. I would like to ask you to help me understand a few financial concepts in your application.
Yes, sir.
I will tell you that I am from the old school of law practice, where when I began practicing law, the only math a lawyer needed to know was how to divide by a third. And so these numbers that I'm going to ask you about are difficult for me to understand. So if you'll bear with me. And I'd like to use as a frame of reference for my questioning your first exhibit, KCC1, and it is labeled Dominion Energy South Carolina, Inc., Condensed Consolidated Regulatory Basis Balance Sheet as of December 31, 2019.
All right, yes, sir.
You may have, I'm sure you're quite familiar with it, but I would draw your attention first, if I may, to page 23 of that document.
All right, yes, sir.
And I'd like to ask you just a few questions about the unprotected excess deferred income tax, or EDIT, if I may.
Yes, sir.
Now, as I understand it from Ms. Griffin's testimony, the total unprotected EDIT is $120,840,000. Does that sound correct to you?
That sounds correct from what I recall from Ms. Griffin's testimony. Yes, sir.
All right, and then you've got a paragraph about halfway down that page. It begins, the company has recorded an estimate of excess deferred income tax, EDIT, authorization in 2019 and estimates of amounts probable of collection from or return to customers. Do you see that sentence?
Yes, sir, I see the sentence.
Excellent. Now, what I'd like to know is, have I overlooked in this section of Exhibit KCC1, have I overlooked a number for the unprotected EDIT of something in the neighborhood of $120 million?
Attorney Elliott?
Yes, sir?
I hate to interrupt you. We're having trouble hearing you in the hearing room. Could you speak into your headset?
Yeah. I will. I turned up the volume on this handset. If that doesn't help, I'll pick up the phone.
That's a lot better.
Am I a little louder? I turned up the volume.
Yes.
Thank you. Mr. Cofer, am I correct that there's nowhere in this exhibit, and we're focused on the section pertaining to excess deferred income tax, is there nowhere where the exhibit reflects the amount of approximately $121 million in unprotected EDIT?
I do not see that number on here, no, sir.
All right, and in that regard, there are some calculations just below that that paragraph, and it's labeled in bold, excess deferred income tax electric, and it purports to calculate, and again, I'm focused on the unprotected EDIT, but I can't make any of those calculations come out to $121 million. Do those numbers reflected there at the bottom of page 23 of KCC1, do they reflect the calculation of some other value?
Yeah, and Mr. Elliott, I am going to have to defer to Company Witness Milwaukee to walk you through the excess deferred income tax balances. I just don't think I would be able to efficiently answer your questions on what's embedded in these on the excess deferred income taxes, and she would be probably best suited to do that.
And are you comfortable that Witness Noraki, I may have butchered that, would be familiar with the condensed consolidated regulatory basis balance sheet?
Well, I can't speak completely for her, but I know her group is familiar with the with this disclosure in this document. Yes, sir.
All right. You'll forgive me if I assumed that you would be familiar with it since you sponsored it as an exhibit, won't you?
Yes, sir.
All right. And I also notice, again, referring you back to this paragraph that I began this line of questioning with, the condensed consolidated regulatory basis balance sheet reflects the intended period of time to credit this $121 million back to customers was 50 years. Is that correct?
Say again, please, where you were, the paragraph you were starting with?
Sure. Let me draw your attention to the paragraph immediately above this headline, Excess Deferred Income Tax Electric. And if you come up 5 lines, on the left-hand margin, the line begins relate, and then I would in particular draw your attention to the sentence, these reversal periods average 50 years. Do you see that language?
Yes, I do.
All right, and do I correctly understand that language to mean that when the application was filed in this case, it was Dominion's intention to credit the $121 million in unprotected EDIT back to customers over 50 years?
I believe that number also includes protected and unprotected balances, and this is an average of 50 years. So that's this is an average of 50 years.
All right, I'll accept average of 50 years. Thank you. Now, I believe I understood Mr. Blevins in his summary of his testimony to tell the commission that the company would be prepared to refund the unprotected EDIT back to customers more quickly than an average of 50 years. Did you understand him to testify to that, sir?
Yes, sir.
All right, and so you would understand that the Office of Regulatory Staff has recommended a period of 5 years in which the company might refund the unprotected EDIT balance of $120 million, don't you?
I know that they had proposed a different period, and I believe it was 5 years, subject to verification.
All right, sir. And if the commission were to accept Mr. Blevins' offer to use the unprotected EDIT in the amount of $121 million to lower customer bills, it could do so over a period of 5 years or a period even shorter than 5 years, could it not?
Yes, sir. I want to be very careful here because I am not the tax expert. Ms. Naraki is, but it is my understanding that it is within the Commission's discretion to authorize a shorter period of amortization of the unprotected EDIT.
All right, sir. And just for the sake of simplicity, if we assume, for the sake of this question, that the Commission were to choose to give the customers all $121 million of the unprotected EDIT back at one time, that amount of credit to revenue would substantially reduce the rate increase in this case, wouldn't it?
Again, I want to be very careful here because I am not a tax expert, so I do have to be very careful that I don't misspeak. But any acceleration of the EDIT would obviously put. I'll say this: any acceleration of the EDIT amortization beyond the period proposed in the company's application would put downward pressure on the rating.
All right, sir. And then, subject to our tax expert's testimony here later this afternoon, if, for instance, the Commission were to accept the Office of Regulatory Staff revenue requirement of $11 million, and if it were to apply $121 million a credit from this unprotected EDIT to the revenue requirement, the Commission could offer your customers a nice rate decrease during this COVID pandemic, couldn't it?
Again, the flow back, my understanding, again, I do want to be very careful here, Mr. Elliott, but my understanding is that the flow back of the unprotected EDIT could be done at time periods at the discretion of the Commission. But again, subject to verification, because, like I said, I am not a tax expert.
I understand, and nor am I. As between the two of us, I'll defer to your caution. Now, if I may, I'd like to draw your attention to page 42 of 52 of Exhibit KCC1. Again, we're still in this condensed, consolidated regulatory basis balance sheet as of December 31, 2019. And may I invite your attention to that page 42?
I am there.
All right, and in the second full paragraph, the statement reads as follows. Follow along with me, if you would, please, just to keep me straight. The South Carolina Commission order also approved the removal of DESC's investment in certain transmission assets that have not been abandoned from the BLRA capital costs. As of December 31, 2019, such investment in these assets included $345 million within utility plant, net, and $37 million within regulatory assets, which amount represents certain deferred operating costs. Do you see that language, and have I read it correctly?
You have read it correctly.
All right, and so is it your understanding that that the company is seeking recovery of $345 million of these transmission assets that were abandoned from the BLRA in revenue in this rate case?
That is my understanding.
All right, sir. And it is not entirely clear to me what the $345 million consists of. Can you tell me, just in general terms, what components of cost, capital cost or otherwise, are included in the $345 million?
Yes, sir. The $345 million was the capital investment that was in our construction accounts related to the transmission facilities.
All right, sir. Now, so the 345 are basically the construction costs for the Base Load Review Act transmission assets, correct?
That is correct, yes, sir.
All right. Now, I'd like to the $37 million. I want to talk to you about a little bit in a moment, if I may. But I'd like to ask you to tell me if how much AFUDC, or in the vernacular, construction financing costs, are currently in rates associated with the construction of the transmission assets pursuant to the Base Load Review Act?
The amount of revenue requirement on those that would have been the financing costs, I do not know. I do know the total amount of AFUDC that makes up the $345 million, but any amounts that would have been in the revenue related to financing costs, which is different than the AFUDC, I do not know that number.
All right. Well, let's. You may know the number I'm looking for, please. So, of the $345 million in question, how much of that is AFUDC?
It's approximately $20 million, $20.3 million.
Now, this would be $20.3 million in AFUDC that the company has yet to recover from ratepayers, correct?
Yes, sir. That is correct.
But you are aware, Mr. Kofer, are you not, that the company is currently collecting AFUDC from the construction of these transmission assets pursuant to the Base Load Review Act?
I'm not sure. I'm not sure about that statement because we're recovering none of the balance of the 345 that includes the 20 million is currently in rates.
All right, sir. Let me attempt to share a document on my screen and ask you if you can just help me understand it, please. All right. Mr. Kofer.
Yes, sir.
Counsel, are you seeing the a document here on your screen? It is captioned before the Public Service Commission of South Carolina. Docket numbers, I'll read the first one, 2017-207-E, dated December 21, 2018. Do you see that, Mr. Kofer?
Yes, sir, I do.
All right. And for the sake of ease, I have simply attached pages 53 and 54 of that order to be displayed on the screen. And in particular, I draw your attention to a bold headline on that page that reads, Transmission Projects that were part of the BLRA project. Do you see that language?
Yes, sir, I see it.
All right. And I'm not. I'll read the whole thing. I'll read the whole thing because I don't want to appear to mislead. The first paragraph under that headline reads, as part of the project, SCE&G's Transmission Planning Department conducted the generation siting studies required under the Federal Power Act and related FERC orders and undertook a major expansion and strengthening of the backbone of SCE&G's transmission system. The total amount invested was approximately $322 million, and all aspects of the project will be in service as of January 31, 2019. Only the financing cost associated with $275 million in capital is in rates today, which is the equivalent to approximately $32 million in revenue requirement. The return of capital of the entire amount invested and the financing costs of the remaining approximately $47 million is not in rates today. Did I read that paragraph from the order number 2018-804 correctly, Mr. Kofer?
Yes, sir, you read it correctly.
All right. Now, let me just ask you a few questions about this.
Okay.
This order was handed down, as I mentioned, I think, December 21 of 2018, but 2018, and by the very language here, not all of the assets were constructed. But is it fair to is it fair to infer that at least as of the date of the hearing in that 2018 case that only $322 million of the $345 million had been constructed?
I believe that's correct. That would have been the amount that would have been, and let me read this one more time.
Please, yes. Take your time.
I believe that would have been the construction amount as of that date.
Right, and based on your testimony of a moment ago, it would be the case, would it not, that the difference between the $322 million as of let us say December 2018 and the $345 million that you're seeking recovery of in this case would be not only the remaining cost of construction of these transmission assets, but also the $20 million in AFUDC you testified to. Would that be the case?
Well, I would expect that there is a balance of the AFUDC that is in the $322 million. So the $322 million didn't all accumulate between this date and the 345. As a matter of fact, of the total AFUDC of $20.3 million, only about $1.9 million had accumulated after 2017. So I would expect there to be a balance of and probably most of the $20 million in the $322 million.
Okay, good. Thank you. You're being very, very helpful. Now, it says only the financing cost associated with the $275 million in capital is in rates today. And so to your point of a moment ago, would you anticipate that the AFUDC accumulated on the 275 would be, I think the number you mentioned of 18 million or so of the total of 20 million AFUDC that you're requesting in this case?
So there's a lot of numbers there. Can you ask that question one more time, please?
Well, again, I wasn't teasing. My math is historical and limited. We're looking at what I understand that to the order to say is that $275 million was in capital costs as of the financing cost. Excuse me. Only the financing cost associated with $275 million in capital costs was in rates in December of 2018. Correct?
That's the way I read that statement. That is correct. That would be only the financing cost on $275 million of construction.
All right. And so then can we infer then that of the $322 million that the order speaks of, $275 million were in capital costs and the balance would be financing costs?
No, I don't think that would be correct. I think the balance would also be additional construction costs that had accumulated from the time the last BRA rates were set. So whatever time it was set, there would have been $275 million that would have been in construction costs that the company would have been recovering financing costs on. And so that would have been the level of construction on which rates were set to recover financing costs on the $275 million. So I don't believe that. So I don't believe the difference between the 322 and the 275 is purely financing costs. I believe it would be construction costs as well.
Excellent.
It's not obviously it's not all AFUDC.
All right, sir. All right, and that makes perfect sense. Thank you so much. Now, last, the order reads that only the financing cost associated with the $275 million in capital costs is in rates today, which is the equivalent to approximately $32 million in revenue. So, is it not the case that as of December of 2018, Dominion was recovering $32 million in revenue in financing costs on the $275 million?
I believe that would be the case.
All right. Now, so the ratepayers are actually paying $32 million in rates today, even though the capital costs of the transmission assets are not in rates. Is that correct?
The capital costs of the transmission assets are not in rates. That is correct.
All right. And so to be clear, my question was, the capital costs are not in rates, but the ratepayers are paying $32 million in AFUDC costs. Is that correct?
We would have to be very careful to understand how that $32 million may have been incorporated in the ultimate rates that came out of the merger approval order and the establishment of the capital cost rider. And to be honest, I'm just not exactly sure how that $32 million of revenue of financing cost recovery on the 275 was ultimately structured into the capital cost rider and the ultimate rates out of the merger approval order. I'm just not sure.
All right, very fine. Fair enough. Now, let me last draw your attention to page 17 of 52 of your exhibit KCC1. Again, we're still in this condensed consolidated regulatory basis balance sheet.
Okay, yes, sir, I am here.
All right, and I would draw your attention, if I may, to the lower half of the page under the heading Regulatory Assets and Regulatory Liabilities. Do you see that heading?
I see it.
And then there are a list of assets and liabilities, regulatory assets and liabilities underneath that. Do you see those?
Yes, sir.
All right, just a few questions. The first one is NND project costs. Do you see that
Yes,
line?
sir. Yes, sir.
And I think NND stands for New Nuclear Development. Am I correct?
Yes, sir.
And that term was adopted back when new nuclear was a thing. What are the NND project costs of $138 million under 2019, please?
Yes, sir, Mr. Elliott. Okay, so if you look at how this chart is structured, so if you look at that first subtotal, you see where it says current, regulatory assets current.
Yes, sir.
All right. And then if you kind of follow to the top of the next page, you see regulatory assets non-current. So for reporting purposes, we separate...
Gentlemen, I hate to interrupt you, but the witness is referencing pages that are not on the screen.
Well, Mr. Chairman, I was trying to make it so I can reduce my screen, but we are in Mr. Kofer's exhibit KCC1, and we are on page 17 and 18 of page 52 pages there, and I was hoping that perhaps the Commission and Council could follow along from his testimony and exhibits.
Okay, do you mind reducing or removing what you have shared now so we can see you all? All right, please proceed.
Thank you, Mr. Chairman. All right, hold on, Mr. Kofer. And let's perhaps start over. You directed my attention to the total regulatory assets current. It's in about it has a number for 2019 of 270, correct?
That's correct.
And then
if you look, I'm sorry.
Well, I was trying to let the Commission catch up because I think they were having trouble following us. You drew my attention to page 18 of 52 of KCC1, and I lost you.
Right. So then you'll see a subtotal regulatory assets non-current.
And is that 3862, number 3? It's in millions.
Yes, sir.
Yes, I see that.
And that is just to point out that on this table we have our regulatory assets broken out between a current portion, and that is an amount that we expect to recover over the next 12 months, and then a non-current portion. So what this 138, if you take the 138 on page 17 of 52 that you were asking me about, And then if you look right below the 270, you see a 2,503,000,000.
Yes, sir.
You have to add those two together, and that is the balance of the N&D project cost that was approved for recovery in the merger approval order as of December 31st, 2019. So that would be the unamortized balance. I believe it was the 2,768,000,000 that was approved for recovery in that order.
All right, good. So those are the that's the fund created in that 2018 order for the abandoned nuclear cost, correct?
That is the balance. That is the remaining unamortized balance that was approved for recovery in the merger approval order.
And ratepayers are still owe how much when you add 138 and 2503 on that on those abandoned nuclear costs?
Well, now you're going to test my math without a calculator.
I thought you said it. I apologize.
Well, the original amount that was approved for recovery, I believe, was 2,768,000,000.
All right, sir.
Out of the merger approval order.
Now, I will draw your attention to page 18 of 52 of Exhibit KCC1.
Yes, sir.
And the fourth item down is deferred transmission operating costs. Do you see that language?
Yes, I see it.
All right, and the first column is the 2019 column, and it reflects a balance of $37 million. Am I correct?
That is correct.
And does this number represent depreciation and the property tax balance owed on the deferred transmission assets?
That balance would represent, and I believe at that point it was deferred depreciation only on the transmission assessment.
All right, so the $37 million is only depreciation on the $345 million in transmission assets that you're seeking recovery of that were financed pursuant to the BLRA, correct?
That is correct.
Good. You've been very helpful, and I hope that, I apologize if my questions weren't any clearer, but you've been patient and you've been great. Thank you very much.
Department of Consumer Affairs.
No questions, Mr. Chairman. Thank you.
Office of Regulatory Staff.
Thank you, Mr. Chairman. This is Chris Eber. We have just a few questions.
Please proceed.
Good afternoon, Mr. Cofer.
Good afternoon, Mr. Huber.
Of course, there's a dispute between ORS and the company regarding the amortization period for deferrals, correct?
Dispute. There is a different proposal, I would say, for the amortization period for deferrals. Yes, sir, that's correct.
I wanted to ask you a few questions about another issue related to the deferrals. This is regarding the inclusion of projections in the deferral balance amount.
Yes, sir.
On pages 14 to 15 to your rebuttal testimony, you testify regarding the issue of limiting the company's proposed amortization for certain deferrals to the actual account balance as of May 31st, 2020, correct?
I'm flipping to page 14, but I recall that is correct. It was May. Yes, sir. Yes, sir.
And on page 15, you state that if the commission determines that the amortization amount should be based solely on account balances as of May 31st, 2020, as ORS has proposed, the company requests the established amortization remain in effect until the account balance is recovered, correct?
That is correct.
And are you familiar with ORS witness Brasino's rebuttal testimony in this case, in which he states that ORS does not object to that request, provided ORS is allowed the opportunity to review the additional deferral amounts incurred after May 31st, 2020, in a subsequent general rate case.
I am aware of that testimony, yes, sir.
And ORS witness Brasino also requests the same treatment be afforded DES's regulatory liabilities as its regulatory assets, correct?
That is correct.
Does the company have any objection to these two requests by witness Brasino should the commission determine that the amortization amount should be based solely on the account balances as of May 31st, 2020, and that the established amortization should remain in effect until the account balance is recovered?
Should the commission propose or approve that request, I don't believe the company would have an objection to those requests from Mr. Brasino.
Thank you, Mr. Carver. That's all the questions I have.
Yes, sir.
How many commissioner questions do we have?
I just have one.
Vice Chair
Mr.
Belzer.
Chair.
Commissioner Hedden, Commissioner Thomas?
Yes. Did you ask how many questions we had?
Yes, sir. Just trying to poll, I shouldn't say poll, but trying to gauge whether or not we need to take a break or drive through. I know we got Commissioner Thomas, Vice Chair Belzer. Anyone else? Okay, let's just go. Vice Chair Belzer?
Thank you. Good afternoon, Mr. Cofer.
Good afternoon, Commissioner Belzer.
I just wanted to follow up on the questioning from Mr. Elliott, and I'm in your exhibit, KCC1, on your direct testimony on page 18 of 52.
Yes, ma'am, I'm flipping there. Bear with me. All right, I am here. Yes, ma'am.
And my question goes to follows up on his questioning of the deferred transmission operating cost, which is the fourth line down from the top. And then for 2019, the amount is $37 million.
Yes, ma'am.
Okay. And I've thought that he asked you the question, does that include deferred depreciation and property taxes associated with the transmission assets? And I believe your response was only the deferred depreciation. Is that correct?
Yes, ma'am. That's what I said. And I was just looking at the note, and I may have to verify, but I'm not sure. And I see the footnote says includes depreciation and property taxes. There may be an amount of property taxes that's in there, and we can certainly verify that. I was thinking as of 2019, it was just deferred depreciation, but I believe that balance would be primarily depreciation, but I would have to verify whether or not there is a deferred property tax amount in there, and would have to provide that number.
Okay. Now, I just wanted the clarification given the footnote there. Thank you.
Yes, ma'am. Actually, when you point out, I was starting to read the footnote, and I was just thinking based on when those were placed in service, that was just depreciation expense. But there could very well be an amount of property taxes in there.
Well, let me ask you this. If there are property taxes associated with that in this account, would those also be those property taxes be reflected in just ordinary property tax account?
No, ma'am. They would be recorded here in deferral instead of the property tax expense account.
Okay, thank you.
Yes, ma'am.
Commissioner Thomas. Commissioner Thomas, I think you may be muted.
Is that better?
Yes, sir.
Okay. All right, so Mr. Cofer, appreciate you helping us out here. I have a few questions, and one of them relates to the unprotected excess deferred income taxes, but I think I'm going to probably need to just talk with Ms. Nowak. How do you pronounce her name? I'm sorry.
Naraki.
Naraki. Okay. So I guess I have a couple questions, and one relates to, since you're now part of a bigger organization than you were a few years ago, and a lot of items end up getting allocated to and from South Carolina and the other entities, and both on the expense side and on the asset side. And are you involved in how those allocations occur?
I am familiar with how the allocations occur. Yes, sir.
Okay. So I guess my concern is that you all have many entities in many states, and I've seen different numbers from 16 to 20 states, and you have different filings at different times in different states, and they all end up having allocations, and sometimes the methodologies are different state by state. And so basically I'm interested in being sure that if you calculate the numbers the way they would normally be calculated in each state, that you did it at the same period, and you added them all up, that they wouldn't come to more than 100%. And if they did come to more than 100%, I would not want South Carolina customers to be picking up any excess amount. Can you assure me that that's not a problem?
Yes, sir. I understand the question. And I will say I'm obviously more familiar with the historical methodology in South Carolina, being more involved now with that over the years. I can tell you that I would be extremely surprised if the allocation methodologies, either under the new allocation methodologies of Dominion Energy or the historical ones at SCANA, would have resulted in an allocation of more than 100%. They are designed to allocate the actual cost, the 100% of the cost, and only the cost. I will also add that the default is we seek to direct charge whenever possible as the best method of assigning cost. So it would be costs that would not be the types of costs that you could effectively direct charge that would run through an allocation methodology. I would also say, too, just even within Dominion Energy South Carolina, it's also important that we actually make sure we have to charge costs correctly between our electric and gas operations. So it's a robust process to ensure that costs are being assigned and allocated to the appropriate companies and the appropriate jurisdictions within those companies.
Okay. All right. So let's talk a little bit about some of the adjustments, and I'm just going to try to run through them kind of quickly. There are a few that I'm interested in. Adjustment 19 for the storm remediation, adjustment number 20, which is a new one, for the storm remediation rider, and number 21, which is another new one for tree trimming and vegetation, and then the number 22, which is the urban major maintenance, number 30, the critical infrastructure protection cost deferral, and finally number 32, the VCS cybersecurity deferral. So all of those deferrals and accruals and whatever that particular one is are certainly based on a lot of estimates, and in terms of coming up with the amounts, in terms of coming up with what should be the recovery period or the payback period to customers. Without going into detail on each one, my question, generally speaking, is would the company be willing to reduce, postpone, speed up, depending on which the item is, in order to give the customers a break here for a little while, just like the same concept with the excess deferred income taxes? And we've heard a lot from customers. I'm sure you've heard a lot of the testimony from the customers, and it's just a very, very difficult time. And it's important that we try to figure out a way to, I guess, make customers happy is what I'd say here. There's a balance between the customers and the investors, and there's some adjustments that could be made that would make things less painful for the customers. Would the company be willing to work on that?
So yes, sir. I completely understand your question, and obviously I heard parts of the night hearings as well. I would like to maybe explain the amortization period for the deferrals we proposed. We really sought to propose objective measures towards the amortization periods. And we believe that's consistent with past commission orders and helps promote transparency in regulation. So just I want to make sure that this commission understands these were not arbitrary amortization periods for the deferrals that the company has proposed. Commissioner, it is certainly within the discretion of this commission to propose longer amortization periods. I do think, if that is an option that is going to be considered, we have to be careful with how long we extend the amortization periods. The longer you extend the amortization periods, the more you're pushing recovery of that to those costs to future generation of customers. So I just think if that's an approach that's going to be taken, we need to be careful with how long we extend the amortization periods. But it is certainly within the commission's discretion to extend the amortization periods if they so choose.
Okay. Let's see. Well, that's about all I can think of right now. I appreciate you helping, and hope you have a good day.
Yes, sir. Thank you.
Thank you, gentlemen. Any more commissioner questions for this witness? Any redirect?
Mr. Chairman, just one. Mr. Kofer, in regard to the amortization period selected by the company, you indicated to the commission that the company had used objective standards in selecting those amortization periods in order to represent periods that accurately reflected the asset that was being amortized. Is that correct? To align the amortization or recovery period closely with the time period over which the deferred balance accumulated. And the company, in making that recommendation, did so adhering to all principles and standards of accounting and rate making to what you believe to be fair and reasonable. Is that correct?
We believe those amortization periods to be fair and reasonable and a very objective measure over which to amortize deferrals.
And does it still remain the company's recommendation that those amortization periods be approved as the most appropriate and fair and reasonable?
Yes, it does.
Thank you very much. Those are all my questions on redirect, Mr. Chairman.
Thank you, sir. Let's take a 15-minute break. We'll be back at 3:45.
Mr. Chairman, could I just one very, very quick follow-up? This is Commissioner Thomas.
Yes, sir, Commissioner Thomas.
Okay, so basically I heard that and understand that, but make a long story short, a lot of different people would be looking at these, and a lot of different people could come up with a lot of different scenarios under which makes those reasonable. And if you had 2 or 3 different people in the room, all 2 or 3 of those people could come up with a very, very reasonable argument for the manner in which those numbers are amortized. Would you agree with that?
Yes, sir, I would agree with that.
Thank you. That's all I have.
Thank you, sir. Mr. Witness, you may be excused. Thank you for your testimony. We'll be back at 3:45.
Thank you, Mr. Chairman.
Good evening, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina's hearing in docket number 2020-125E. Before we get started, we're going to take a quick roll. Vice Chair Belzer, Commissioner Caston, and Chairman Williams are present in the hearing room. Commissioners Thomas, Irvin, Williams, and Powers are present virtually. Commissioner Irvin, I understand you wanted to be recognized.
Yes, Mr. Chairman. During the past hour, I was on the call bridge listening to the testimony because my computer had mandatory updates that I had tried to delay and defer, but it wouldn't allow me to. So I was unable to have a video connection, but I did use the call bridge. So I've been listening and I've heard all the testimony and evidence. I just wanted that to be a part of the record in this case. But I'm back with you now virtually.
Thank you, sir.
Thank you.
Okay, so it is approximately 4 o'clock. I see the applicant has five witnesses left. Do you think we can get through all of those witnesses this evening?
Mr. Chairman, obviously it depends on cross-examination. Our next witness is Kevin Kochums, and I think it will depend upon how much cross-examination there may be.
All right, applicant, call your next witness.
Thank you very much, Mr. Chairman. Our next witness is Mr. Kevin Kochums. I see Mr. Kochums has turned on his camera. And good afternoon, Mr. Kochums. Would you say hello so I know your audio is working?
Good afternoon, Mitch.
Thank you.
Attorney Willoughby? Attorney Willoughby?
Yes.
I'm not sure what Mr. Kochums has going on in his room there, but he seems to be barely visible. It seems to be a dense fog in his room. And the court reporter uses video to read lips.
Is that better?
Yes, sir. Thank you.
Okay.
It is better.
I may have had something on my camera. I apologize for that.
All right.
So the court reporter will now swear you, Mr. Kochums.
Mr. Kochums, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Please state your name for the record.
My name is Kevin Kochums.
And by whom are you employed and in what capacity?
Effective January 1st, I am a manager of regulation for Dominion Energy Services.
In connection with this proceeding, Mr. Kochums, did you prepare and cause to be pre-filed direct testimony consisting of 23 pages?
Yes, I did.
Are there any corrections or changes to be made to that testimony?
No, there are not.
If I asked you, or if I asked you the questions that appear in that pre-filed direct testimony, would your answers today from the stand be the same?
Yes, they would.
Mr. Chairman, I would move the introduction into the record as if given orally from the stand, the pre-filed direct testimony of Mr. Kevin Kochums.
Mr. Kochums, pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you very much. And attached to your testimony, Mr. Kochums, was 2 exhibits. Is that correct?
That is correct.
Are there any corrections or changes to be made to those 2 exhibits?
No, there are not.
Thank you very much, Mr. Kochums. Madam Chair, I would move the introduction at this time as the next hearing exhibit, the 2 exhibits attached to Mr. Kochums' pre-filed direct testimony.
The two exhibits attached to Mr. Cocum's direct pre-file testimony, which are KRK1 and KRK2, will be marked for identification as a composite exhibit and numbered 35 and entered into the record of this case.
Thank you very much. Hey, Mr. Cocums, have you prepared a summary of your pre-file direct testimony?
I have.
Please deliver that at this time. And Madam Chair, I would also say that I'm going to try again at some point in Mr. Cocum's summary to share his exhibit 2, I believe, as he's summarizing the testimony.
Thank you.
Good afternoon, Chairman Williams and members of the Commission. I'm sorry, was I not supposed to start?
No, you're perfect. You proceed.
Good afternoon, Chairman Williams and members of the Commission. In my pre-filed direct testimony, I provide certain accounting and financial information in support of the application. I also present the company's fully allocated customer cost of service study, which allocates responsibility for the revenues required to operate the electric system among the various customer classes. With regard to the customer cost of service study, there are 3 major steps in the cost of service development. The first step is the functionalization of costs into production, transmission, and distribution. To accomplish this, we rely on the accounts where the company's costs were recorded. These accounts conform to the uniform system of accounts of the Federal Energy Regulatory Commission and are categorized by these primary functions. The second step is to classify those costs into demand-related, energy-related, and customer-related costs. Demand costs are incurred in proportion to the kilowatts of demand imposed on various segments of our system by our customers. Costs which are demand-related are typically referred to as fixed costs. These include the major portion of the company's investment and expenses in its production and transmission facilities and a significant portion of the investment and expenses of its distribution system. Energy-related costs vary with the number of kilowatt hours consumed on the system. These costs are also referred to as variable costs. Customer-related costs are primarily a function of the number of customers served. These costs include items of investment and expenses in functional categories such as meter investment and expenses, customer accounting and sales expenses, investments and expenses related to secondary lines and services, and a portion of investment and expenses related to transformers. The third and final step to properly allocate the demand, energy, and customer costs to customer classes. The allocators used for demand-related costs are the coincident peak allocator for production and transmission-related costs, and the non-coincident peak allocator for distribution costs. The coincident peak allocator is developed based on the contribution each customer class makes to the system territorial peak demand. The non-coincident peak allocator is developed by taking the non-simultaneous peak demands of the different customer classes whenever they occur during the year. The allocators used to assign energy-related costs to the various classes are developed from the annual kilowatt-hour sales by customer class. The allocators used to assign customer-related costs to the various classes are either weighted or non-weighted allocators based on the number of customers. The company has used these allocation methodologies with the Commission's approval in all electric rate proceedings over the last 30 years because they provide consistency in the allocation of costs. This concludes the summary of my direct testimony.
Thank you very much, Mr. Cocum. I'll see if I can now take this slide down.
You're slowly losing your award, Mitch.
I know I am. I'm going to have some help here. Okay. Okay, here I've got it. Okay, I'm back in the okay. Now, Mr. Cocums, did you also, in connection with this case, prepare and pre-file 14 pages of rebuttal testimony.
Yes, I did.
And in connection, I don't believe there were any exhibits attached to that testimony, was there, Mr. Cocombs?
No, there were not.
Are there any corrections or changes to be made to your rebuttal testimony?
No, there are not.
If I asked you the questions that appear in the rebuttal testimony, would your answers today from the stand be the same?
Yes, they would.
Would you, Mr. Chairman, I would move the introduction of Mr. Cocomb's pre-filed rebuttal testimony as if given orally from the stand.
Mr. Cocomb's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you very much, Mr. Chairman. Mr. Cocombs, have you prepared a summary of your rebuttal testimony?
I have.
Please deliver that at this time.
In my rebuttal testimony, I respond to certain matters raised in the pre-filed direct testimony of David E. Dismukes, witness for the South Carolina Department of Consumer Affairs, regarding the customer cost of service study, who advocates that the company use the average and peak method of allocating costs. I also respond to certain matters regarding working capital raised by Mark E. Garrett, witness for the United States Department of Defense and all other federal executive agencies. With respect to Mr. Dismukes' proposed changes regarding the customer cost of service study, I explained that consistency is an important principle of rate making, and the coincident peak method has been used with the approval of this commission for over 30 years. As an initial matter, any determination that changes are appropriate should be made only after a full evaluation of the issues with input from all stakeholders. But the company believes that based on the actual load analysis and operation, the coincident peak method remains most appropriate for allocation of costs. The company built its production and transmission assets to support the system peak regardless of when that occurs. Coincidentally, the company believes that the method of cost allocation that allocated some portion of fixed costs based on energy usage, such as the average and peak, would not adequately account for the peak-driven demands historically experienced by the company and would therefore fail to reflect the actual load characteristics of the company's system. Because the company is providing adequate generating capacity to meet customer demand whenever those demands are made, the company's investment in production plant is driven by peak demand, not average demand. The company believes that it would be appropriate to retain the cost allocation system that it has used with commission approval for over 30 years. But the company respectfully asserts that if the commission believes it appropriate to evaluate a different methodology, any change should be deferred until the company's next general rate case so that an alternative methodologies and assumptions can be fully evaluated. Finally, I note my disagreement with Mr. Dismukes' recommendation to shift costs between customer classes. His recommendation is grounded on his use of the average and peak cost allocation method, which the company believes is not appropriate for the reasons I explained more fully in my direct testimony. I note that ORS has concluded that the company's customer cost of service study was reasonable. I note that DOD witness Garrett and South Carolina Energy Users witness Kevin O'Donnell in their rebuttal testimony both agree with the company's allocation methodology used in its customer cost of service study. I explained in my rebuttal testimony the company's disagreement with DOD witness Garrett's recommendation that it be required to conduct a lead lag study to determine working capital needs. The company has used this current formulaic approach for many years, which has the advantage of simplicity and consistency. There is no showing that a lead lag study is materially more accurate for determining working capital needs, and due to the time needed to perform a lead lag study, the company should not be penalized for failing to perform a lead lag study. I also note that FERC does not require the use of a lead lag study for electric utilities, and in fact withdrew a regulation that would have required electric utilities to do so. Mr. Garrett cites several utilities that have negative or zero working capital balances. However, when an equitable comparison is made between these utilities and the company, it is clear that the company's working capital is similar. This concludes the summary of my rebuttal testimony.
Thank you very much, Mr. Cocombs. Mr. Chairman, Mr. Cocombs is available for questions from the parties and from the commission.
Thank you. AARP.
Mr. Chairman, Adam Prothero for AARP. We have no questions for this witness. Thank you.
Walmart Incorporated.
We have no questions for this witness. Thank you.
Sierra Club.
Dorothy Jaffe on behalf of the Sierra Club. We have no questions. Thank you.
United States Department of Defense and all other federal executive agencies.
Yes, good afternoon, Mr. Chairman. I do have a few questions.
Please proceed.
Okay. Mr. Cocombs, I'm Emily Medlin, representing the United States Department of Defense and all other federal executive agencies. I would like to talk to you this afternoon about cash working capital. Would you agree that cash working capital is the amount of cash that a utility needs in order to pay expenses before the utility's revenues are received?
I would agree with that statement. I mean, the purpose of cash working capital is to fund the operation of the day-to-day needs of the company.
Okay. And as a result, you are asking the commission to award the company $111 million for cash working capital, correct?
Yes. So cash working capital is part of the total working capital number. The cash working capital portion is $111 million.
Okay, and that translates to $11.5 million in rates per year, correct?
Yeah, that's. Are you saying the $111 million of rate-based translations to how much in a revenue requirement? I want to make sure I'm following your question.
Yes.
Yeah, that seems about right.
Okay. All right, and the amount by the company was derived by utilizing the 1/8 method or the 45-day formula. Is that correct?
That is correct.
Okay, and do you agree that with the 1/8 method, one multiplies the operating account balances by 12.5%, which is 1/8 of a year or 45 days?
Yes, it's a very simplistic formula where we take O&M expenses and multiply them by 12.5%.
Okay, and that method has an assumption that revenues are received on average 45 days after expenses are paid, correct?
Well, the formula itself doesn't take revenues into account. I mean, that's not part of the formula.
Right, but it's assuming that the company is having to pay expenses, and then 45 days later, they receive the revenues to pay those expenses, right?
Yeah, that's correct.
Okay. And would you agree that a lead lag study is another method to determine the cash working capital?
I would agree with that, yes.
Okay. And a lead lag study provides the result as to how much cash is needed to account for any lag between expenses incurred and revenues received, correct?
Yes, that's the objective of the lead lag study. You are correct.
Okay. And I'm going to hopefully correctly share my screen. I've sent around to the parties DOD pre-marked cross 1. So let's see. Okay. Is it up, hopefully?
I still have a black screen, but it may be just a lag.
Okay. Let's see. Is it still sharing?
It says it's starting to share content.
Okay.
Which makes me think it's on its way.
Okay. Let me give it a second. And while we're waiting, I've sent around to your council DoD FEA pre-mark cross 1.
Emily, this is basically this is request number 8-1. Is that what you're referring to?
That's correct, Mitch.
Perfect. Thank you.
I can see it now. I can see the screen now.
Okay, great. All right. Okay, and this has been pre-marked as DoD FEA 1, which is the company's response to DoD FEA 8-1. And I would like to direct your attention to the response to 8-1A. Now, the utilities that Dominion that uses the 1/8 method is just South Carolina, right? The retail jurisdictions. Is that correct?
So in A, it references Virginia Transmission, South Carolina Transmission, South Carolina Gas, and South Carolina Electric.
Okay. All right. And all of Dominion Energy's other retail jurisdictions utilize a lead lag study to calculate working capital. Is that correct? And B?
That is correct.
Okay. And that's Dominion Energy, Ohio, West Virginia, North Carolina Gas, Utah, North Carolina Electric, and Virginia. Okay. And then direct you to the subpart D, where we asked whether Dominion Energy had to hire an outside consultant to perform this lead lag study for any of your other retail jurisdictions, and the response was that no outside consultant was used. Is that correct?
Can you scroll down a little bit? I'm sorry.
Yeah. Oh, sorry.
I think you're right.
Can you see it now?
I could see it through the end of B.
Okay.
Yeah.
See it now, or?
No, you got to go to the next page, Emily.
Okay. Let's see. I'm on the next page, am I?
I'm pretty comfortable
Okay.
that that's what it says, if that's as far as you're going to go.
Okay. Well, did you help prepare this response?
Yes, I did.
Okay. So can you answer, just without using the exhibit, are you no outside consultant for the other jurisdictions utilize an outside consultant to perform the lead lag study? Is that correct?
I think that's correct. I think they all did it in-house with internal resources.
Okay. You stated in your testimony that a lead lag study is extremely complex and inexpensive, correct?
That is correct, yes.
Okay. However, despite your belief that they are extremely complex, Dominion Energy has the skill and competency to perform them in-house. Is that right?
Well, I mean, that's a true statement, but that doesn't mean it's easy to do or not time-consuming to do.
Okay, I understand that. That's all I have. I would like to move the pre-marked DoD FEA pre-marked Exhibit 1 into the record as the next hearing exhibit.
DOD FEA.
Mr. Chairman, we have no objections.
Thank you, sir. DOD FEA Cross Exhibit 1 will be marked and entered into the record as hearing Exhibit 36.
Okay, thank you. And let's see, is there a way to unshare? Okay, I see. There we go. Hopefully. Thank you. That's all I have.
Thank you, ma'am. Frank Knapp, Jr.,
I have no questions, Mr. Chairman.
South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Good afternoon, Mr. Chairman. This is David Neal with SACE and CCL. Can you hear me?
No, sir, we cannot.
All right. Let's by one other method. How about now? Is this okay?
Not really.
All right. We'll go to door number 3. Hold on a second. I appreciate your indulgence. How about now?
Loud and clear.
Awesome. Again, I appreciate your patience. Mr. Kokums, again, this is David Neal with SACE and CCL. I'm going to have some questions this afternoon relating to Dominion's cost of service study. And some of those questions may overlap with issues related to rate design. You would agree that the company's cost of service study is an important part of the company's proposed rate designs, correct?
Yes, I would agree with that.
And so if at any point you think a question that I'm asking you would be better directed to Dominion witness Alan Rooks, please feel free to let me know.
Okay.
First, if I could, that's a little harder now, one-handed. Turn your attention to page 18 of your direct, and if it's easier, I will attempt to show that now. Is that up on your screen?
Yes.
Okay. If you would please, this is again from page 18 of your direct, read the highlighted portion.
It says distribution facilities include the low voltage lines, transformers, and related facilities that serve individual neighborhoods, rural areas, and commercial districts. They do not function as a single integrated system in meeting system peak demand. Instead, the distribution system serving each neighborhood, rural area, or commercial district must be able to meet the peak demand in the area wherever it occurs.
And you would agree that the company's distribution grid is designed, engineered to serve expected and actual customer peak demand in those specific geographic areas as you described in the passage you just read. Is that right?
Yes, I would agree with that.
And put another way, the distribution grid is built by the company to serve load at any given location, regardless of the type of customers or number of customers served at that location. Is that right?
I think I would agree with that. I mean, I have a little hesitation because the distribution system isn't the same everywhere. It's sized for whatever customers are there to be served.
I think that makes perfect sense. But okay. At any location, though, it's going to be designed to serve that load, no matter what type or number of customers happens to be at that location.
Yes, I would agree with that.
Now, you would agree that in the company's cost of service study, costs should be classified according to their cost causation characteristics. Is that right?
That is the goal, to reasonably assign costs to the class of customer that caused those costs.
And you would agree that the starting place for that cost of service study is the actual costs incurred by the utility in rendering service to its customers?
Yes, the starting point is the books and records of the company.
Now again, Mr. Kokums, I'm going to ask you some questions about the company's methodology for classifying a portion of distribution plant costs as customer related in its cost of service study. First, just so we're clear on terms, you would agree that it's the company's intention to classify as customer related those costs that vary with the number of customers served.
I'm sorry, say that one more time. I want to make sure I'm following.
Sure, and I'm summarizing page 16, lines 8 through 9 of your direct, if that's helpful. It's my understanding from reading that it's the company's intention to classify as customer-related costs that vary with the number of customers served.
That is correct.
And turning to demand-related costs, which, again, I think you define on page 15 of your direct, the company's intention is to capture in demand-related costs those that are incurred in proportion to the demand imposed on the system. Is that a fair summary?
That's a fair summary.
Now, before I ask you some more questions, again, I want to make sure we're on the same, level playing field when it comes to terminology. I've shared with you and your counsel over email 2 different documents. Now I'd be turning to what has been pre-marked as SACE CCL Cross Exhibit 4, which is a excerpt from the Regulatory Assistance Project's cost allocation for a new ERA manual. And before I ask questions about that, before I go further with it, I have a couple threshold questions. I just wanted to go ahead and tee it up. Mr. Kokums, do you consider yourself to have expertise in the area of utility cost of service?
I'd hesitate to call myself an expert, but I certainly do have knowledge of that, and as well as other people within the company. Yes, sir.
And are you do you keep up with professional literature on cost of service, emerging trends, and how to do cost of service studies and cost allocation?
I wouldn't say that that's something I look for often or frequently, but certainly if there's something out there that's brought to my attention, I would read it.
Are you familiar with an organization called the Regulatory Assistance Project?
Regulatory Assistance Project? No, sir.
RAP. It's RAP for short. So you weren't aware that RAP, on December 13th of 2019, that the Public Service Commission of South Carolina hosted a day-long workshop that was organized by the Regulatory Assistance Project that explored the topic of the utility of the future?
I was aware that there were meetings to discuss different topics with the commission. I'm not aware of that particular one.
At this time, Chair Williams, I would like to mark this electric cost allocation for a new era excerpt under as a treatise, as a treatise in the field of utility cost allocation.
Mr. Chairman, this is Mitch Willoughby on behalf of the company. If the witness has seen this, and I don't think he has, and is familiar with it, then maybe he could answer questions about it. But I don't know that I necessarily agree with Mr. Neal that it's a treatise. It is what it is, but I don't agree that it is an authority of any sort. It's just a document. So I would have objections to the introduction of the document unless Mr. Kokums is familiar with it and knows the content of it.
And Chair Williams, if I could respond briefly.
Please respond.
Under Rules of Evidence 803.18, it's my understanding that a witness can be asked questions on cross-examination if it's presented with a learned treatise that's considered a reliable authority, and that can be done either by the witness acknowledging the authority of the document or by judicial notice. And given the Commission's prior association with the Regulatory Assistance Project, I would ask that the Commission take judicial notice of the Regulatory Assistance Project's manual that was published in January of 2020.
Mr. Chairman, if I may, that what Mr. Neal just said was basically explains my objection. There's no foundation for this document. I'm not familiar with the Regulatory Assistance Project, have no idea whether they're a learned group or body, certainly do not admit that, and therefore this is just piece of paper that has been introduced. The commission receives input from lots of people, and probably you don't agree with everything that you receive, but from an evidentiary standpoint of view, there's no foundation laid, there's no witness that's going to sponsor this exhibit, and therefore it's objectionable and should not be used as an evidentiary support. If he presents it to Mr. Kokums, and Mr. Kokums familiar with it, he's already said he doesn't know who RAP is, then that would be different. But my suspicion is that Mr. Kokums is not familiar with this organization, not familiar with this document, and therefore is not going to be able to testify to it. What Mr. Neal is attempting to do is just simply put the document into the record, and to that we object.
And to be clear, Chair Williams, it is not my intention just to get it into the record. I actually wanted to ask Mr. Kokums some questions based on information in the manual.
Now I'm getting a little confused. Do you not want to enter this document into the record?
My primary purpose was to use it in cross-examination as permitted under 803.18.
Yeah, I'm reading the
in
rule
cross-examination.
now. If that's all you want to do,
that?
go ahead.
Thank you, Chair Williams. Mr. Kokums, did you receive what has been marked, again, not for purposes of admitting in the record, but just for purposes of keeping it straight, Cross-Exhibit 4, an excerpt from the electric cost allocation for New Era?
Are you going to share this your screen, or am I supposed to get a hard
I'm
copy?
happy to. I did email it to you, but...
Okay. Well, okay, I can see a PowerPoint presentation, it looks like.
It is, it's the cover page from the manual.
Okay.
But going to section 11.2, distribution classification. Again, it's an extensive, over 300 page manual, but just for purposes of what I wanted to ask you, going to chapter 11.2, distribution classification. Do you see here where it says the classification of distribution infrastructure has been one of the most controversial elements of utility cost allocation for more than a half century? Do you agree that the issue in this case, that there's controversy over the classification of distribution infrastructure in this case?
What can you tell me exactly what controversy you're referring to?
Yes, I'm referring to some questions about the extent to which distribution plant costs have been, a portion of distribution plant costs have been classified as customer related.
Okay, yes, I'm familiar with that question, or those varying opinions.
Mm-hmm. And are you familiar with something called the basic customer method as a way of classifying distribution plant costs?
I've heard that term before. I've never done any kind of calculation behind it, but I have heard that term before. Yes, sir.
So turning your attention, I'll just highlight it to make it easier to see. Can you read what I've just highlighted?
It says the basic customer method for classification counts only customer-specific plant as customer-related and the entire shared distribution network as demand or energy-related.
And just to continue, the next sentence.
For relatively dense service territories in cities and suburbs, this would be only the traditional meter and portion of service drop costs.
So, thank you. Reading that, does that refresh your recollection or give you a sense of what is meant by the basic customer method?
Yes, it does.
Okay. I'm going to take that down for a moment. So again, sorry to kind of slow us down, but I just wanted to make sure we had a kind of a shared understanding of what the basic customer method is. You would agree that Dominion does not use the basic customer method, correct?
I would agree that that Dominion does not allocate just the meter and the service drop to customer cost. I would agree with that. Yes, sir.
So you include those costs as customer related in your cost of service study, however, correct?
Yes. So the meter, the service drop are included in our cost of service evaluation. What we do from a calculating a customer cost standpoint is we go back to include the transformer and portions of the secondary distribution lines. So I think the question is,
yes,
at what point in the electric system do customer costs start based on the varying methods that are out there?
And you've anticipated my next questions. I think, so in addition to meter investments and expenses related to customer service and accounting, as you've just said, Dominion includes a portion of distribution plant costs. And I'm going to try to make this clearer, I'm going to go to what's been now marked as composite hearing exhibit 35, which is the exhibits attached to your direct testimony. And we're going to go to page 3 of 16 of exhibit KRK1. Do you see that?
Yes, I do.
Okay. So just to make sure we're all on the same page about what you just said, when we look at something like FERC account 364-365 here on line 14, which is the overhead lines, as I understand it, a portion of that you've on line 16 has D30, which is a demand allocator. Is that correct?
That is correct.
And then on line 18, we get what's marked here is, I'm just going to highlight for ease of reference, line 18, Dominion has taken a portion of those overhead lines and designated them or classified them as a customer related with the C35 allocator. Is that correct?
That's correct. So basically what that is the portion of the distribution system, and I'll use a simple explain or example because I'm not an engineer, but if we have a line running down a street and it takes a left turn and feeds a neighborhood, the portion that's running down the street would be that primary overhead line. The portion that's going into the subdivision is the secondary line. And then the portion further down the street that feeds another subdivision, that would be the secondary line as well. So the line going, the distribution line going down the street that feeds 5 or 6 subdivisions on that street, that would be the primary line. The subdivision piece would be the secondary lines. Hopefully that helped.
Certainly. And again, just to put some numbers behind this, because making it customer related means that it's related to the number of customers. As we look down the column of residential customers, for example, again on line 18, we see that the residential class has been allocated about 74% of the total for secondary distribution lines. Is that right? Again, lawyer math is always risky, but the 311,698 out of the total 421,773.
Yes. So when we looked at the distribution portion, the overhead line portion of our distribution system, $311 million was related to those secondary lines. Hopefully we're saying the same thing.
Yes, and that, yeah, so that's 74% of the total.
Okay.
Do you disagree with that?
It's 74% of the 631?
Of the total on line 18 of the 421.
I'm sorry.
It's residential.
I'll trust your math on that, but that seems about.
But I guess really what I'm trying to just make clear is that a consequence of classifying a portion of these distribution plant assets as customer related is that it increases how much of that is allocated to the residential class.
I guess I would agree that that's how the math works, but the math is following the logic of how the system is established.
And all right, let me turn this off. I'll just note that the same C35 customer-related allocator shows up again for underground lines in line 22. You would agree with that?
Yes, the secondary function.
And again, in the transformers secondary function, there's a customer component at line 29.
Exactly. So that would be the transformer hanging on somebody's pole that feeds their service drop.
And except, just so we're clear, this is just under the company's methodology, you've apportioned some portion of all transformer costs, all secondary transformer costs. You've apportioned a part of those as customer related and a part of those as demand related.
So essentially what we did is we looked at the transformer costs that are within our system for a certain size. Don't hold me to this, but I think it's a 25 kV or lower transformer. And we looked at those and assumed that each transformer could feed 4 customers. And we figured out how many customers we had and kind of did the math and said $177 million of those transformers are feeding those customers. Hopefully you're able to follow that.
Yeah. We're gonna go into, just to make sure we're clear, we might go into a little more detail in a minute, but that was helpful. So in your direct, you say that the company follows, quote, principles and methodologies that have been accepted by this commission for the past 38 years. But I couldn't find a precise name or description for the methodology that we've just been talking about for allocating a portion of those distribution plant costs as customer related. Is that fair?
I guess I could respond saying that is the methodology we've used since, for over 30 years. I don't know that we've named it or but if you went back and looked at the prior orders, I mean, you'd have to dig back into it, but you'd be able to see that that's what we've done.
And are you familiar with a methodology called the minimum system method or the minimum distribution method?
Again, I've heard of it. I'm familiar with it, but I've never done any kind of calculation of it.
Okay. So would it surprise you to learn that 38 years ago, when, again, that's the number you provided as that y'all have been doing this for at least 38 years, that the company described its methodology for allocating a portion of distribution costs as customer related as the minimum distribution system method?
That wouldn't surprise me. No, I mean, if you say so, I'll trust you.
So I'm just going to skip ahead here. Really, what I'm trying to get at here is just to make sure that we understand that part of the difference of opinion between the company and AARP witness Rubin and Department of Consumer Affairs witness Dismukes about what's the appropriate basic facilities charge relates to what's the appropriate, what should be appropriately classified as customer related. And that part of that has to do with what's classified as parts of this distribution system that are classified as customer related. Isn't that right?
I would agree with that. I think it comes down to when you look at the system, where do you draw that line between distribution and customer class? And
so, again, this gets into something that Mr. Rooks testified to, but you would agree that he testified that I guess what I would call the theoretical basic facilities charge that that would be supported by the company's cost of service study is about $19.49 for residential customers.
That's correct.
And just, again, to draw a line under it, the difference between, or a big portion of the difference between the current BFC of $9 and that theoretical BFC of $19.49 has to do with these distribution costs.
Yes, a major portion of the customer-related costs that factor into the basic facilities charge are the assets that support those customers.
And again, that is a choice the company has made to allocate, to classify those as customer-related as opposed to demand-related.
I mean, that's the methodology that we've employed. Yes, that's correct.
And would you agree that a characteristic of the distribution grid is that it's shared between customers?
I would agree with that, yes.
So, for example, there could be times where a new house is added to an existing distribution grid without requiring any new poles, any new wires, any new transformers. Isn't that right?
Again, not being an engineer, I would think at some point you're going to have to add more lines or bigger lines. Now, I don't know if you could add one house. I guess it would depend on the specifics of the distribution line you're talking about.
Well, but let's think of the flip side. You can imagine a scenario, even not as an engineer, where a house in an existing neighborhood is torn down and is no longer in service, and that wouldn't require the company to remove any poles, any wires, or any transformers. Can you imagine a scenario like that?
Yes, I can imagine a scenario where a neighborhood tore down a house. Yes, sir.
But not just that they tore down the house, but that a result of tearing down that house and taking it out of service doesn't require any reduction in the distribution grid that serves that neighborhood.
I wouldn't imagine so, no.
So next, again, I'd like you to consider, not as an engineer, but as somebody who is familiar with the cost of service principles that are underlying the company's case here. I'm going to ask you to consider a hypothetical new subdivision. And to try to keep things relatively simple, I want you to just imagine a new residential development, and it's one that's not served by any gas utility, and that has a mixture of three different types of properties. Some large detached homes, kind of on larger lots, some connected townhomes, like let's say 2-bedroom connected townhomes, and an apartment building made up of small, like 1-bedroom apartments. Are you with me so far?
I'm with you.
Okay. And you would agree that in order to serve the expected load of those 10 large detached homes on single lots, that the company would need more poles, more wire, larger transformers per resident than would likely be required for a group of 10 connected townhomes. Isn't that right?
So I'm assuming the usage for a large house is going to be higher than the usage for a apartment. Is that what you're saying? I want to make sure I'm following you. I'm sorry.
Yes. I mean, I think that's yes. Implicit in this hypothetical is that the large houses, let's call them McMansions, on big lots are going to be bigger users of electricity than the 2-bedroom connected townhome.
Yes, I would agree with that. So I would think that would factor into the distribution line that's going to feed those townhouses or that apartment complex.
But it's also going to affect what size transformer you need to serve each residence. Isn't that right?
Well, it may be the number of transformers that are necessary. Yes, sir.
And by the same token, if you had a single apartment building that had 10 1-bedroom apartments, you would require a lot less poles, wires, and transformers to serve that one building with 10 separately metered units than you would for the 10 McMansions.
Yes, I agree with that. I think we're saying the same thing, that distribution line that goes to feed those areas, that's part of that distribution that we allocate based on demand. It's the secondary lines that are allocated to based on the number of customers.
But this is a single subdivision, so we've already established that we're talking about the secondary lines that are going into this neighborhood, and that then there's a service drop from those, after the transformer, to these different residents. So I'm saying that in this hypothetical, we're talking about parts of the distribution grid that the company has allocated as customer related. And I'm trying to show that, as you've agreed, there's going to be a different number and potentially size of grid assets to serve the McMansions versus the townhomes versus the apartments.
Okay, I'm sorry. Could you repeat the question? I want to make sure I'm sorry.
I apologize. I thought we were on the same page, that you had agreed previously that that the number of poles and wires and transformers, or at least the size, if not the number, the size of transformers that would be required to serve each McMansion is going to be different than the distribution assets that are going to be needed for those small apartments.
I would agree with that statement.
And
I think it's
sorry to
important.
interrupt.
No, I'm sorry. I think it's important to note that there's a lot of different extremes, and because we don't have data to create a rate for every single customer, we have to do this by classes of customer. So obviously there's if you go one or two standard deviations outside of the norm, you can find extremes on one end or the other. But again, the goal is to try to get a cost that reasonably reflects the cost that class is causing.
I hear you, but just stick with me in this hypothetical for just a minute longer. The parts of your cost of service study that that classify a portion of these distribution assets as customer related, under your methodology, a significant portion of these poles and wires and transformers are going to be split evenly per customer because of the method you're using to take a customer-related allocator to those assets.
Well, again, I agree with what you said. I guess what I'm trying to point out is you may have a transformer that feeds an apartment complex, and then you may have down the street a transformer on a farm that feeds one house, one farmhouse. So the point being is that we assume that one transformer feeds 4 customers. That's not necessarily true for every single transformer, but on average, that is a reasonable assumption to make.
I understand the assumption you're making. What I'm trying to get at is that this the potential unfairness in your company's methodology is just going in one direction, so that the denser and smaller the residential customer served, the more likely it is that your methodology is going to result in a larger percentage of those distribution grid assets, those shared distribution grid assets, being attributed to them than in the folks in the larger houses that are more spread out.
I guess I'm struggling with the question, and I apologize. I'm not trying to be difficult. I just want to make sure I'm being responsive. But
well, again, I think we've covered the hypothetical. I don't need to go into that more.
Okay.
I don't think a residential subdivision is an extreme example of the kinds of territories that you serve, and you've already again agreed that the underlying assets, the grid assets that are going to be needed to serve the larger houses versus the small apartments, that there's going to be a significant difference there. And that's really all that we really need to cover. here. Is that fair?
I think so, yes, sir.
And again, the concluding point I was trying to make, and this is where you gave an answer about, I think, basically we're talking about average cost rate making, but that because you're taking this customer, you're calling these distribution assets customer related, that means they're being allocated identically per customer, regardless of what kind of house they're living in.
Again, this may be somewhere where you need to ask Mr. Rooks, but I think Mr. Rooks' exhibit shows a different BFC based on either class or rate.
We're just in the residential class now, so
right,
and we'll just stick to residential class rate 8 to keep things simple.
So then, yes, I would agree with your statement.
And again, at page 15, line 16 of your direct testimony, when you're talking about the demand-related portion of distribution plant, you testified that customers cause the company to incur these investments and expenses based on the relative demand requirements that they place upon the system. Do you remember testifying to that in your direct?
I'm sorry, which page? You're on 15?
I'm sorry, I was on page 15, starting, I think, at line 16. That's from my notes, where you wrote, customers cause the company to incur these investments and expenses based on the relative demand requirements that they place upon the system.
That's correct. I see.
And that's where so you're talking there about what you consider the demand-related portion of distribution plant.
Correct.
And now I'm going to try to skip ahead. Again, I've mentioned already that given that you said in your testimony that the company's been using this methodology for at least 38 years, I assumed that you were referring to the predecessor company, SC DN's general rate case in docket number 82-240-E that was filed in 1982. Are you familiar with that case?
Oh, I'm not particularly familiar with that case, no, sir.
So you weren't aware that in that docket, in Commission Order number 83-404, that the Commission rejected SC DN's request to increase the basic facilities charge from $6 to $7.10 as, quote, unreasonable.
I'm not aware of that, but I'll take your word for it.
Again, it's a Commission order. I don't think I need to take time pulling it up on the screen. Chair Williams, and if there's no objection from your counsel, I would just ask that we take judicial notice of order number 83-404 from the aforementioned SC DN rate case.
And it was what was the title of the case and what is the order number, Mr. Neal?
The docket number is 82-240-E. I believe it was filed in 1982. And the order number was 83-404. And it was a SC DN general rate case. And it was consolidated with a case around terms of service that isn't relevant to this.
Judicial notice taken.
Mr. Chairman, while I have not reviewed that order, we have no objection to the Commission taking judicial notice of it, but I would have this a caution only to the extent it has any relevance or bearing on this particular case, and it may have none, but it's in the Commission's files, and we certainly don't object to the Commission reviewing its own files.
Thank you, sir. Please continue.
If you give me just a moment, Chair Williams, it might speed things up. All right. Mr. Kokums, when it comes to rate design, and again, if these are better for Mr. Rooks, feel free to say so, you would agree that if the commission, for whatever reason, disallowed the classification of distribution plant costs as customer related, and decided that it wouldn't therefore allow an increase in the basic facilities charge, the company could still recover its allowed revenue requirements from a resulting change in the volumetric rate. Isn't that right?
Yeah, that's basically how it works. If the cost isn't recovered through the BSC, it would be allocated based on usage.
So one way to think about it would be if when you've got a customer like residential rate 8 that's got a two-part rate, a basic facilities charge that's fixed, doesn't change, and then the volumetric rate, the per kilowatt hour charge. It's kind of like a balloon. If you squeeze one side, it's going to make the other side go bigger. Is that right?
That's correct.
Switching gears, I would like to turn your attention to the coincident peak allocator for production and transmission costs. Do I understand from your testimony that the company's peak demand usually occurs between the hours of 2 o'clock and 6 o'clock on a summer day in the afternoon?
That's typically when it occurs, yes, sir.
And that is, it's within those hours that the company uses this coincident peak method to establish that coincident peak allocator.
That's correct. So within the test year, July 18th, between 2 and 6 o'clock, the peak usage occurred.
And in the test year, in this case, it was July 18th. Is that right?
July 18th, 2019. Yes, sir.
And so you would agree that Dominion typically continues to experience its peak during that time?
Between 2 and 6 o'clock?
Yes, sir.
Yes. Again, not being an engineer, my understanding is it's an instantaneous peak, and then it may go down, but we use that 4-hour band in the day it occurred.
And Dominion has not proposed any changes to this aspect of its cost of service methodology in this case. Isn't that right?
That's correct.
And so you would agree that all other things being equal, if a customer has lower peak demands on the Dominion system between the hours of 2 o'clock and 6 o'clock in the afternoon, on a summer afternoon, it's going to cost less to serve that customer than a customer with higher peak demands in that same 4-hour window.
So I think I agree with you, and so yes, if more customers contributed to the peak, the peak would be increased.
And a consequence of that, yeah, sure, and a consequence of that is the customers who are using less in that peak are costing less to serve. They're putting less demand on the system.
Correct.
And turning your attention to the company's rate offering for low usage customers. Now I'm talking about rate 2. Are you familiar with that rate?
No, I'm sorry.
Oh, okay.
That'd be a question for Mr. Rooks.
And I'll ask him that. But just to be clear, you're not familiar that the company offers it's late in the day, offers a rate for low usage customers that's different than the rate 8?
I am familiar with that concept, but if you're going to go any deeper than that, I'm not sure I'm going to be able to help you.
Well, I'll just ask this one question, and if we need to ask Mr. Rooks, that's fine. But would it be your understanding that the rationale, or let me put it this way: would you agree that the company makes an effort to have rates that are cost justified, that are based in cost to serve?
Yes, I would agree with that. I mean, the cost of service study that we do informs rate design.
And so if you are offering a rate that has a discount for customers who put less demands on the system, who consistently use less energy, that the rationale for that is that it is cheaper for the customer to serve those. It is cheaper for the company to serve those customers.
I think I agree with what you're saying. Again, not having any really knowledge about that rate, I hesitate to give you complete agreement. That may be a question better served for Mr. Rooks.
Okay, and I'll skip ahead again then. And would you agree that, as a general matter, that company's 4-hour summer afternoon peak window that we were just talking about, that 2 o'clock to 6 o'clock p.m. period, that generally corresponds to times of the day when rooftop solar has more production than certainly in the late evenings or early mornings?
That would be my general understanding, yes, sir.
And again, if this, my guess is you're going to say this is a question for Mr. Rooks, but you would agree, I think you testified that the company didn't, or maybe that is Mr. Rooks. But do you agree that the company has not proposed any changes to the summer peak periods for any of its residential time of use rates in this proceeding?
I'm not sure. That would be a question for Mr. Rooks.
All right. Well, again, I appreciate your time. I have no further questions.
Thank you, sir. Office of Regulatory Staff.
This is Andrew Bateman with ORS. No questions, Mr. Chairman. Thank you.
I
Mr.
want to
Chairman,
make sure I didn't
this is
skip
Scott
anyone.
Elliott.
I'm sorry. Attorney Elliott, did I skip you?
You did. I have a few questions for this witness, if I may.
Oh, absolutely. Please forgive me. Please proceed.
Happy to. Mr. Cockums.
Yes, sir.
As I understand your testimony, you, Dominion, and the Office of Regulatory Staff, and the Department of Defense, and SCEUC all agree that the summer coincident peak allocator is in the public interest in this case. Am I correct?
Attorney Elliott?
Am I not close enough? I'll get closer.
Yes, sir. There you go.
Thank you, Mr. Chairman. Mr. Cockums, I'll for the benefit of all concerned, isn't it true that Dominion, ORS, Department of Defense, and SCEUC all promote the use of the single coincident peak demand allocator in this case?
That is correct.
And isn't it true that the CP allocator, as we call it, is developed based on the contribution of each customer class to the system territorial peak demand experienced during the test year?
That is correct.
And to Mr. Neal's point of a moment ago, if a customer class has a steady load and puts less pressure or demand on the peak, it is cheaper in a sense to serve. Is that correct?
Yes, I think I would agree with that.
And the industrial load is generally steady during the year and contributes less to the peak than any other customer class. Isn't that true?
I don't know that for certain. I don't know what the industrial class load is throughout the year and whether it's less during the peak or not. I'm sorry.
All right, sir. Now, Mr. Disputes challenges the use of the coincident peak, does he not?
Yes, he does.
And if I understand his testimony, and I'm looking at his direct testimony on page 24, I will attempt to summarize it and ask you if you think that if this sounds like a reasonable summary of his complaint. He says, my analysis finds that a significant portion of the company's production plant fleet is devoted to serving energy needs of the company and not solely demand needs. Does that sound like one of his complaints about the coincident peak allocation?
Yes, sir. I don't have that in front of me, but that sounds accurate.
But now, isn't it true that Dominion uses an allocator to assign energy costs to customer classes as well?
That is true. Yes, sir.
And didn't you testify? And I refer you in particular to page 19 of your direct testimony, lines 5 through 8. Energy costs reflect the variable cost of producing, transmitting, and delivering electricity using the system demand already in place. Therefore, the company's energy sales during the test year by class of customers were used to allocate these costs. An example of a cost allocated on this basis is fuel. Do you recall that to be your testimony?
Yes, sir.
So isn't it true that the CP allocation method that you employed considers both demand and energy?
Well, I guess the CP allocator basically allocates the fixed costs for producing generation and the transmission of it. The energy related costs are allocating the variable costs like fuel, as I mentioned in my testimony.
All right. So isn't it true that the way you have allocated these costs, you consider both the fixed cost, if you will, then, and the variable costs?
Yes, sir.
All right. Now, Mr. Dismukes, he may be Dr. Dismukes or Professor Dismukes, and I don't want to offend, but you will recall that Mr. Dismukes has submitted an exhibit that purports to show the result of an A and P allocation based on your filing. Do you recall that?
Yes, sir. So he produced an analysis and shared it in his. Yes, I see what you have on the screen, Mr. Elliott.
All right, and my screen is obscuring the label in the upper right-hand corner, and I'm going to read it from the hard copy in my hand, and I hope that all the those on the line can see this, but it reads, Witness Dismukes, docket number 2020-125E, exhibit DED9, page of 2. Can you see that on your screen, Mr. Cocombs?
I cannot, no. I see basically the table, and that's all.
All right. Do you recognize the table from your review of Mr. Dismukes' testimony?
Yes, sir. I can attest to the exact numbers, but yes, it appears to be a table that was in Mr. Dismukes' testimony.
All right. Bear with me, Mr. Chairman. Reading across the top of the page, upper left-hand corner, it says results of alternative case cost of service study. Do you see that language?
Yes, results of alternative class of service study.
Yes, sir. Thank you.
Attorney Elliott, you're.
Am I not in front of my speaker?
Yes, sir. Please stay in front of your speaker.
So much. The next line in dark is account description, and it has the labels are total electric, total jurisdictional electric, residential service, small commercial service, medium commercial service, large commercial service, and lighting service. Can you see that on my screen?
Yes, sir.
All right, very fine. Now, to cut to quite literally the bottom line, I draw your attention in Mr. Dismukes' Exhibit DED2 to the bottom two lines, and you will see proposed rate increase, parentheses, percent. Do you see that language?
Yes, sir.
And so, according to his study, using his A&P allocation method, the total jurisdictional electric increase would be 8.66%. The residential service rate increase would be 5.77%. The small commercial service increase would be 0.45%. The medium commercial service would be 11.51%. And the large commercial service or industrial customer class would be 22.02%. Do you see where Mr. Dismukes is recommending a 22.02% rate increase on large commercial service customers using the A&P allocator?
Yes, sir. I see the 22.02. I've kind of lost the heading, but I think that is the large industrial customer column. There you go. Oh, too far.
I've got something on my screen that's obscuring it, so I can't tell what. There it is, large commercial service. You see that?
Yep.
And we come
yes,
down
sir,
to 22.02%.
Yep.
So, do you agree with me now that reading Mr. Dismukes' Exhibit DED9 that his A&P allocator would give rise ultimately to a 22.02% rate increase for industrial customers?
Yes, sir. I see that.
All right. Would it be safe to assume? Well, let me ask you this: isn't it true that Dominion makes an effort to encourage not only new economic development, but development of existing businesses and industries in the state?
I have a general knowledge of that, but that's certainly not something that I have any input or responsibility of.
But you wouldn't argue with that statement, would you, Mr. Cocombs?
No, I wouldn't argue that we encourage businesses to move to South Carolina. I mean,
all right, I think that's a fair assumption. And would it be a fair assumption to conclude that the higher the industrial electric rate in a jurisdiction, the less industrial development that you might expect in that jurisdiction?
I would agree that the cost of electricity for industrial customers would be one of probably many factors that they would take into consideration on any kind of relocation or construction of a plant.
Yes, sir. And if Dominion's industrial rates were so high that it lost industrial customer revenue, isn't it true that the remaining customer classes would have to pick up the lost revenue and pay for those lost revenues?
That's a fair statement. If tomorrow all the industrial customers went away, those costs would be shifted to the other classes.
All right. And so if Mr. Dismukes' concern is for the residential customer class rates, his recommendation could actually have the opposite effect if it leads to an excessive rate increase on industrial customers who flee the state.
That's a pretty deep question that I don't know that I'm qualified to answer. I mean, there's a lot of economics and
That's all right, Mr. Cocombs. I think it answers itself.
Okay.
Now, in fairness to Mr. Dismukes, while he plainly in Exhibit DED 9 demonstrates the excessive rates for industrial customers using the A&P allocator. He does, in his testimony, limit the rate increase he proposes in this case to 9.53% on industrial customers based on the application in the case. Do you recall that to be the case?
That's my recollection, yes, sir.
All right. Do you recall him giving an explanation for that arbitrary number?
I'm struggling to remember if he did or not, to be honest with you at this point.
All right. But if in the event he did fail to give an explanation for that arbitrary number, one could hardly blame him, given the fact that his own computations here would lead to a 22.02% increase on industrial customers. Would you agree?
Can you repeat the question? I'm sorry.
Well, if the record reflects that Mr. Dismukes gives no reason for assigning a rate increase of 9.53% to industrial customers, one reason might be that he frankly would not want to draw attention to his 22.02% rate increase that he is ultimately proposing on industrial customers.
That may be the case. That may be a better question suited for Mr. Dismukes.
Oh, I agree. Thank you so much, Mr. Kokums. Thank you, Mr. Chairman.
You're welcome. Department of Consumer Affairs.
Thank you, Mr. Chairman. We do have some questions. See if, Mr. Elliott, would you mind stopping sharing your screen?
I don't mind at all. I beg your pardon.
Good afternoon, Mr. Kokums. How are you?
I'm well. How are you?
Good. My name is Roger Hall. I'm an attorney and assistant consumer advocate with the Department of Consumer Affairs. Just have a few questions for you. I'm actually going to kind of go out of my planned order a little bit, so bear with me. Just for the sake of screen sharing issues, do you have a copy of your rebuttal testimony and Mr. Dismukes' direct testimony with you?
I have a copy of my rebuttal. I do not have a copy of Mr. Dismukes' direct testimony.
That's fine. I'll share the screen if we need to. On page 5 of your rebuttal testimony, at lines 10 through 13, you criticize Dr. Dismukes' statement that the company cost allocation method associated with transmission plant facilities is inconsistent with that employed by FERC in setting transmission rates. Do you agree?
On line 10 through 13, you said? I'm sorry?
Yes, page 5 of your rebuttal.
Mm-hmm.
Lines 10 through 13?
Yes, I see that.
Okay. And specifically, Dr. Dismukes states that FERC generally utilizes a cost allocation based on the average 12-month coincident peaks, or 12 CP, correct?
That is correct. It's my understanding that they may favor a 12-month CP, but that's not. They also recognize that there may be circumstances where that's not appropriate, based on the individual utilities operating.
Sure. And good. That was going to be my next question. And so, Dr. Dismukes, on page 27 of his direct testimony, he states that he recommends that the commission require the company to gather monthly system coincident peak information on a class basis in the future. I further recommend that the commission require the company to file an alternative CCOSS allocating demand-related electric transmission plant on a 12 CP basis in its next rate base filing. Does that sound familiar?
Yes, well, let me first apologize to Dr. Dismukes. I think I referred to him as Mr. Dismukes in my testimony and here today, so I apologize for that. But yeah, what you just read sounds like what he said.
Okay.
Mr. Chairman, excuse me, Roger, for interrupting, but Mr. Chairman, I would, Dr. Dismukes is going to have an opportunity to testify. I don't think we need for Roger to read his testimony. If there are questions that he has of Mr. Cocombs, we'd say ask those, but we don't need to have Dr. Dismukes' testimony read to us before he testifies.
Mr. Chairman, if I may?
Yes, you may.
Mr. Cocombs, part of his testimony clearly rebuts Dr. Dismukes' testimony, so I just need to lay the foundation for my next question. They would not make sense, frankly, if we did not discuss what Dr. Dismukes said in his testimony.
Overruled.
Thank you. So again, Mr. Cocombs, just to make it clear, one of Dr. Dismukes' recommendations is that the commission require the company to file an alternative cost of service study using the 12CP basis in its next rate base filing. That's your understanding, correct?
Yes, my understanding was that was his recommendation.
Okay, thank you. And in your on your rebuttal testimony, on page 6, lines 3 through 7. Actually, I'll bear with me. I'll share this one. And can you see that?
Yes, sir. I can see that.
Okay. This is again your rebuttal testimony, page 6. Would you mind reading the highlighted portion, please?
Yes, it says, if the commission wishes to evaluate a change in cost allocation methodology, it should defer that evaluation until the company's next general rate case. This will allow the company and other stakeholders to fully study the cost allocation methodologies and recommend future action based on a full evaluation of available alternatives.
Thank you. I believe in your summary you alluded to that comment as well, and you discussed full evaluation. Is that correct?
That is correct.
So would you agree that in order to fully study a potential change in cost allocation methodology, addition data would be useful?
Yes, I think a comprehensive study would incorporate all of the data that's available.
And for that, one example, class level load research information would be useful, correct?
Yes, I would agree with that.
Okay, thank you. And so, next question. As we discussed a minute ago, I believe you stated, I'll paraphrase, so please correct me if I'm wrong, that FERC may favor a 12CP cost allocation method, but that utilities are free to employ alternative allocation methods, correct?
That is correct. That's my understanding. Yes, sir.
And are you familiar with the company's open access transmission tariff?
Yes, sir.
Okay. Do you know the cost allocation method that is utilized by the company in determining its rates under the open access transmission tariff?
I think there's several of them. Some are related to labor. I believe there's one that's related to plant. I don't know that I could name them all for you right now.
Those sound like allocators. Is that what you're answering?
So, I'm sorry. I thought you asked us within that the open access transmission how costs were allocated.
No, I'm wanting to know the cost allocation method.
Cost. Okay.
What cost allocation method is used to formulate those allocators you were mentioning?
Well, I guess it would depend on the cost allocator. So, for example, the costs that were driven primarily by labor or wages would be allocated based on a labor allocator. And again, there's several different allocators that are used to allocate costs to the.
So, okay, and correct me if I'm wrong. Again, attorneys here trying to understand these issues. So the 12 CP method we're talking about, that is a cost allocation method.
As again, I apologize. As Dr. Dismukes proposed, that would be a cost allocation method. Yes, sir.
Okay, and you all use the 1 CP method. That is a cost allocation method.
Correct.
Okay, so what is the cost allocation method that is used for the open access transmission tariff?
Again, there's several of them where we would take, again, costs that were driven by or tied to labor, and we would allocate them based on a labor allocator. Okay. And again, there's 3 or 4 of them that I'm struggling to remember off the top of my head.
And another one might be a gross plant allocator.
Yeah, that sounds right.
Okay. And so, what is the cost allocation method that is used to formulate the gross plant allocator under the OATT?
I think that formula would look at gross plant and allocate it appropriately. Maybe I'm not understanding your question. I'm sorry.
Okay. I'm just wondering if there was a particular methodology or method.
Well, that would be the method. It would be the percentage of gross plant to the different classes,
okay. And
it would get allocated that way.
Okay, so there's not a overarching name for the method that's used.
If there is a name, I don't know it or I've forgotten it. I'm sorry.
Okay, sir. Let's get it. See. Just I think one more set of questions here. Okay, so again, you discuss in your testimony that other production cost allocation methods may be appropriate. I'm going to go to page 3 of your rebuttal testimony.
Okay, I'm there.
Okay. And at the bottom of the page, I'll go ahead and share the screen for convenience. And here I'm just reading from line 15. And it says, the company continues to believe that while other methods may be appropriate in other locations and jurisdictions, use of the coincident peak cost allocation method is the most consistent with the actual load analysis and operation of the company's electric system. Is that correct?
That's correct.
Okay. And then the next line, the company builds its production and transmission assets to support the system peak, regardless of when the peak occurs. That's correct?
Yes, sir.
Okay. When you say production assets, are you referring to the company's fleet of electric power plants?
Yes, that would be the generation assets, if that's clear.
Mm-hmm. Yes. All right, I'm going to scroll down here. This is an exhibit from Dr. Dismukes' testimony, exhibit DED-8. Can you see that now?
I can see that.
Okay. And at the bottom here, it notes that the source is the company's FERC, or the FERC Form 1. Do you see that?
I see that.
Okay. So subject to check, would you agree with the representation that this chart shows the various operating statistics on the left-hand side that represent the 2019 statistics associated with Dominion's electric plants reported in the FERC Form 1?
Subject to check, yes, I would agree with that.
Okay, great, thank you. And would you agree that the company's largest electric power plant in terms of net generation was its ownership portion of VC Summer Nuclear Station?
You're referring to the 5.5 million?
Yes.
Yes, sir. That's the largest.
Okay, great. And so, so while we're looking at that, this one's always kind of gets me. So we see the 5.5 million megawatts there under net generation, and then you see beside that to the right the 91.5% capacity factor.
Yes, I see that.
And then, sorry, to the left of the 5.5 million is 686.4 for the nameplate capacity.
I see that.
So would you agree that this means that 5.5 million megawatt hours is 91.5% of the maximum generation possible from this facility based on its rated 1 hour nameplate capacity?
I think that's correct. Again, my hesitation is there may be some nuance to that me not being an engineer doesn't fully understand what capacity factor means, but as an accountant, that would be my understanding. But again, I think I need to qualify that.
I understand. And so maybe to put it another way, is that VC Summer operated at 100% output for 91.5% of the hours in 2019? Is that generally your understanding of this, or is that an engineering question also?
Again, I think that would be an engineering question, but...
You generally agree with it?
I generally agree with it.
Okay. And then so in contrast, and again, I'll understand if you don't understand this question. In contrast, natural gas combustion turbines, which are listed here as gas CT, they only operated sparingly in 2019. If you look down at, we have at the bottom left-hand side, Williams, Incoits, Par. They have much lower numbers here. Typically, does that demonstrate that they operated sparingly in 2019 especially compared to VC Summer?
I think that's a reasonable conclusion to draw. Yes, sir.
Okay. And perhaps these facilities may have only been ran a handful of times in 2019. Would you agree?
That seems reasonable.
Okay. And just again, looking at net generation, we see Hardyville with a 0. That basically means that it did not run at all. It did not operate in 2019, correct?
That's what I would take from this chart. But again, I have a little hesitation because I'm not an engineer. But that seems like a reasonable conclusion.
Okay. And I think this, it's right. Not trying to get into the weeds with you too much here. Just again with understanding allocations. So would you agree that these statistics probably aren't really surprising, because natural gas combustion turbines are generally viewed as having high fuel and variable operating costs compared to nuclear facilities?
I think that's a reasonable statement, yes. It would all depend on the price of gas, and that obviously varies, but generally that seems like a reasonable statement.
Okay. And is it also correct then to say that the company operates baseload facilities such as nuclear and coal-fired facilities more frequently throughout any given year than peaking units such as natural gas combustion turbines?
Again, that seems like a reasonable statement.
Okay. Thank you. I believe I may be done. Just bear with me for just a moment, please. And that is all the questions I have. Thank you, Mr. Kokums.
Thank you.
And Office of Regulatory Staff does not have any questions, correct?
That's correct, Mr. Chairman.
All right. Commissioner questions?
Chair Williams.
Commissioner Caston and Commissioner Thomas is next.
I almost feel compelled to apologize to everyone for dragging this on this late on Friday, but it is what it is. Mr. Cocombs, thank you for sitting there and doing this.
It's my pleasure, sir.
Oh, come on now. Remember, there'll be no liars in heaven. The cost of services study, was that done in-house or outside source?
So that was done in-house. We have a special program that helps us with that. But we gather all the inputs and input them into the program internally.
Who directs or is responsible for the cost of study? And before you answer that, I've looked through, like your direct testimony, page 4. I present the company's fully allocated cost of service study. The study allocates responsibility for the revenues required to operate the electric system among the various customer classes. I look at Mr. Rook's direct. As manager of electric pricing and rate administration, I am responsible for designing and administering the company's electric rates and tariffs to comply with regulatory orders, relevant statutes. And then I present the rate design the company is proposing in this proceeding. The rate design takes the revenue requirements produced by the cost of service study and creates specific rates. Who drives this boat? I mean, who directs or is responsible for the cost of services study, cost of service study?
So both Mr. Rooks and myself are in the same department. We're in the rates and regulatory department. So we obviously get a lot of information from other departments, a lot of inputs into rate design and the cost of service. But I would say the rates department is responsible for developing the cost of service, and they're also responsible for developing rates that are based on the cost of service.
And for what it's worth, don't beat yourself up, because my experience has been that you need a lot of information from a lot of different folks. No one person knows all that, can know all that. So I suspect you're no different.
No, sir. There's a lot of information that informs the cost of service, and there's a lot of different departments within the company that provide inputs to it that is very detailed and specialized. And to be quite honest with you, we probably don't really understand a lot of it. We just know here are the inputs, and we put them into the model.
Well, I guess that's where I was going. First of all, let me say that I certainly am no cost of service study guru expert. I'm familiar with them, been involved with them. And what I do know from experience, or at least opinion, is every rate design, every rate designer, every consultant, whether it's internal or external, uses a model, some model. They design themselves, get off the shelf, whatever. And it's just comes down to the input you put in it, what numbers you put in it, how you allocate it. And going to the 50,000 foot level, which in my view, where you start understanding the system itself. And bear with me, because I'm going to just share what I think Dominion would do, but I don't know that they do. I just know what we did or how we did. You know, you talk about peak hour, you talk about max day, average day. What are the standards? Whose standard do you use? On the water side, for example, we had something called the American Water Works Association. And they developed standards, and many of the things were, the industry coming together over time and developing these things, tried and true. But what it all boiled down to mostly was recommendations, opinions. It wasn't law. These are just good standard practices, but the utilities typically did what they thought was right relative to certain things, like allocations, allocating cost to various users. And looking at the system as a whole, the supply, and I guess the electric side's part, you have generating facilities. We had reservoirs, and I don't need to go any deeper, but we similar things, transmission lines, distribution lines. How do you allocate it? What do you call it? And those things pretty much are judgment. Some you can look based on history, some on what some recommendations are, but the bottom line is it comes down to that utility's call. So
I agree with you, Commissioner.
Yes.
From an electric standpoint, we have kind of the cost allocation, Bible, if you will. There's a National Association for Regulatory Utility Commissioners cost allocation manual, and it's several hundreds of pages that talk about different ways that costs can be allocated, and I find it quite fitting that right up front they have a quote in there that says equity is the mother of confusion. That the whole purpose is to allocate cost equity, and there's so many different ways you can do it that it certainly isn't straightforward. It's not a science, so to speak.
Amen. And things do change over time. I observed even during my time, whereas years back, especially on the water side, a declining block rate seemed to be the rate of choice, especially in the South, because we had all the water we need. That's definitely fallen from favor, and in my opinion, wisely so. More to a inclining block or whatever. Perhaps something similar with electric, I don't know. Things such as I know there was some discussion about industrial usage.
Mm-hmm.
Okay, 1 meter supply enough electricity that would be equivalent to, say, 1,000 residents, as opposed to 1,000 meters to give you the same thing. And is that demand fairly constant over a 24-hour period? Those things matter. So breaking things into cost allocations is very doable, and there's many ways to do it, but there are many better ways to do it. I guess it just boils down to what that utility thinks is better than the other. So I guess you pretty much answered my question, and I'm the one that's mostly talked here, but you do agree, if I'm understanding you, that when it comes to allocating cost, there is no one right way. There are ways, and it pretty much boils down to how you choose to do it. Is that true or false?
I would agree with that. I think that there's obviously, based on the record of the case, there's multiple ways to do this. Again, it's not a science, but I go back to one of the things that I mentioned in my rebuttal testimony, that consistency is extremely important. I would think that the commission, the last thing that the commission would want us to do is change our methodology every time we came in for a rate case. That would just create confusion. It would shift costs between classes. And it'd be hard to, if we're reshuffling the deck every time we come in, it's going to be hard to keep track of it. So I completely agree with you with what you said. I would just add to it the aspect of consistency.
Well, on that subject, I know someone had mentioned, I think in your testimony, others I can't recall, that this has been done for 38 years, 30 years, I don't know. If you want to know the truth, I don't know really much about anything the commission did prior to 2020. Not that I don't care, but other than some kind of legal precedent, that's really, I'm not sure, a guide that's either good or bad. What I do think would be helpful and useful is to seriously, which hopefully you do, seriously consider what is the best way to allocate these costs that are in the best interest, as you say, equitable for the different rate classes. And again, I agree with you. It's complicated. There's no one right answer. But if we start with the end in mind, or in my view, if perhaps our guiding principle is first, do no harm, and try to treat all customers, residential, as equitably as possible. That's a good starting point. Now you can make the argument where we do that. Maybe you do. But I think just because we've always done it that way does not mean that's the way we need to perpetually do it. There may be better ways. There may be different ways. As I said, at least in the water industry, the way rates are looked at least in the municipal side and from AWWA's perspective and others, I think it is changing because time and life have changed. The way we view things. And the way, we don't have all the water that we think we have. So, just some thoughts there. Do you agree that it may be okay, or it's okay to look at things differently sometimes?
I completely agree with you, Commissioner. And my prior point of being consistency, that in no way was I trying to imply that we should never change. I guess my point, maybe I didn't communicate it well enough, was that when we do make changes, that they're very thoughtful and well vetted, that we take very precise and measured steps when we change things as fundamental as the cost of service study.
Mr. Cocombs, no need to apologize. I think you've been very incredible. You've been very controlled, and I know there's nowhere you'd rather be this late on a rainy Friday than right here doing this. So thank you for your time. Thank you.
Thank you.
Commissioner Thomas.
Thank you, Mr. Chairman. So, Mr. Cocombs, it is getting a little bit late, and we've talked a lot about allocations, and it's a topic that is of interest to me as well. And obviously, with the changes in the company over the last couple of years, allocations have changed, and that just cuts in so many different directions, and a lot of it's been talked about. So, just one that I'm thinking about right now is looking at your testimony on direct testimony on page 8, adjustment number 17. That's the allocation of the Dominion Energy expenses. And this is about midway on line 11. It says this process has changed the way costs occur, with certain costs now originating on Dominion Energy DES books and being charged to DES South Carolina. And for the test year, it increased expenses by approximately $9.2 million. And that's a calculation that hadn't been done in the past. It's a whole different thing. And my concern, as I expressed earlier, is that with all of these changes and the parent company doing business in 16 to 20 different states, the potential for them being done in different ways in different states and over different periods of time, my concern is that when you add all of those up, calculate them over the same time, add them up, they add up to more than 100%. And I would like to know that that's not happening, and if it is, that South Carolina is the one that's coming out on the benefit, not a different state. And I don't know how I get that answer. Pretty sure you probably can't tell me. I guess my question would be, can you tell me that doesn't happen?
Yes, Commissioner. So I think, Witness Kofer, provided a really good answer to that. I don't know that I could, add anything in addition to what he said. I guess I will share with you for that particular adjustment, and maybe give you an example. The legacy SCANA services, audit services department, they moved on paper to a DES department. So those costs were no longer originated at DESC. They were basically came back through DES. So they would be part of that, pro forma adjustment number 17. It's the same people, it's the same work they're doing, but the costs are originating in a different place. And that's just one of several examples. But that's the cleanest one I could think of that may help explain what that adjustment is really doing.
Right, but a lot of them wouldn't probably be quite that clean. And would you agree with that?
I would agree with that. When you get into allocations and things of that nature, it gets messy pretty quickly.
Well, I don't know. I guess I'm just thinking that with all of the changes that have occurred, that it'd be really, really nice to have a spreadsheet that has whatever it is, 16 or 20 columns, whatever state you file in, and you got a total company, you got spread out over the 16 or 20, see if those add up to the total company or not. And that's not something that I'm saying I have to have it right now in this case, but some sort of, I don't know. That would just be helpful to bring comfort to me. And do you have any thoughts on something like that?
I guess the only thoughts that really come to my mind is like Mr. Kofer said, we have a pretty robust system and processes in place, and I can confidently attest that the ORS's review of those are extremely thorough, and they go through those costs with a fine-tooth comb. So hopefully that provides that the audit services portion of the ORS provides you some level of comfort that the customers of South Carolina are only paying for the services that they're benefiting from.
Okay. Well, I appreciate your help, and that's all I have. Hope you have a good weekend.
Thank you. You too.
Commissioner questions.
Mr. Chairman.
Commissioner Irvin.
Thank you, sir. We appreciate your being with us this afternoon, and I was listening earlier to your comments about consistency, and I agree that that can be a very important quality when it comes to rate making. so I'm going to ask you to look at the United States Department of Defense exhibit that deals with their request number 8-1. I'm going to, do you have that in front of you, sir?
I do not. If you give me a minute, I could try to find it.
Okay. I'm not sure how it got marked into evidence, but it was pre-marked DOD FEA Cross Exhibit 1 PDF.
It was 8-1, sir?
Yes, sir.
Okay, I'm pulling it up now.
Thank you. And going to, just to go ahead and give you kind of a heads up where I'm going, I want to ask you about the use of lead lag studies to calculate working capital. And okay, so what jumped out at me was I was shocked and surprised that Dominion Energy Ohio, Dominion Energy West Virginia, Dominion Energy North Carolina Gas, Dominion Energy Utah, Dominion Energy North Carolina Electric, and Dominion Energy Virginia all use lead lag studies to calculate working capital. Guess who got left out of the mix? And you know where I'm going with that.
Mm-hmm. Yes, sir.
South Carolina got left out of the mix. And South Carolina got left out of the mix even though no outside consultants were necessary to conduct any of the lead lag studies because you have that in-house. They were performed internally by each jurisdiction, and the process took approximately 6 months or so with input provided by various groups or individuals within the company. Why did we get left out of the lead lag study process for working capital?
Well, I guess that my initial response is that we've only recently become part of Dominion Energy Services. The month of January is the first month we've been converted to their accounting systems. And the formulaic method is what we've been using for the last many years in South Carolina. I mean that's the reason why we've continued to do what we have done. Now you are absolutely correct that the other Dominion Energy service territories do a lead lag study, but their working capital number is a positive number. Our working capital number is a negative number. So I'll just point that out.
I'm just wondering if going forward, are we going to be treated like the other Dominion jurisdictions, or are we going to be left in a subset of our own?
I guess what I could say is we will certainly do what this commission directs us to do. If this commission feels that a lead lag study is better or more accurate, we will certainly perform one and submit that in the next general rate case.
Well, wouldn't you agree with me? Wouldn't you agree with me, sir, that in fairness, if we're going to talk about consistency as a principle, an important principle of the process, it's only fair that we get similar treatment to the other jurisdictions in Dominion territory. Would you agree with that?
Certainly. So I mean, I absolutely don't have any knowledge of the regulations in those other jurisdictions, but it certainly would appear to me that based on the other jurisdictions being able to do that, they probably have a process in place that we could implement here.
Thank you, sir. Those are all the questions I have, Mr. Chairman. Thank you.
Any more commissioner questions? All right, redirect. No redirect. Okay. Let's take a 10-minute break. All right, ladies and gentlemen, we're back.
Mr. Chairman.
Attorney Willoughby.
Yes, before I'm failing in my technology award, before I could get to my video and indicate that I had a couple of questions of Mr. Kokums, you had taken the break. So I do have just a couple of questions before we transfer to the next witness, depending upon what the commission's plan is for this afternoon.
All right, please proceed.
These will be very brief, Mr. Chairman, and thank you very much.
Attorney Willoughby, hold on 1 second. Oh, yeah. So before you proceed, Attorney Willoughby, I need to take a quick roll call.
Perfect. I'll stand by.
All right. Commissioner Caston, Vice Chair Belzer, and Commissioner Chairman Williams are present in the hearing room. Commissioners Thomas, Irvin, Williams are present with us virtually. Is Commissioner Powers present with us virtually? Let's take a 5-minute break. All right, ladies and gentlemen, we're back on the record. We're going to take a quick roll call. Commissioner Caston, Vice Chair Belzer, and Chairman Williams are present in the hearing room. Commissioners Powers, Irvin, and Thomas are present virtually. Commissioner Williams is present with us virtually. All right. Everyone is present. Attorney Willoughby, please proceed.
Thank you very much, Mr. Chairman, members of the commission. Mr. Kokums, just a couple of questions on redirect. You were asked some questions by Commissioner Irvin about the League Lab study and also by, I think, Emily Medlin earlier. But in response to Commissioner Irvin, you had talked about the difference in the League Lag study results from a neighboring Dominion companies and the study or the study that's done here, the application that you use for working capital here in South Carolina. And you use the word negative versus positive. Would you explain the results and what you meant by negative and positive?
Certainly. So I guess when I look at working capital, I look at all of working capital. Working cash is a piece of that, but there are other pieces of working capital. So our fellow Dominion subsidiaries do a lead lag study, and the working capital is anywhere between $10 and $150 million, positive number, which is an increase to rate base. Our working capital calculation is a decrease to rate base of $24 million at a retail level. So that's what I meant. It was either a positive or an increase to rate base, or a negative, a decrease to rate base. So I apologize for that confusion.
No confusion. I just wanted to make sure that you explained that. So the working capital calculation that you've done here results in a decrease to rate base, correct?
Correct. So if you go to, and I can, it would be, I think, Mr. Kofer's Exhibit C-6, total working capital is a negative $24 million, which is a decrease to rate base of $24 million.
And based upon your knowledge of what is done in the other states by Dominion Energy subsidiaries, do you see did you learn that there were positive results in those other states, which would be an increase to rate base?
That is correct. Again, I don't have any knowledge of the regulations in the different jurisdictions, but it's pretty easy to see that their working capital is a positive number.
So the customer is then helped by the working capital calculation you've done here, since it's a negative to the rate base. Is that correct?
Yeah. So a decrease to rate base would lower rates.
Thank you very much. And let me ask one question. You had a detailed conversation with Commissioner Caston. And is it true, Mr. Kokums, that the process that you used for your cost of service study reasonably reflects the cost caused by each class of customers and properly assigns costs to each customer class?
Yes, that's a true statement.
And while you believe, as you had the conversation with Commissioner Caston, while there are other ways of doing a cost of service study, is it your opinion that the cost of service study that you've done in this case is both consistent with what has been done historically for the company and reasonably assigns costs to each customer class and allocates those costs reasonably to each customer class?
Absolutely. That there are different ways of doing that calculation. There's different jurisdictions. There's different weather patterns. I would imagine the cost of service study done in Hawaii is different than the one in South Carolina. But for our jurisdiction, based on South Carolina and how we've constructed our plants and our transmission lines and our distribution lines, the methodology we have put forth we feel is the most accurate.
Thank you very much. Thank you very much, Mr. Cocombs, and those are all the questions I have, Mr. Chairman.
All right, thank you. Ladies and gentlemen, looking at the witness list, it seems as if we have 4 more witnesses from the applicant. Is that right?
That is correct, Mr. Chairman. Let's see.
Delk,
We
Neely,
have,
Naraki, and Rooks.
And Mr. Neely has been stipulated or will be stipulated. But there's Mr. Delk, Miss Naraki, and Mr. Rooks.
Yeah, I'm not sure if the commission will accept the stipulation of Mr. Neely yet. I'm not sure about that.
And we understand, Mr. Chairman. May we release Mr. Cocombs?
Yes.
Thank you very much.
All right, so we're going to break for the day. Next week, to make sure we finish in a timely manner, please be prepared to stay until 9 o'clock. Hopefully we don't have to stay that late, but we have not made it very far this week. So the 15th is our deadline. We need to be prepared to stay until we finish so we can meet that deadline. I'll see you bright and early Monday at 9 a.m.
Mr. Chairman.
Yes.
Sir, this is Roger Hall of the Department of Consumer Affairs. One quick question for planning purposes for our witnesses. David Butler sent around before the hearing what he called a cast of characters. It's been very helpful. It has an order, and he had stated that the order of presentation on this list, or the order of witnesses and parties on this list, would be the order of presentation. Just want to make sure that's still the plan.
Yes, that's my plan. Unless
okay, great.
Someone has protection.
Correct. Great. Thank you.
All right. Any other questions?
Mr. Chairman, this is Ms. Eaton. What time did you want us to start on Monday?
9 a.m.
Thank you.
All right. We're in recess until Monday, 9 a.m.
Thank you, Mr. Chairman.